किशन कुमार शंकर भाई तो बाजी पर આપણે થોડી વાર ઘંટી કોર્ટમાં કે હશે પણ આવે છે
કેટલા કેસ છે આપણા
હશે પ્રોસેસ
તેના માટે છે
આજે 50,000 રૂપિયા ભરવાના છે સાહેબ ને પૂરું કરવાનું છે એટલે ગઈકાલે આજે રાખી દીધું છે એ ઘંટી કોર્ટમાંથી આવે છે તો બપોરે રાખો કરવાનું
કેટલા વાગે આવે છે
ઘંટી કોર્ટ કે પતંગ આવે છે 3 વાગ્યા સુધી હું હવે કીધું છે એ પહેલા તાત્કાલિક એ જાવ બતાય
ફરિયાદીને ટ્રાન્સ કર્યો કેટલા વાગે આવે છે ઓર્ડિનેટ તો સિરિયસ
કે 3 વાગે આવું બહુ સેકન્ડ સિટિંગમાં રાજેન્દ્ર સિંહ મોતી સિંહ પરમાર મોહન સિંહ પરમાર मतलब एपेलेंट નો રિપોર્ટ આપો ના આર્ગ્યુમેન્ટ આપી દો હાર્દિક ભાઈ આપણે કોપી નીચે આપી દો મારી પછી
તમે
એપેલેન્ટ તરફે હું છું સાહેબ એપેલેન્ટ નથી આવ્યો 50,000 રૂપિયા બાકી છે 20% પર ને એ સાહેબ નથી પડતા એટલે હું એમનો રિપોર્ટ દલીલ આપી દીધી મારી પાસે આજે રિટર્ન આર્ગ્યુમેન્ટ આપી દીધા સર
એચએમ રાવલ કે
એ નથી આવ્યો
ચાલો તો આજે સાંભળી લઈએ
જી સર
જજમેન્ટ કરું કીધું
જી સર
હું આર્ગ્યુમેન્ટ થઈ તો
સાહેબ રિક્વેસ્ટ હતી કે 15 દિવસનો સમય રાખજો એટલે આજે આપ સાહેબ જે તારીખ આપો ને એ તારીખે મને નોટિસ આપી દે હાજર થવાનું કે આ તારીખે તમે કોર્ટમાં હાજર રહો
આવા દો બધા
જી સર જી સર જી સર અમિત રમણલાલ મેવાવાલા અમિત રમણલાલ મેવાવાલા વકીલશ્રી યુજે વાજપાઈ વકીલશ્રી યુજે વાજપાઈ નરેન્દ્રભાઈ ઠાકોરભાઈ વકીલશ્રી ડીએ કાલે વકીલશ્રી ડીએ કાલે
કેટલા બાકી રહે છે
કઈ તારીખે 55 બાકી
આજે કેટલા ભરો છો 40 કાકા કેટલા 1 લાખ રૂપિયા બાકી 1 લાખ બાકી છે
95 બાકી છે તારી સાથે બોલું અને તારી પાસે 55 બાકી રહે છે
55 કરી દો આજે 40 ભરો છો
કઈ તારીખે સાહેબ 25
40 ભરો પછી કેટલા 55 બાકી રહે
સાહેબ એક ઉપલેટી મોડે પૈસા આપે એનો મતલબ કોઈ નથી એવું છો આજે અપીલ દાખલ કરવાને બી સાહેબ 7 મહિના થઈ ગયા 7 મહિનામાં 1 રૂપિયો નહીં આપ્યો ગયા વખતે 25,000 રૂપિયા જમા કરાવ્યા એને બરાબર છે તો સાહેબ હવે 50,000 રૂપિયા સાફતા તો આપવા જોઈએ કે નહીં સામટા તો આપવા જોઈએ કે
40 નેક્સ્ટ તારીખે સાહેબ
મારી
25
તો આપણને નમ્ર અરજ છે કે આપ કોઈ બી પ્રકારનું જજમેન્ટ જે જજમેન્ટ આપવું હોય છે જજમેન્ટ આપો
સાહેબ 14 તારીખ રાખો પૂરા કરી દેવા જોઈએ છે
સાહેબ 7 મહિનાથી દર વખતે સાહેબ એમ જ કહે છે કે હું આવતે મહિને તમને પૈસા આપી દઉં આવતે મહિને તમને પૈસા આપી દઉં પૈસો એક રૂપિયા આપતો નથી
લાસ્ટ ટાઈમ બી આપણે વાત કરી ગયા
કઈ તારીખે સાહેબ 25,000 કોર્ટમાં જમા કરાવેલો આજે 40,000 લઈ
એડવોકેટ ક્યાં છે કાકા બોલાવો કાલે બે મૂક્યો તમારે એડવોકેટ આવે છે તમારા
બોલાવો
વકીલ સાહેબ આજે સાહેબ એમના ગ્રાન્ટ બદલનું મરસી છે એટલે આજે આવી શકે એમ નથી
જેલમાં જે રેટ લેવાની
ચાલીસ આજે આપણે તો લઈ લો
હમણાં આપવા જોઈએ ને.
આજે હપ્તા આપતો છે ને હપ્તા
આજે 15 જોઈએ.
40 આપ્યા છે 40 બરાબર છે
40 આપે તો લે.
સમજાયું છે
તો બાકીને ક્યારે આપે મને?
ચૌદ કલાક.
આ 14-15 માં આ 14-15 માં આ 14-15 માં
પછી લખી દો. અને મેસેજ સંગ્રહ
20 તારીખ આપો છો તમે.
જી સર.
21 તારીખ સુધી આજે 21/3 બરાબર તમારે પૈસા ભરવાની રજા આપી દો. રોકડા આપી દો છો કે અહીંયા રોકડા આવે?
રોકડા દેતા હોય તો સાહેબ રોકડા જ આપી દઈએ.
રોકડા
લાસ્ટ ટાઈમ તો કોર્ટમાં જમા કરી
રોકડા
દીધા
આપીને સાહેબ લખાઈ દે પેલા કોના 40,000 રોકડા મળી
પૂછી લો એને પૂછી જો કે રોકડા જોઈએ છે કે જમા કરાવે.
રોકડા આપી દે ચાલે કે રોકડા
ચાલે.
તો આપી દો અમને ત્યારે આપી દો. ખુરશી પાસ કરી દો અમારું. ત્યારે
એમાં સર
55,000 બાકી રહે પણ લખી દેજો મને. ખુરશીમાં બાકી રહે
એની સાઈડ
હો ને? તમે એમની જોડે તો પાંડેજી કાલેની જોડે છે 21/3 આવે.
હાવડે એટલે સાહેબ મેં જોઈ કર્યું એની બીજી મેટર એક મારી પાસે છે એટલે હાવડે એટલે કેવી મીઠું
બરાબર.
ને સાંભળતા નથી બહુ ઓછું કામથી ઓછું આપણે
એવું નાખ્યું મને. હમણાં 40,000 કીધા તો એ કે 15,000 આપી દો.
15,000 એટલે પેલા 25 ને આ 15 જ આપે છે એમ કે.
હા એવું સમજાય.
પ્રશાંત વિજયકુમાર વકીલશ્રી જેજી દેસાઈ પ્રશાંત વિજયકુમાર અમરતલાલ નાનજીભાઈ
The senior is in some personal difficulty, requesting for a short day.
You are appearing for
Appellant. Appellant is present.
Shant Vijay Kumar. Now, what is the check amount?
35 lakh.
You have deposited 20% of the amount?
Yes, I believe so. I will need to reconfirm.
Who is a Gandhi Bhai, you are appearing for amount. એમાં ખરા છે 20% આવી ગયા છે? 20% આવી ગયા છે. You are seeking adjournment for what purpose? For argument or for deposit?
For argument.
ये अभी क्या हुआ? जाएगी?
presented by the secretary.
कई तरह के રાખો જે સ્ટેડી હોય
Sir, any Friday maybe.
સર 28 માર્ચ 28
Obliged.
23/3
જયેશભાઈ કાંતિભાઈ પટેલ જયેશભાઈ કાંતિભાઈ પટેલ વકીલશ્રી કે ક્રિશ્ચિયન
કેમ તેના માટે છે બધું માટે છે કરવાનું છે
સમાધાન થઈ ગયું છે સાહેબ
એવી જ
હા 7.5 લાખ રૂપિયા થયું છે અને મહેનત આપી દીધા છે સારા બસ બાકી છે
વિજય સુમનભાઈ કોણ છે સમાધાન થયું છે આમાં તમારે
એ 3 સુધી આપવા સાહેબ કીધું 13 માર્ચ સુધી આપવા કીધું
કેટલા બાકી રહેશે
સાહેબ 5.5
5.5 લાખ
જી
તો કઈ તારીખ રાખી 13/3 રાખી
આપણું નામ સાહેબ મળતો
તમારા કોણ છે વિજયભાઈ ના કોણ છે તમે છો? આજે અરજી આપી દો તમે આજે કઈ તારીખ જોઈએ બોલો તમારા કઈ
સાહેબ આ મહિનાની એન્ડ પર થઈ જશે
સર 28/3
જી જી
प्रमोद कुमार, दिनेश भाई उपनारायण, वकील जी पीएन सिंह,
In my 20% amount is already paid. Second of I am paying. Half of it, 46,000 are paid. 50,000 we are paying.
In which number you are paying, 113 or?
$96,000 under 20%, 46. आज बचा नहीं करवाना चाहिए.
So in both matter, 20% amount is paid now.
Yes, आज भेज.
प्रमोद नारायण, दिनेश शुभ नारायण सिंह નથી આવ્યા respondent. ના વકીલ કોણ છે? PNC.
वकील जी पीएन सिंह,
ये कहाँ रहता है? दिनेश शुभ नारायण सिंह कहाँ रहता है? अतुल में रहता है. आप भी अतुल रहते हो? पार्टी में. The chances of compromise is there, or we should keep for the argument. Arguments not there.
As of now, arguments.
When you want to start your arguments?
So whenever it's fine.
This one,
So in every.
so 4th April.
जमा कराओ.
हाँ.
RNP મંગાવી દેજો એમ. एक नंबर 4 April 4/4.
वकील जी अनंत देसाई, अनिल कुमार, सुनील भाई. अनिल कुमार, सुनील भाई गांधी. अपन खाली.
તો ઓનલાઈન બેન્કિંગ ફ્રોડ છે એ માટે એનું છે.
એટલે આ નથી સાહેબ આપણે એક્સપર્ટી ખાલી જો આખું બે એક ફરિયાદી છે ને બધું નથી એક્સપર્ટી નથી ચાલુ.
અહીંયા વલસાડની બ્રાન્ચ છે ઇન્ડસ્ટ્રીન કે
સુરત
સુરત.
આરોપી નવસારીના છે બે સુરતની છે બે પરસવાળા
सामान एवरी मुद्दा क्या क्या है.
9 એપ્રિલ કરી દો. 9 ભોગવા માટે સુરત મુકાવી દેજો. ફરીથી રીઇશ્યુ આજે જ કરી દેજો.
क्वेश्चन में मेरा करेंगे क्योंकि से लॉटरी बिजनेस सिटी में भी सोचा मुद्दा की
મેલ પણ કરો ને ફિઝિકલ પણ મોકલો એમ. બંને મોકલી શકો. 9 એપ્રિલ હા.
9 એપ્રિલ છે
કેટલો ચેક અમાઉન્ટ કેટલો છે આમાં?
3 લાખની ઉપરનો છે કે
વ્હીકલ લોન છે કે એવું કઈ
આ
છે?
વ્હીકલ લોન છે.
विनोद भाई नौशा भाई
मैं एप्लाई गुजरी गई विनोद भाई नौका भाई
वकील जी जे प्रजापति
તો શું કરું છું? ડિસ્ક્લોઝ કરી દે.
प्लीज को
કાલે પાછી કહેજે લોકડાઉનમાં ફરી વાર.
ये करें છે
અચ્છા
કન્ડિશન આપી છે અક્ષર ની જે બોલા ગુજરી ગયા બરાબર છે એ કેન્સર હતું એ
તો કાલે પાછી જ ખેંચી લો હમણાં. બરાબર ને?
भी जाए करो
ખુશીથી જાહેર કરો ને આપણી પાછી ખેંચી લેજો. કાલે કરી દઈએ આમાં.
जी सर गुजरी गई
8 3 તો બે આમ. તમે સિંક કરી દેજો
ગુલાબભાઈ, અમરતભાઈ, મંથન, નરેન્દ્રભાઈ ટંડેલ,
20% રકમ જમા કરી છે 4 લાખ 60,000 રૂપિયા બાકીનું હવે સમાધાન કે છે ક્યારે જમા કરવાનું આજે આપવાના છો કઈ ક્યારે આપવાના?
આપણે અમરતભાઈ કોણ તમે જાઓ ઓકે ને બોલ્યો તમારે બેસો હમણાં
બેસો. ના, ઓફિસ આપી દો.
જાઓ નેક્સ્ટ
સુરેશભાઈ, ફુલજીભાઈ, વકીલશ્રી જેબી પટેલ, સુરેશભાઈ, ફુલજીભાઈ, વકીલશ્રી જેબી પટેલ, સરદાર ભીડાવાળા બેન,
Appellant હાજર છે સર.
સરદાર ભીડાવાળા બેન,
ચેક ની અમાઉન્ટ કેટલી છે
એનો કેટલા રૂપિયા છે? કેટલા? 77,000.
20% ભર્યા છે અમાઉન્ટ
20% ભરવાના બાકી છે જો રિસ્પોન્ડન્ટ આવે તો સર એમને સમાધાન કરીને ચેક આપીને પૂરી કરી દઈશું.
કોણ છે બિલાડ વાળા બેંકના કોણ છે ડોગેટ
સર એવો બેન નો નહીં રેલવે મટીરિયલ પણ આવે છે
સ્નેહિતા જે છે સર સ્નેહિતા જે
તો મળી લે મને રાખો સાઈડમાં જો થઈ ગયો તો ચેક આપવાનો તો બાજુમાં મૂકો
જી સર
તો કાલે જો પદાર્થ છે તમારે પૂરું થઈ
જી
જાય
સર બરાબર સર.
તમારા કોસ્ટ અમાઉન્ટ બી ના ભરવી પડે જો પદાર્થમાં પૂરું થયું.
જી સર.
એડે ફેબ્રિકેશન, જાહિદ અલી, મુમતાજ અલી, હરીશભાઈ, પ્રદ્યુમન શેખ,
હાજર છે સાહેબ હરીશભાઈ રેટના હાજર છે.
જાહિદ અલી, મુમતાજ અલી,
શું હતું રિસર્વે
યસ સર સાહેબ પ્રોબ્લેમ સુરત થી બોલાવ્યા છે કસ્ટમર સુરત કે આપણે
20% જમા કરાય છે
હા જમા કરાવી દીધા છે.
હરીશ પ્રદ્યુમન ચેકના
તમારું બીપી આવું છે.
તમે હો ને
હા યસ આઈ એમ એટિંગ.
જોઈ લો આમાં કઈ
હા
કોમ્પ્રોમાઇઝ
જી સર
કરવાની વાત
હવે વોટ્સએપ પર વાત કરીશું.
રાખે સાહેબ
જી સર ચોક્કસ બેસો.
અરે બપોરે કેટલી મિનિટ અત્યારે બધું આ તો ઘરે ગ્રેડો પાર્ટી પણ છે ને બી જોઈ લો આપતો બોલતો મેં કરેલી છે લોકો તરફ
વકીલશ્રી ટીએલ મહેતા, વકીલશ્રી ટીએલ મહેતા, વકીલશ્રી ડીએમ આચાર્ય, વકીલશ્રી ડીએમ આચાર્ય, વકીલશ્રી પીએલ મહેતા,
કયા ગુનામાંથી
ચોરી
આરોપી તરફથી આવી પાર ક્રમ
બીઆર પટેલ
વલસાડ મહારાષ્ટ્ર નંબર
થઈ છે એફિડેવિટ જોયું છે ને?
એફઆઈઆરમાં છે 1,87,700 ના ફોટો નોંધાયેલા. એમાં સાહેબ અજાણ્યા વ્યક્તિ વિરુદ્ધ ફરિયાદ આપી હતી.
શું ચોરાયેલું હતું?
હાજી
શું ચોરાયેલું?
ફોટો અનાજ ફોટો
કઠોળ અનાજના.
એમાં સાહેબ અજાણ્યા વ્યક્તિ વિરુદ્ધ નોંધાયેલી છે. જેમાં તપાસ દરમિયાન સાહેબ આરોપી તરીકે માલિક સુરેન્દ્ર ઉર્ફે બોલાવ, વાહનના માલિક સુરેન્દ્ર ઉર્ફે બોલાવ એને સાહેબ એરેસ્ટ કરવામાં આવ્યા. ત્યારબાદ
કઠોળના ગોળાનું શટર.
હા અહેમદ જાનની મોતને પછીની સાત સાહેબ આરોપી ની કબૂલાતના આધારે પોલીસ સમક્ષ નીકળી કે અમારી સાથે આ પ્રદીપ પણ હતો અને તેના આધારે સાહેબ અમારી આ ગુનામાં ધરપકડ કરવામાં આવી છે.
કુલ 2670 કિલો કઠોળ છે.
અને સાહેબ અન્ય આરોપીઓ સાહેબ જામીન પર મુકેલા છે. એક 20-25 2003 જાન્યુઆરી 2025 થી સુરેન્દ્ર બોલાને અને બીજી છે સાહેબ 23-25 થી હેમંત ચાર મોહમ્મદ અને નિશાદ બેનાનો
એનો શું રૂલ છે એમાં?
એને સાહેબ કે સાથે હતો એવું કે
સાથે હતો.
હા પેલા ચાંદ અને નિશાદ તમારી સાથે હતો.
ગુનાહિત ઇતિહાસ છે, ક્રિમિનલ એન્ટિસિડન્ટ.
કોઈ નથી ગુનાહિત ઇતિહાસ નથી. ડ્રાઈવર છે પણ સાથે હતો એવું કીધું છે. બીજા આરોપી સાહેબ જામીન પર 15
તારું બેલ ગ્રાન્ટ છે 15,000 ના જામીન પછી. નેક્સ્ટ 20.
ઓકે સીઆરએમ દેસાઈ
બોલો બીજો બંધના
જી સર એ રિવિઝન છે સાહેબ.
શેના માટે છે આ?
એમાં ફાઇનલ ઓર્ડર છે. ફાઇનલ ઓર્ડરમાં છે ને સામાનો પૂરો નોટ બંધ થયેલો છે અને પછી જજમેન્ટ આવ્યું છે.
138 છે.
નહીં બંધના રોહિત છે ને આ 125 છે સાહેબ. સર મારી પ્રથમ રિમાન્ડ કરવાની હતી. તમારો વકીલ આવ્યો છે સાંભળી લીધું. અને મેં ટોટલ છે 2,70,000 રૂપિયા ભર્યા છે. રિવિઝન બિલ એટલે સોરી રિકવરી બિલ.
તો તમે હાજર થયેલા ને ત્યાં પછી હાજર નહોતા એવું છે?
હાજર થયેલા સાહેબ વકીલ બી રોકેલા પછી સંપર્ક તૂટી ગયો છે. કંઈ ધ્યાન નહીં આવ્યું સામાવાળે બેકારજીના લીધે. પછી આમ સામાવાળો પૂરો બંધ થયો છે અને સામાવાળો દલીલો પણ બંધ થયો છે અને કામ જજમેન્ટ પર આવ્યું. મારે પૂરો લીડ જ નથી થયો છે.
પણ આમાં રિઝનેબલ અમાઉન્ટ 4,000 રૂપિયા જ કર્યા છે ને?
નહીં સાહેબ એમાં 16,000 રૂપિયા તો આ બિલનો જ પગાર છે. એટલો ખાસ સાહેબ એ અરજદારનો જ પગાર છે સાહેબ. ટેક્સન એફિડેવિટ બે સાઈડ રજૂ થઈ જાય તે જ નથી શકે ખાલી 16,000 તો બિલ કમાઈ ખાસ સાહેબ.
અરજદાર નંબર 2 ને 8,000 છે.
જી સર.
અરજદાર નંબર 3 ને 8,000 છે.
અને આ બિલના 4,000 મહિના છે.
ટોટલ 20,000 બાંધ્યો.
આ બિલનો પોતાનો પગાર 16,000 રૂપિયા છે અને મારી ટોટલ કમાણી 15,000 થી 20,000 રૂપિયા નથી મહિના છે. એટલી તો ખોરાકી ભરવાનું થાય છે. એટલી સાહેબ
આ સામાવાળા એડવોકેટ છે ને?
જી સર.
તો પછી હવે ક્યાંથી એને તો ઇશ્યુ નો કે ભાઈ હાજર
આપસે
થાય.
સમજ નાનાથી
હા, તો પછી આમાં તો રિમાન્ડ
ઇન્ટરેસ્ટ ઓફ જસ્ટિસ હું તો ખાલી ઇન્ટરેસ્ટ ઓફ જસ્ટિસ અને આપસે જે તારીખ લીડ કરો કે આ તારીખે આ જરૂર પુરાવા આપી તે તારીખે મારે આપી દેવો છે પુરાવા માટે.
ના એવું તમારે કોમ્પ્રોમાઇઝ કરવો હોય તો તમે છો આમાં? ને એડવોકેટ ક્યાં છે? મુંબઈમાં છે સમાવાળા?
ઝાંસી.
ઝાંસી, મધ્યપ્રદેશ.
અને સાહેબ જેવું મને ત્યારથી વકીલ રોક્યા છે, અસલનો જ વાત છે, નામ નથી પાડતો, મને જ્યારથી વકીલ રોક્યા છે ત્યારથી આમની રિકવરી એક તારીખે પૈસા ભર્યા છે, કોઈ એક પણ તારીખ પછી ચૂકવો નથી, પૈસા ભરાયા જ છે સાહેબ, ઈચ એન્ડ એવરી ડેટ છે, દરેક ડેટે ભરાયા છે, અને પૈસા તો મેં પડવા જ પડશે. હવે છોકરી એક સંતાન બી મેજર થયા છે.
એની અમે તમે જુઓ આ મેટર ની છે ને CRM ફાઇલ 2014 માં કરેલી.
ના પાડતો જ નથી.
2014 થી પછી છેક ના આયા ને છેક 2023 સુધી 2023 માં જજમેન્ટ આવ્યું. હવે there is no reason for remanding this matter back. હવે ફરીથી આખો 2000 પાછી
આખો
મેટર
નહીં,
રિમાન્ડ કરું તો 2030 માં પણ પૂરું નહીં કરે આ.
આખો નહીં સર, આખો નહીં સર, મારા પૂરો આખો નહીં, અરે ઉલટા પાછો થઈ રહી છે સર, મારો પૂરો ક્લિયર કરવા બાકી છે. અને હું તો સાહેબ આક્ષેપ નહીં કરું, આક્ષેપ જે ડેટ ફિક્સ કરી આપો એ વિધિન 30 days માં પૂરી જ કરી દેવાનું છે. આક્ષેપ 30 days કરી આપો, આ 30 દિવસમાં ડિસ્પોઝ મારે 30 દિવસમાં પૂરું જ કરી દેવાનું છે. જે આક્ષેપ છે તારીખો કે આ તારીખે લીડ થઈને એવિડન્સ આપી દેલા, મને એવિડન્સ આપી દેવાનું છે, મારું ડેક્લેરેશન એફિડેવિટ આપી દેવાનું છે.
તમારા આર્ગ્યુમેન્ટ કર્યો છે આજે આવવાના છે?
સાહેબ સિનિયર આવે.
આવે છે આવવા દો, રાખીએ આપણે.
જી સર, જી.
કારણ કે આમાં 2000 આમાં પાછો રિમાન્ડ કરવાનો કોઈ પ્રશ્ન જ ઉપસ્થિત થતો નથી. કારણ કે 2014 ની મેટર છે મેન્ટેનન્સ.
આપ સાહેબ સહમત છું, પણ મારી સાહેબ 20,000 ની કમાણી અને 21,000 ની પડાઈ બાંધી દીધી સાહેબ, કઈ રીતના ભરું સાહેબ? હું કઈ રીતના ભરું? અલ્ટિમેટ પછી મારી જેલમાં જ જવું પડશે.
તો રિમાન્ડ તો ના કરે, તમે ઇન્કમ માટે ગ્રાઉન્ડ પર ચેલેન્જ કરો છો.
એ ગ્રાઉન્ડ લીધું જ છે સાહેબ. હું મારો પુરાવો લીડ કરાતો સાહેબ થશે નહીં વસ્તુ, એના માટે મારે પુરાવો લીડ કરવો પડશે સાહેબ. મુદ્દો એટલો જ છે, નાનો માર્ક કહેવાનો છે.
તો આ ત્યાં આ મેન્ટેનન્સ ઇન્ટ્રી મેન્ટેનન્સ તરીકે ચાલુ રાખવા જે ઓર્ડર કર્યો છે,
જી સર.
તો પછી અમને વાંધો હોય તો પછી રકમ છે condition સાથે. આ જે ઓર્ડર જે કરેલો છે that may be treated as interim maintenance till the final disposal of your main petition which is
સાહેબ
yet to be remanded back.
એવું મંજૂર સર, એ મને વાંધો નથી.
એમને આવવા દો, તમે કોના તરફથી છો?
સાહેબ પેમેન્ટ આપી દે, એ મને વાંધો
આવવાના છે?
આવવાના છે.
તો બસ તો જોઈ લો, એવું તો પછી પૂછી આપી દો તો પેટર્ન પાછળ
હા,
કરી દો.
એ બાબતે મારે વાંધો નથી.
હા, કારણ કે આ જે ફાઇનલ ઓર્ડર કર્યો છે મેન્ટેનન્સ નો that may be treated as interim maintenance
Implementation. જી
till
સર.
your evidence is completed and the matter is decided again.
જી સર.
બરાબર એ રીતે કરવાના, વચ્ચે એક પૂછી આપી દો. આવશે
હું સર તૈયાર છું. મારે ખાલી રિક્વેસ્ટ એટલી છે કે જે સંતાન પુખ્ત થઈ ગયા છે કે આ લોકો જાણ કરે આ સંતાન આ થાય પુખ્ત થઈ ગયું છે, કેમ કે ચાઇલ્ડ છે ને સાહેબ મેજર થઈ ગયા છે.
એરિયાસ બધી ભરી ગયા હમણાં?
એરિયાસમાં 270 ભર્યા છે સાહેબ.
હવે આવો તો ઈંડાને પછી
જી સર, જી સર.
ચલો નેક્સ્ટ સેશન કેસ હવે
જયેશભાઈ ઈશ્વરભાઈ પટેલ.
જી સાહેબ શ્રી. વખતે પેલા મામલતદાર જે ભૂલી ગયા તેનો મરણનો દાખલો આવવા માટે આપ્યો હતો. આરોપીઓ સાથે બંને હાજર છે.
પ્રજાપતિ વિષયનું છે આ સેક્શન કયું છે? આવ તો કેસ
કોણ તો સાહેબ
એવું બેસેલે કે ચાર્જશીટમાં નામ લખેલું છે. અને એ હતા એ MS વસાવા હતા મામલતદાર શ્રી નું પોતાનું હતું. અને ચાર્જશીટમાં MM વસાવા હતા એટલે સમર્થન MM વસાવા છે. MM વસાવા 2019 થી 24 સુધી નથી. ચાર્જશીટમાં ઈમેલ નામ લખેલું.
સાહેબ આઈઓને નોટિસ જ થાય ને આઈઓ સુધી ખુલાસો કરાવ્યો.
આવ તો કેસ આપો. ચાર્જશીટ નું જવાનું.
ચાર્જશીટમાં MM વસાવા
પેલા કોન્સ્ટેબલ પર કાર ચડાઈ જઈ
જી સર, જી સર.
બીજા કોણ બાકી રહે પ્રજાપતિ?
હજુ તો સાહેબ પંચાયત થયા છે. પંચાયત થયા છે. આઉટ ઓફ ફોરેસ્ટના મામલતદાર હતા, તેને બોલાવ્યા છે. આવું ચાર્જશીટ બાકી છે.
ગુનામાં છે પ્રોહિબિશન ના ગુનામાં કઈ સંડોવાયેલા છે પેલા આરોપીઓ?
નહીં સાહેબ, તદ્દન ગુનો.
પ્રજાપતિ ભાઈ જો ક્રિમિનલ એન્ટિસિડન્ટ હોય તો મુદ્દો બધું જોડે. હા
આવા છે.
ગુનાહિત ભૂતકાળ હોય તો બધો હવે બાકી ના કાઢો સમન્સ. સત્યાવીસ 3
જી સર.
એક જ 27 સાહેબ આપી છું સાહેબ, અનુકૂળ હોય તો 28 સાહેબ.
28 રાખો.
જી સાહેબ.
28 નેક્સ્ટ.
લાલ મોતીલાલ રાઠોડ
ખુલાસો તો આવી ગયો છે મારે.
ખુલાસો આવ્યો છે, પણ એમ નહીં કરતો. કે જે સમન્સ આવ્યો છે એવા કોઈ મામલતદાર અહીંયા નોકરી નથી કરતા. અને અહીંયા એ મામલતદાર 2021 માં હતા એ MS વસાવાના MM વસાવાના
આખું છે 306 છે.
302 છે.
બરાબર. આરોપી EDP છે.
હિતેશભાઈ ઈશ્વરભાઈ
હાઈકોર્ટ માંથી છોડ્યા છે જામીન પર.
જીતેન્દ્રસિંહ બલદેવસિંહ
હાઈકોર્ટ થી છૂટ્યા છે. બરાબર. કેસ આપો.
જીતેન્દ્રસિંહ બલદેવસિંહ જીતેન્દ્રસિંહ બલદેવસિંહ
ક્યાં છે આરોપી? ક્યાં છે આમાં ભાઈ?
સર કેટલા આવતા તમે એમના કે મામા એક્સપર્ટ થઈ ગયા
તો exemption અરજી આપો તો ઓળખની તકરાર નથી કરીને. લઈ લે ને પ્રજાપતિ આમાં
આરોપી ગેરહાજરીમાં એક સારા જવાબ
બોલો ફર્સ્ટ છે કે ફર્સ્ટ
પંચ છે. લાવા ચેક કરી લો.
तीस बाईस
પંચ છે. ક્યાં રહો છો તમે? બેસો હમણાં બહાર બોલાવો કર્યો. નેક્સ્ટ 23.
એવું છે આરોપીનો વોરંટ ઇસ્યુ કર્યું કે જણાવેલ એડ્રેસ પર રહેતા નથી પર વોરંટ ક્લિયર કરી પાસ કર્યું છે.
ઇમિડિયેટલી છે ને. ત્યાં વિશે 3 કરી દેવાનું.
અટક પંચનામું છે અટક પંચનામું
બે મહિનામાં એક 27 મુજબનું છે. પાછળ બીજું છે જો.
મેં પેલા કપડા
सात नंबर जजमेंट है शुरू करो ये मैं
વલસાડના જ છે
बुलाओ हमने खड़ी
હિતેશભાઈ રમણભાઈ
शुरू को दो
ત્રણે આવવાનું प्रिंसिपल बने काम का 28 3
ये जने थे ना बस ये लपेट देख रहे थे इसको करना
जी सर 108 ठीक है एंडिंग प्रजापति
तो माथे में रखो है इस समय रखी ना समाधान माटे सब लोग
55 नंबर है तो मહેસાણા
શું તમારા કાર્યભાઈ
Every family is starting to be very. That is all like. By my final, I don't share upon a solution. I just said, they are like.
હા કઈ વાંધો નહીં કોણ નંબર છે તમારો ભૂરાવાનું છે અમે પિન્ટુ કુમાર શાંતિલાલ
Be to or something, please.
પુકાર કરો તો
પિન્ટુ કુમાર શાંતિલાલ પટેલ. કુમાર શાંતિલાલ પટેલ. કવિતાબેન પાતાલભાઈ પટેલ. કવિતાબેન પાતાલભાઈ પટેલ. કવિતાબેન પાતાલભાઈ પટેલ.
શું નામ છે તમારું
પિન્ટુ કુમાર
કવિતાબેન આવ્યા છે
તમે વાળા આવેલા છે
નથી આવ્યા
Also a big one suggestion to you. For the I'm also a guardian. What I said, so the Satan word the Marabar Moral. Maru suggestion that we usually buy in person. But at least said one in Mila, we be our moral days. I could go Chakran. But I can see you to an Bharat can use it. I can manage to alternative વિકલ્પ હોય છે
તમારા લગ્ન થઈ ગયા પિન્ટુભાઈ બીજા લગ્ન કર્યા છે ને બેનના બીજા લગ્ન થઈ ગયા છે કલાવતી બેનના
not at all.
એ ક્યારે કલાવતી બેન ક્યારે છે
On the contrary, સાહેબ એને બે મેરેજ કર્યા અને આગળ મેરેજ થયેલા ત્યાર પછી એનો અફેર ના પાડ્યું એટલે મારી નીચે પણ તકરાર છે કે સી નોટ અ લીગલ વેટેડ વાઇફ મારી કાયદેસરની પત્ની સાહેબ નથી ખોરાકી બંધાઈ ગઈ છે ખોરાકી લગભગ 10,000 બાકી અનિશ્ચિત કર્યું છે એટલો એનો પગાર નથી હવે એ યુઝ એમાઉન્ટ છે એટલે સેટલ કરવા પણ તૈયાર I have already given offers.
તમે કેટલા ટાઈમથી બાળકોને મળ્યા નથી
એક વર્ષમાં તકરાર કર્યું તોફાની બાજુ
પછી આમાં નવા ઇસ્યુઝ જ ઉભા થશે તમે મળવા જશો તો લાવો તો છૂટા રહેશે તો પછી હવે હમણાં ઓર્ડર થઈ ગયો હશે ને એમાં
મેન્ટેનન્સ નો નથી
બાળકો કેટલા વર્ષના છે
બાળક 10 વર્ષથી કેટલા છે વર્ષ હે 9 વર્ષ
તમે ક્યાં રહો છો
હું જરા ઘરે
અને એ ક્યારે છે
એ ધરમપુરમાં છે.
ધરમપુરમાં કોઈ સાહેબ રૂમ ભાડે લઈ રહે છે એના ફાધર બધું ત્યાં નથી રહેતું પેરેન્ટ્સ ના નથી રહેતું
આવા દો એમના ભૂરાના આવા દો એમના એડવોકેટના 2020 ગાર્ડિયનની અરજી છે તમારી મીડિયેશનમાં પણ ગયેલું મનાતું કોમ્પ્રોમાઇઝ
એટલે મતલબ જેનો એકોનોમિક સાહેબ she is not in control સાહેબ ધરાવી સાહેબ એક રિસ્પોન્સિબલ અને મેન્ટેનન્સમાં સાહેબ 125 માં નેગોશિએશન થયું એની સાથે તો એ 25 લાખ રૂપિયા સાહેબ પાછું આ તો સાહેબ ઇટ્સ અ કેસ ઓફ બ્લેકમેલિંગ પોઝિશન છે
અરજદાર અહીંયા જ નથી આવતા જે સામાવાળા છે કલાવતી બેન અહીંયા પણ આવતા નથી કોર્ટમાં
આજે 125 નો પૈસા લેવા આવે છે એ નથી આવશે
ભૂરાના આવા દો ને એમના એડવોકેટ છે સામેવાળા એમને આવવા દો એટલે પછી ડિસાઈડ કરે છે રાખો મને
જેલ નંબર 9 અને 10 સિવિલ બોર્ડમાં બંને વકીલ સાહેબ એક જ ઓર્ડરની સામે છે. એમાં એપેલન્ટે પૈસા જમા કરાવ્યા છે બંને મેટરમાં. સાહેબ એફડી કરવા માટેની અરજી છે.
શેના માટેની અરજી છે?
ફિક્સ ડિપોઝિટમાં ઇન્વેસ્ટ કરવા માટે.
કોર્ટમાં જમા છે.
રકમ કોર્ટમાં જમા છે.
DM આચાર્ય દેસાઈ બાંધે વાયરમાંથી
હા.
તેમાં 375 જમા કરાવેલા છે. રાજ્ય વહીવટમાં જમા
એ તો મારે એફડી થઈ જાય ઇરરેસ્પેક્ટિવ ઓફ ધેટ. તમે તપાસ કરો પહેલા ત્યાં.
જમા થઈ ગયા છે.
જમા નહીં
ના
થાય.
એટલે એફડી એટલે કોર્ટમાં જ છે એટલે ફીમાં ઇન્વેસ્ટ નથી કર્યા.
ના એનો કરી થશે હમણાં આપણે ઓર્ડર છે ને ખબર એફડી માં બોલાવો તો આપણે
સંજયભાઈ બોલાવો. સંજયભાઈ
હાઈકોર્ટનો અમારા સર્ક્યુલર જ છે કે જે પણ પૈસા આવી રીતે ડિપોઝિટ થાય એને એફડી કરી દેવાનું. એના માટે કઈ એપ્લિકેશન આપવાની જરૂર નથી તમારે. સર પાંડે જે છે ને આ બંનેમાં
એકમાં SR પાંડે અને એકમાં DM આચાર્ય.
તમે રિસ્પોન્ડન્ટ તરફથી જોવામાં
રિસ્પોન્ડન્ટ હશે બંને.
બંનેમાં તમે પૈસા મને લાગે DGBCL વાળા જમા કરાયા છે એવું છે ને?
બંને જ કરાયું.
બંને કરાયા.
બે જ સેપરેટ અપીલ કરી હતી સર. DGVC એટલે બી કરી અને
પ્રાઇવેટ પાર્ટી છે.
પ્રાઇવેટ પાર્ટીએ પણ.
પ્રાઇવેટ પાર્ટી ચેનલ છે.
DGBCL અને પ્રાઇવેટ પાર્ટીએ ટોટલ તરીકેના પૈસા જમા કરાયા. એફડી કરી છે ને?
નથી કરી સર. કલાકથી
કરવાની જોઈએ ને. હાઈકોર્ટનો સર્ક્યુલર છે ને રાખવાના નહીં ભાઈ લોકો શું કામ નહીં કરવું? એફડીમાં મૂકી તો એમાં હા દેસાઈભાઈ તમને અરજી છે એમાં અરજીમાં આધાર કરવું છે કે આપણે અરજી લેવાની જરૂર છે નાણાકીય
ના કઈ વાર નથી.
દેસાઈ કલાક કરાવી દઈએ આજે આજે કરી દો.
હા હા સર.
એ આપણે જે કોર્ટની જે બેંક હોય ને SBI કે બેંક ઓફ બરોડા કે એમાં હોય
SBI માં
સિરિયલ નંબર
5.
બીજો ચોથું છે
રેકોર્ડ પર એમનો અનુબંધ કર્યો છે. એ તો પછી કરાવી.
કોણ નંબર કોણ છે તમે SN કાઝી તમે છો?
બધા સર કરે છે. અમૃતભાઈ આ
જે મેઇન એફેક્ટેડ પાર્ટી જ છે ને
હે
જે મેઇન એફેક્ટેડ છે એ જ છે ને જમરાજભાઈ તમે બસ તો દલીલો માટે રાખીએ ક્યારે રાખવું બોલો આજે કરવું છે આજે નથી આવ્યો
ના આપણો પાછો
બીજા ચોથું છે ને તો
જૂના સેક્ટર અગાઉના
મેટર પેન્ડિંગ હોય શું કામ મોકલે બોલો ક્યારે રાખવું છે આપણે દલીલો માટે તો તમે
નેક્સ્ટ મંથમાં સાહેબ. .
चौथी पांचवी पांचवी 5-4
सेट सीरियल नंबर 3 સાહેબ આમાં 40,000 જમા કરાવી આપી દીધા છે એમને.
અત્યારે પૈસા મળી ગયા
એની અરજી આપી છે.
હવે પ્રોસીસ આપી દીધી ને?
અરજી આપી છે 55,000 બાકી રહે છે તે
અમિતભાઈ ક્યાં ગયા? ચલો અમિતભાઈ રમણલાલ ધન્યવાદ. વિશ્રામ એકવીસ ત્રણ આપી દેજો બાકીના પૈસા બધા પછી એમાં બી અડધા લઈને આવવાના અડધા પછી લાવવાના એવું ના કરતા બે દિવસ 21-3
જી સાહેબ.
એમએસસીબી માં કોણ છે એનો પતા બીઆઈ પટેલ કે કોણ?
વકીલજી બીઆઈ પટેલ, વકીલજી સીજેલાલ, વકીલજી ડીએમ મિસ્ત્રી, વકીલજી બીઆઈ પટેલ, વકીલજી સીજેલાલ, વકીલજી ડીએમ મિસ્ત્રી.
અને પહેલા ક્યારે હતી એમએસસીબી જો બનાવવા તો ડિસમિસ કરી અરજી આવેલી છે કોઈ? કઈ તારીખ? 24 पे बच्चे આજે પડી છે. રાખો ભાઈ એમટી દેસાઈ કોણ છે મતલબ છે એડવોકેટ હરેશ પટેલ તમે આપી દે આર્ગ્યુમેન્ટ સવારે
રેકોર્ડ આવવાનું બાકી છે.
જો તમારે કોણ
કયું કે આવી ગઈ શું?
લેખિતમાં જ આપી દેજો પેલું. 4 એપ્રિલ 4/4.
ક્રિમિનલ અપીલ છે. આચાર્ય છે. હા. CRM નું ડિસ્કોર્સ થઈ ગયું. ક્રિમિનલ અપીલ છે. ક્રિમિનલ અપીલ કરો. હા કરી.
એક્સિસ બેંક વાળું છે
ના સાહેબ એ બીજું છે. સીરિયલ નંબર 12 માં CRM ચેક કર્યું અને ક્રિમિનલ અપીલ લખ્યું છે.
એને દેસાઈ
આવે ને સવારે હવે સાહેબ એ મેટરમાં શું છે સાહેબ 12 નંબરની મેટરમાં બતો ભાઈ જેડે ફેબ્રિકમાં સાહેબ 8/11/23 ના રોજ મોડ સાહેબે કન્વિક્શન કરેલું. આરોપી ગેરહાજર. આરોપીને અનેક વાર વોરંટ કાઢ્યા, અનેક વાર વોરંટ એવોઇડ કર્યા. છેલ્લે ડિસેમ્બરમાં વોરંટ અમને હાથમાં આપ્યું. સુરત લગભગ અઠવાડિયે એક વખત જાય. પીએસઆઈ એમના ઓફિસમાં પેલાને મોકલાવ્યા આરોપીને કે તમે જેને સેટલ કરી આવો. હવે સાહેબ સેટલમેન્ટમાં રકમ એટલી નાની કે સાહેબ વાત જ નહીં આવે. અને સાહેબ પીએસઆઈ પોતે મોકલે કોને આમની પાસે રાધર ધેન ટુ એરેસ્ટ થિંગ. અને આ આરોપી સાહેબ 1 વર્ષ અને 3 મહિના સુધી ભાગેડું છે. ડિસેમ્બરમાં જે છેલ્લો વોરંટ કાઢીએ કો મોડ સાહેબે એમને કીધું કે હતો આપ્યા ઓપન વોરંટ છે, એમાં કોઈ તારીખ નથી સાહેબ. આ 14 થી 15 વખત સાહેબ સુરત ગયા. પીએસઆઈ એને પોતે કે તમે સમાધાન કરી લો, મને એરેસ્ટ નથી કરવો. સાહેબ ધીસ ઇઝ અ ફેક્ચ્યુઅલ પોઝિશન સર. વી હેવ ગોટ ધ રેકોર્ડિંગ ઓફ પીએસઆઈ કે આઈ એમ સેન્ડિંગ એક્યુઝ યુ ડુ કોમ્પ્રોમાઇઝ. આમણે કીધું કે હું શું કામ કોમ્પ્રોમાઇઝ કરું? મેં એમને સામાન માલ આપ્યો છે સાહેબ, માલના પૈસા છે 3,73,000 રૂપિયા. વળી સાહેબ એમણે મૂળ ફરિયાદ દરમિયાન
આરોપી જે સુરતના છે.
હા સુરતના છે સાહેબ.
તમે બી સુરત
ના એ વલસાડ રહે સાહેબ. ગાયત્રી સ્ટીલ વલસાડની ફર્મ છે સાહેબ.
એને દેસાઈને બોલાવો.
એટલે he has been harassed in all possible way.
8 વર્ષ થઈ ગયા, મુદ્દલ રકમ જ માંગુ છું, વ્યાજ બાદ વકીલનો ખર્ચો બધું મેં જવા દીધું. પ્રિન્સિપાલ મારામાં આવીને એગ્રીમેન્ટ નથી.
અને સાહેબ બીજી વસ્તુ કે પીએસઆઈ આમની પાસે મોકલે rather than to arrest. It was his bounden and compulsory duty to arrest him looking to the order of the honorable Mode સાહેબ. આવું સાહેબ એમને મને ફોન કરે કે શું કરું, આટલામાં સમાધાન કરો, 2.5 કહો, 2 કહો, કઈ મેજિકલ ફિગર કે ધીસ મેજિકલ ફિગર હેઝ નો સ્ટાન્ડર્ડ, નો બેઝ. અને અત્યારે અમે સમાધાન માટે બહાર બેસાડ્યા, મેં વાત નથી કરી, એમની જોડે એમણે વાત કરી, તો અત્યારે એમ કહે છે કે હું 373 માંથી 3 આપું. તો અમને કારણ પૂછ્યું કે મેં તો તમને 373 નો પૂરેપૂરો માલ આપ્યો છે સાહેબ, પૂરેપૂરો માલ આપ્યો, પાક્કા બિલ જીએસટી સાથેના. અને વળી સાહેબ મૂળ ફરિયાદ દરમિયાન એમણે અમારું દેવું સ્વીકાર્યું અને લખીને આપ્યું કે 3,73,000 રૂપિયા હું આપવા તૈયાર છું અને 3 મહિનામાં ચૂકવી આપી, which is on record your honor. Upon which he has admitted my debt sir, and upon which the conviction order was passed. નામ બોલો, નામ બોલો. જેડેક ફેબ્રિક બોલો. અહીંયા જેડેક ફેબ્રિકેશન સાહેબ ડિસેમ્બર થી અમે હેરાન થઈએ છીએ. હું કેરલા હતો સાહેબ, ત્યાં અમને મને 8 થી 10 ફોન કરે કે મને પીએસઆઈ મોકલાવે છે. પીએસઆઈ આરોપીને મોકલાવે ફરિયાદી પાસે કે તમે જઈને સમાધાન કરી લો, મારે તમને એરેસ્ટ નથી કરવા. ધીસ ઇઝ સમથિંગ વેરી અનયુઝ્યુઅલ.
આપના પૈસા આપવાના છે કે નહીં તમારે? तो कब दोगे तुम? और पुलिस को भेजते हो उनके यहाँ समाधान के लिए? पुलिस तुमको पुलिस अरेस्ट नहीं करती है तुमको? कहाँ है आपका एडवोकेट? कहाँ गए? तुमको बोले क्या हो? कहाँ रहते हो तुम? कहाँ रहते हो? तो तुमको जामीन पे इसकी कंडीशन पे ही छोड़ा है कि तुम समाधान करो. तो आपके वकील ने ऐसा बोला है कि वो पैसा भरने के लिए तैयार है पूरा, जो चेक अमाउंट है वो, और उसमें से एक पैसा भी कम नहीं भरना, पूरा भरना पड़ेगा आपको जो चेक अमाउंट है वो, नहीं तो फिर यहाँ से जेल में भेज देंगे आपको. अभी बुला गया उनको, वकील को बुला गया. તમે જો આમાં
હું પણ સાથે છું, જોઈન્ટ પાછું અને નિકુલભાઈ જોડે સાહેબ. તો એમાં થોડુંક એમને જે બિલ્ડરનો એમને જે માલ સપ્લાય હતો ને સાહેબ, બેમાં ડિફર છે. બેહે અમને કોઈ વાંધો નથી સાહેબ. એ ફરિયાદી જોડે બેહીને ફરિયાદીને રિફર કરે. મોકલાવો અમારું બિલ ને બધું જ વસ્તુ છે અમારી પાસે સાહેબ. કોઈ બી એ પોતે એની આત્માને
જો તમે વાત કરો છો એમાં કન્વિક્શન થઈ ગયું
એટલે
છે.
સાહેબ જેમને સાહેબ ગોઠવું ફરિયાદ
બધો ટાઈમ પાસ છે એ લોકોએ કબૂલાત કરેલી લોક અદાલતમાં મેટર કર્યું જજ સાહેબે કર્યું તમે બતાવી દો પેમેન્ટ આપી દો આ ખાલી ટાઈમ પાસ કરે છે બધું કબૂલાત કરી મોટ સાહેબે જજમેન્ટ પાસ કર્યો કે ભાઈ he has to pay all going to jail
સાહેબ આપ સાહેબની રૂબરૂમાં બોલું કે એ એમની આત્મા પર દિલ પર હાથ મૂકીને એના બિલ ને બધું તમને બતાવી દે. તમને બતાવી મને બીજી કોઈ નહીં દે. બરાબર તમે તમારીથી હાથું માનીને કાઢી દો. તમે તમારીથી માની લો કે સાચું છે કે ખોટું છે આપણે માન્ય રાખવાના સાહેબના ગાડી હું માની દેમ છું. આ કેમ ને સાહેબ આપણે એમ એ એક વખત કબૂલ કરી લે એને જે માલ મોકલાવ્યો છે આપણી પાસે ઓન રેકોર્ડ બધું છે સાહેબ બધું એ જોઈ લે સાહેબ.
બિલ પ્રમાણે
હા તે બિલ પ્રમાણે માલ બીજો મોકલાવ્યો છે સાહેબ.
બિલ પ્રમાણે ચેક આપ્યો સાહેબ એમની એક્ઝેક્ટ અમાઉન્ટમાં એક્ઝેક્ટ ચેક
જે माल की एक पैसा वो सही सही बताओ क्या किया है वो माल क्या भेजा और क्या
चेक
किया
दिया था कि नहीं दिया था इनको?
इन्होंने दिया मुझे।
और चेक आपने दिया था?
हाँ, मैंने दिया।
चेक का अमाउंट किसने लिखा था उसके ऊपर?
नहीं,
तो क्यों जितना बाकी था उतना ही लिखा था ना आपने?
जितना बाकी था उतना ही लिखा था लेकिन वो जो मैंने काम किया ना वहाँ पर वो भी मेरा पैसा अभी तक फंसा पड़ा है।
अब ऐसा नहीं जो अब तो जो भाई
नहीं माल क्या था वो बोलो साथ में।
HP का माल इनको देना था जो सर्टिफिकेट इन्होंने दिए थे वो सर्टिफिकेट गलत है लेकिन फिर भी मैंने इनको कोई क्लेम नहीं किया मैंने कहा ठीक है मैं
સાહેબ આ નવો બહાના કાઢે છે જ્યારે કેસ ચાલતો ત્યારે આ બધું
કોઈ ડિફેન્સ નહીં there was no such defense आप सब
It's just passing time, sir.
it will be very crystal clear
आज भी मेरा पैसा LNT में पड़ा हुआ है वो पेमेंट नहीं था
એમનું સર્ટિફિકેટ ના લીધે સાહેબ એમનું અટકી ગયું તો બી આપણે આપત્તિ આ સાહેબ
સાહેબ LNT નું સર્ટિફિકેટ લાવ્યો છે કે ભાઈ એના લીધે એનું અટકેલું છે સાહેબ ખોટું ઇલોજિકલ
मैं आपको पूरा डिटेल दे सकता हूँ मैंने कितना बिल दिया है मुझे कितना पैसा मिला है वहाँ से कितना पैसा बाकी है मेरा
સાહેબ અત્યારે આ વાત કાઢે છે
but that is not a lookout set એમના પૈસા બાકી છે અમારા પૈસા બાકી રાખવા that doesn't mean અમે તો પૂરેપૂરો માલ આપી દીધો છે we have given full goods as per his requirements quotation I
no not as per the requirement
why you
they are telling the lie
ના ના હું શું કામ બોલું
હા,
અમે માલ પૂરેપૂરો આપી દીધો છે એમને પોતે એડમિટ કરી ગયા સાહેબ કે મેં પૂરેપૂરો ચેક આપ્યો છે મેં લખ્યો છે બધું તો કર્યું છે ખર્ચ નથી
એનું માટેનું નામ નથી સાહેબ એક તો વસ્તુ અમે ક્લિયર છે કે એનું એ કબૂલ કરી
મેરિજ પર આખો કેસ ચાલી ગયો છે મેરિજ પર આખો કેસ ચાલી ગયો
હવે તમે કહો છો કે અત્યારે આ ડેન્સિટી નો ત્યાં
સર,
તમે ડેમેજ એક્સપ્લેન કરો એમની જોડે અલગ
એક વખત એ લોકો ડિસ્કસ કરી લે સાહેબ એ લોકો બે જણાને કરી લે એટલે આપણે કરી દઈએ સાહેબ એ લોકો બે જણાને એ લોકોને કરે ડિસ્કસ કરીએ
કઈ સાહેબ ડિસ્કસ કરવાનું નથી અમે અમારા પ્રિન્સિપલ અમાઉન્ટ માંગીએ છીએ સાહેબ આજ દી સુધી એનો એક લેટર નથી આવ્યો કે મટીરિયલ વોઝ સબ સ્ટેન્ડર્ડ વાળા નહીં આ બધી નવી વાત કાઢે ટાઈમ પસાર કરવાની વાત
तुमने अभी मेरे को जो बोला था तुम 3 बार इनको मिलने गए थे मेरे को नहीं मालूम है मैं नहीं तो साहब के सामने मैं गलत होऊंगा इसके लिए क्या वो सही था तुम गए थे
हमें गया था इनसे वो बात करी थी जाके
3 लाख આપવાની વાત કરેલી બીજી કઈ વાત નથી
3 बार गएला साहब
આ નવી નવું ચેપ્ટર કાઢ્યું સાહેબ આ
પૈસા આપવા માટે વાત કરેલી
हाँ तो तैयार था ये जो है जे की वो तैयार था
માલ ડિફેક્ટ તો લીધું નથી એમાં.
नहीं बोला था तुमने मानता हूं तो
નહીં બોલા હતા સર ખાલી 3 લાખ અત્યારે બી 3 લાખ ની વાત કરી हमने डेंसिटी की बात
एक मिनट चुप रहो आपने 3 लाख जब देने के लिए बोला तब क्या बोला और क्या बात हुई वो साहब के सामने इनको बोलो इनके साथ में क्या बात हुई इनके साथ में हाँ
3 लाख में इसको सेटल कर लो मैं आपको 3 लाख रुपए दे देता हूँ और आपने जो भी मुझे माल दिया वो भी उसका भी सर्टिफिकेट गलत है मैंने इनको बोला
नहीं
नहीं નથી બોલા સાહેબ
मैंने इनको घर पे वहां पर बोला मैंने कहा चलो कोई बात नहीं मैं
तो चेक का ही दिया तुम सर्टिफिकेट गलत था तो चेक का ही दिया हमने तुमको फोर्स नहीं किया चेक के लिए
એવું તો ના ચાલે
બારું
દેવ જણા વાત કરે ને પૂરું કરાવી દે
અત્યારે પૈસા 20% તમે જમા કરાવી
જમા કરી દીધા
આપણો ચેક અમાઉન્ટ કેટલી છે
3,73,000
એમાં 90,000 કેટલા ભર્યા છે
75,000 સાહેબ
ઠીક છે
75,000
75,000
બાકીના 3 લાખ આ લઈ લો આપણે.
હા ભૈયા આપી દે મને ડેટી આપો એટલે હું આપણે સેટિસ્ફાઈડ માટેનું નો સીલ લખી આપું સાહેબ મને કઈ વાંધો નથી આઈ હેવ નો ઓબ્જેક્શન એટ ઓલ
સર એક વખત હું વાત કરી જોઈ લે પાછળની આપેલું 99% હું આપના આપ સાહેબ અગાડી સાહેબ નહીં કરું
હવે જે બી હોય
આપ
બધું
સાહેબ
તમારે
હા
સબસ્ટાન્ડર્ડ માલ નીકળે ડેન્સિટી ઓછો હોય તો તમે ડેમેજીસ ક્લેમ અલગથી કરવાના છે.
નહીં, સાહેબ,
આમાં કોઈ
હું સાહેબ
હવે કોઈ નવા ઇશ્યુઝ ના જોયા અમારી.
હું આપ સાથે કરી પ્રોમિસ
અમારે
અમારે
એવું
પહેલું પૂછ કરી દે
આચાર્ય નહોતા તો બી એમણે કીધું કે અમારા સાથે સેટલ કરો એટલે જામીન પર થોડા જેલમાં હતા.
સાહેબ બધું પૂરું કરો આપ સાહેબ
હવે કંઈક જેમાં
ચોક્કસ.
કોઈ નવા કોઈ ઇશ્યુઝ ના જોઈએ. જો સાંભળ્યું અત્યારે excuse કે જેલમાં લઈ લીધા.
ઓકે સાહેબ એ આપણે એટલે વાંધો નથી.
ક્યારે રાખું છું બોલો.
કોઈ બી સાહેબ એ વાતો નહીં,
ઓછા
કોઈ
કરવાના,
બી
વધારે
વાતો
કરવાના એવું ચેક અમાઉન્ટ હતા જેટલા ડિપોઝિટ કર્યા છે માઇનસ તમારો જે ચેક અમાઉન્ટ છે.
હા સર જી સાહેબ આઈ એમ રેડી ફોર ઇટ
જે ક્લિયર હોય રાઉન્ડ ફિગર તમારે જે
Yeah.
373 હતા ને
373 અરાઉન્ડ છે સર 373 ઓડ ફિગર છે અમે ચેક જોઈને કહી દઈશું 373 છે સાહેબ
હવે અત્યારે 75,000 જમા કરી
હા, સાહેબ.
બરાબર. બાકીના જે હોય તમારા રેસિડેન્ટ સાઈન કરીને લઈ લો.
હા,
એક
ચોક્કસ.
કઈ વાંધો નહીં, સાહેબ એટલે હું
આમાં
નહીં
બીજો નહીં, પણ એમાં કોઈ ડેલિગેશન નહીં કે આમાં
નહીં નહીં સાહેબ આપ સાહેબ અગર ખાલી મેં કહી દીધું સાહેબ મને બીજું કઈ નહીં આપ
આમાં જે હોય તમારે તમારા વિશ્વાસ રાખીને કીધું કે આ આચાર્ય બી નહોતો તો બી હવે છોડે લાગે જેલમાં હતા તમારે.
નહીં સાહેબ આપણે એ ખોટું નહીં થાય પ્રોમિસ સર
અમારે સેટલ જ કરવાનું છે. અમારે 25% જમા કરાય છે એ બધું ઓર્ડર્સમાં બી લખ્યું છે. એટલે
બાકી સાહેબ ડિલેમાં તો મને સાંભળવાનું હોય ડિલેમાં તો મને સાંભળવાનું હોય સાહેબ જી સાહેબ
તેમ છતાં વિશ્વાસ રાખીને એમણે કીધું સર અમારે સેટલ જ કરવું
જરૂર
એટલે
કહું સાહેબ.
ડિલે બી ગ્રાન્ટ કર્યું ડિલે કોન્ડોન કર્યું એક્સપાર્ટે અને
નહીં સાહેબ હું બધી રીતે સાહેબ એવું નહીં
હવે
એ ડેટ આપો ને એટલે એ કરી
10, 15, 20, 25,000 ઓછા વધતા કરવાનું એ બધું તમે મ્યુચ્યુઅલી કરતા હો તો
યસ 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 સર એ જ વસ્તુ મ્યુચ્યુઅલી એક જ
જે હોય complainant કે
જી, સર.
પ્રમાણે આપી.
સાહેબ આઈ નીડ માય ચેક અમાઉન્ટ ઓનલી આઈ ડોન્ટ વોન્ટ એની એક્સેસ અમાઉન્ટ
ત્યાં કોઈ એમણે ખર્ચો બી નથી માંગ્યો. તો આચાર્ય
નોટ એટ ઓલ નથી માગતો આઈ એમ વેવિંગ ઓલ માય રાઇટ્સ
નહીં, 5, 10 પ્લસ માઇનસ કરીને તમે બેસીને બતાવી દો છો. બરાબર.
હા સાહેબ આઈ એમ રેડી ફોર
સર વાક્ય આપો સર
હા સાહેબ જી સાહેબ આઈ એમ રેડી ફોર સાહેબ તારીખ કઈ આપશો
આજે બીજું તો પૂરું કરી દઈએ ને.
આજે પૂરું કરી દો સાહેબ આજે ડીડી આપી દે તો પૂરું કરી દઈએ સાહેબ ડીડી આપી દે પૂરું કરી દઈએ
સર આજે ડિસ્કસ કરી લઈએ પછી હું એક ડેટ આપો એટલે તે સાહેબ પૂરું કરી દઈએ સર
કાલે 8
હું આપશે
સાહેબ
મારે કોઈ
કાલે
નથી
પૂરું થાય એવું છે. કાલે રાખીએ
8
સાહેબ
વર્ષથી મેટર પેન્ડિંગ છે સાહેબ.
ડબલ થઈ જાય એમના.
ડબલ થઈ જાય પૈસા અમારા કાલે લોક અદાલત છે સાહેબ ડીડી લઈ આવે હું ડીડી પર હું વિડ્રો કરી લઈશ બસ ડીડી પર હું વિડ્રો કરી લઈશ બસ હું ડીડી પાસ થવાની ખાસ
બે દિવસની અંદર જ રહી લો તેમાં એક તબિયત એ હતી ને અત્યારે રમઝાન ચાલે એટલા રિક્વેસ્ટ છે મારે પૂરું
તો
કરવાનું.
મારે પકડવા રાખવી છે કે next
ઓકે
week
આઈ એમ રેડી ફોર ઇટ
ક્યારે રાખવું છે બોલો.
મંગળવાર
કોઈ બી આપશે કોઈ બી દે આપો એનો હું એ નહીં કરું સર
મંગળવાર આપો સાહેબ મંગળવાર આપશે
આવતા શનિવારે રાખો. ત્યારે
હા
આવતા શનિવારે.
ચોક્કસ સાહેબ
આ બધું વર્કિંગ ડેની લોક અદાલત
ચોક્કસ સાહેબ ચોક્કસ સાહેબ ચોક્કસ
બરાબર.
હા જી સાહેબ
સર, પૂરું હવે આ નવું એ નહીં કે માલ ઓછો તો આમ હતું તેમ હતું એમને એમ નહીં. તો તમારા ભરોસે મેં કીધું સાહેબ સેટલ જ કરવાનું, પૈસા ભરવાના છે એ રીતે છોડેલા એમ.
જી વાંધો પણ સાહેબ 29 રાખો છો.
ના ના 15 તો નહીં કહે છે ને.
ના 15 રાખો ને સાહેબ 15 પૂરું થઈ જાય છે આપણે પૂરું કરી દઈશું.
અરે
પૂરું કરી
14 રજા છે મને 15 16
15 મે સાહેબ કહે છે શનિવાર છે લોક અદાલત છે શનિવાર લોકો શનિવારે પતાવી દો ને એટલે વાત પૂરી થાય અમને બચારા 8 વર્ષનો વનવાસ તો પૂરો થાય
અરે ભાઈ અત્યારે બોલવા તો દો જરા શ્વાસ તો લેવા દો.
અરે નથી કોઈ નથી થઈ ગયું છે યાર
હું 15મી છે રજા છે.
સાહેબ વહેલું રાખો સાહેબ.
હા વહેલું રાખો વહેલું રાખો
વહેલું રાખો.
નહીં, પણ તમારા પેલા ભાઈ આવશે ને તો સુરત થી આવવાના છે ને આવશે ને લઈને.
હા ડીડી રૂપેશભાઈ તો છે સાહેબ રૂપેશભાઈ તો છે સાહેબ
15 રાખો.
આઈ એમ ઓબ્લાઇઝ ફોર ઇટ
15-3.
જી
હા સાહેબ
હવે પૂરું કરી દો આમાં તમારે બરાબર ને આમાં તમારા એક કર્યું છે તો પછી
જી સર
15 આવવાનું સવારે 9:30
15-3.
હા તો આઈ એમ સોરી
15-3. આવતા જ.
બરાબર.
બસ પ્રેમથી પછી જો પ્લસ માઇનસ જે કરો એ અમારા પોર્ટને અમારે નહીં મ્યુચ્યુઅલ કન્સન્ટ તો તમારી રીતે.
સાહેબ they will sit together no involvement of advocate let them decide their
હા,
own
બસ તમે રહો એમાં વચ્ચે તો
Yes,
સારું.
yes.
આ દેસાઈને બી રાખો વચ્ચે.
મહેસાણા ને એવું માર્કેટનો ભૂલ છે
બરાબર. સિવિલ
હા એ વલસાડનું જ છે પણ ટાઈપિંગ મિસ્ટેક છે
તમારા
વલસાડ
દેસાઈની અરજી આપી દો એક સમાધાનની વાતચીત કરવાની.
હા સર આપી દો
મુદત આપો.
આપી દો આપી દો
સાયબર ક્રાઇમ વાળા કઈ રીતે થયા છે
સિવિલ
હા એ વલસાડ જ છે પણ એ ભૂલથી મહેસાણા લખાઈ ગયું છે અને ત્યાં બકેલી બેન આગળ એ લોકો આવેલા હતા અને એ લોકોએ કીધું કે અમારી શાખાનો જ કેસ છે હા એવું સુધારાની અરજી જરા મંગાવી દો ને એફિડેવિટ પર
તમારે શાનું છે તમારે શાના માટે આવ્યા?
એ પેલા ડીજે કોન્ડન વાળું છે
મહેસાણા લખેલું છે ત્યારે એ બનાવ વલસાડનો છે વલસાડનો છે જે બેન એપ્લિકેશન
કયો નંબર છે? કેસ નંબર બોલો.
56 સિરિયલ નંબર 15 એક્સિસ બેંક વાળો
ને મોબાઈલ જો તમે ચલે બચાને દો
બરોબર.
વલસાડનું શું થયું?
સાયબર ક્રાઇમ વાળા ને આજે
તો હું કરું?
હા બસ બી સાહેબ.
સાયબર ક્રાઇમ
મારો તો ભરાઈ ગયા હા નહીં 10% માંથી
બસ તો એમની જરૂર છે ને સાયબર ક્રાઇમ વાળા ને
બસ
સહજ આવી તો
તો આપણે ચલાવવાનું ના કરીએ હા
સાહેબ એક સેકન્ડ છે બે સીએમ 9 અને 10 એમ તો ભરે જાય
મારા ત્યાં નીચે
2 મિનિટમાં
રિક્વેસ્ટ બોક્સમાં આવી ગયા છે
80% સાહેબ રકમ ભરાઈ ગઈ છે મુદ્દલ એમાઉન્ટ માં જો અરજદારના વકીલ કન્વિન્સ થતા હોય તો સાહેબ સમાધાન થઈ જાય એવું છે મૂળ એવોર્ડ ને 80% ભરાઈ ગયા છે મુદ્દલ પ્રિન્સિપલ એમાઉન્ટ પેટે 40% મેં ભર્યા 40% જી
સિરિયલ નંબર
સીએમ નંબર 9 અને 10
9 10 ક્યાં છે અચ્છા 9 10
20 24 અને 21 24 સિવિલ સાહેબ એમાં મૂળ એવોર્ડ જે છે ને એવોર્ડ ના 80% ભરાઈ ગયા છે પછી વ્યાજ થોડું ઘણું જતું કરીને સમજવાની વાતચીત થતી હોય તો અરજદારના વકીલો તૈયાર થતા એનો સાહેબ બેઠક થાય છે
ઉપર લોકો આપું છે આવતીકાલે
આવતીકાલ રાખો સાહેબ જીબી ના અધિકારીઓ આવતા કે સાહેબ જીબી તો સાહેબ ખબર સાહેબ એ તો હાઈકોર્ટ સુપ્રીમ કોર્ટ ની અપીલ માં જાય એવી ખોટી સાહેબ
થઈ જાય ને સાહેબ સાહેબ એનો
તો હું એ જ કહું છું કે 8 ટન રાખો કાલે બધા ડેપ્યુટી એન્જિનિયર અહીંયા આવવાના છે સાહેબ
કાલે બોલાય
હા સાહેબ એટલે
ને અરજદાર બી તૈયાર થતા વ્યાજ જતું કરતા હોય તો 10% હું પડે 10% જીબી પડે તો 100% રકમ ભરાઈ જાય જો અરજદાર વ્યાજ જતું કરતા હોય તો સમાધાન થાય તો બેટર થઈ પતી જાય પૂરું થઈ જાય
બસ એવું એ ડેપ્યુટી એન્જિનિયર બોલાવો પડે
પણ એમની દિશાને તો આવીને ગયા પાછા
હા એને બી કહીને આવતીકાલે પત્રકાર જરા કરે એને બી કહીને
8 3 કરતો બોલે
યસ ખાસ લમ પૂનમ સુનારે
આવતા જો કરવાનો
એક રિવિઝન સર પીવી ઇન્ડાવેટ આવી પેટમાં રિવિઝન છે રિવિઝન એક પીવી ઇન્ડાવેટ આવી જશે
હા એમાં આવી જાઓ
યસ પીવી ઇન્ડાવેટ આવી જશે સર
સીએ નંબર 16 માં તમારું એક છે
હા સાહેબ 7 નંબર શું ટ્રાન્સફર પેટિશન છે સર
શું છે એમાં 16 નંબરમાં
તે ટ્રાન્સફર પેટિશન છે પાર્ટી ની મેટર છે 138 ની મેટર છે અને બે એડિશનલ માં અને બે પ્રિન્સિપલ માં ચાલે છે તો ચારે ચાર મેટર ને કોઈ બી એક
ક્યાં
કોર્ટ
વાપીમાં છે કે અહીંયા
પાર્ટી માં છે પાર્ટી કોર્ટ ચારે ચાર મેટર કોઈ બી એક કોર્ટમાં ટ્રાન્સફર કરી દો તો
તમાવાળા ક્યાં છે તમારા બીજી કીધી નોટિસ જોઈએ
અવંતિ ફીડ્સ લિમિટેડ અવંતિ ફીડ્સ લિમિટેડ
ના એડવોકેટ લઈ આવો ત્યાં કોણ છે પાર્ટીમાં જે એડવોકેટ થાય છે ને અવંતિ કિંસાન એમને હાજર કરી દો અહીં
જી સર
એટલે એમનું સીન કરાવીને આપણે ઓર્ડર કરી દેવાનો
જી સર
નહીતર આમાં નોટિસ બધું આ છે હૈદરાબાદ મોકલવી પડશે
જી
તમે જે ટ્રાન્સફર એપ્લિકેશન કરી છે ને જ્યાં મેટર ચાલે છે ને ત્યાં પાર્ટી કોર્ટમાં એના એડવોકેટ્સ કોણ છે એમને નોટિસ તમારે આ કોપી આપી દો એમને નહીં હાજર સાથે આવો તમે એમને લઈને
જી સર
હા તે થઈ જાય
જી સર
અત્યારે એમાં રાખી દે
પટેલ છે
અત્યારે 1 એપ્રિલ રાખી દો 1/4 વહેલા આવી જાવ તો વહેલા લઈ લેજો
જી સર
નેક્સિસ બેંક તો શું જોયું
એક્સપ્રેસમાં તે સીએ નંબર 14 માં 15 માં છે એમાં મહેસાણા સુધારો કરવાનો છે એ માં છે એ કરવાનો છે
9/4 કરી દો
પછી સીએ નંબર 8 છે એની બે એટલે આપી તે પ્રસ્તાવને નોટિસ
એ બી 9/4 કરો કયા નંબરમાં શું છે
કે નંબરમાં 8
સરદાર ભુગાડો હવે નોટિસ કાઢી દો ને અહીંયા ડિલીટ આપી દો અહીંયા નજીક છે ને જઈ આવશે Then advocate કોણ છે એમને criminal board માં ખાલી બે બાકી રહી ઉપરની એ બે નંબરમાં કયો છે
Definitely ગણિત સાંભળો. એને દિવસે સામે સ્ટુડન્ટ કે ચિંતા આવે તો આ સેવા કાર્ય કરવો
આવે એટલે જોઈ દો અચ્છા ગ્લાસ કાઢી દો આ ઉપર ઢાંકણું કાઢી દો
ને આપણે FD કરવાનું છે.
હા આપણે હાઈકોર્ટનો સર્ક્યુલર કરી દેવાના
હા આરસી એના બધા કલાક છે.
ના પણ આમાં બી એ લોકોને ઇન્ટરેસ્ટ લોસ થાય હા સુપારકર ભાઈ સ્ટાર્ટ નો
ચાલુ કરું સાહેબ.
હા ચાલુ કરો ચાલુ
ગુડ આફ્ટરનૂન સર.
ગુડ આફ્ટરનૂન
Sir, last time I took the honorable court essentially to the documents,
બરાબર
and I also started taking the honorable court to the order in question.
બરાબર
Honorable court would recall their case during the course of arguments was that there is a specific performance of the contract,
યસ
and the trial court, believing that there is a contract which needs to be specifically performed, has granted injunction.
રાઈટ
I will come back to the order after 10 minutes. I will now take the honorable court to plaint
યસ
to show to the honorable court that there is no such pleading in the plaint. The whole plaint does not say a word about a concluded contract. Sir, before I take the honorable court to the plaint, let me indicate orally what their case is. Their case is, you went on discussing with us, you went on negotiating with us, you kept us under a belief that you will enter into a contract. We spent a lot of time and money and energy. Now that you are not entered into contract, we are entitled to compensation. 9 million is the compensation that you should pay. And that is their only case. There is no case of concluded contract anywhere in the plaint. That I will show the honorable court first. So please go to page 503, their amended plaint.
બધી જ આપી દો મને
In 758 is yes. Yeah, wait, beta. So this is original plaint, amended plaint માં minor ફરક છે હું પછી આવું because I have marked original plaint page 503.
હા પેજ 503
હા original plaint છે
હા
સાહેબ એમાં I will only highlight relevant paragraphs. Sir, પહેલા એમણે બધા facts કયા શું થયું શું ના થયું વગેરે વગેરે I have gone through in greater detail, so I will not take the honorable court.
યસ
Sir, please go to page 512, paragraph 26. અહીંયા 20 સપ્ટેમ્બર સુધીની વાત કરી. આપ જોશો તો પેરાગ્રાફ 25 માં 20 સપ્ટેમ્બર સુધીની વાત કરી.
બરાબર
Now, para 26, plaintiff submits that essential terms of the proposed acquisition were already agreed between the parties and they were in discussion for merely closing ancillary terms. એટલે હજી ancillary term તો બાકી હતી પોતે કબૂલ કરે છે.
બરાબર
So please then go to page 514, paragraph 30. It is pertinent to mention that on specific requests made by the defendants, plaintiff confirmed to the defendants it will be able to increase equity value for proposed acquisition to euro 90. Therefore, evidently at every point of time, plaintiff was committed to achieving the closure. Amari tayyari hati. Not that closure was achieved. Sir, please then go to page 515. Last 4 lines of para 31 before para 32 starts. સાહેબ 22 ઓક્ટોબરની વાત કરે છે એમાં this also meant since the deal could not be finalized by end of September 2024 as envisaged the signing exclusivity with the plaintiff continued. Said their own case deal is not finalized till September 24 because the trial court assumes their bid of 9 September is accepted. Copy of email of 22nd October 24 issued by PwC to plaintiff is produced. Now please see further. After receiving PwC's email of 22nd October, given that PwC already assured plaintiff that SPA would be signed with it, delay in closure was only because of the complexity of the deal. Please mark complexity of the deal. Plaintiff patiently awaited an update on the next stage of the deal for the proposed acquisition from defendant's end. એટલે 22 ઓક્ટોબર સુધી તમે રાહ જોઈએ છે. During this time, plaintiffs stayed committed to achieving the closure of the proposed acquisition for a plaintiff. Plaintiff also conducted multiple meetings with the defendant in order to be aligned in their idea and the way forward. એટલે 22 ઓક્ટોબર સુધી અમારી ચર્ચા ચાલુ છે. Sir, then please go to page 516, para 34. Therefore, it is clear from email dated 22nd October and now 29th October that understanding between the parties was deal with the plaintiff was final, but formalities would take some time considering the complexities of the transaction and number of stakeholders involved. Importantly, after receiving email of 29th October, plaintiff did not inform that they were considering other parties for finalization of proposed deal. Plaintiff was completely kept in dark. It was only later plaintiff came to know, while on one hand, defendants had made promise. Now kindly mark, leading plaintiff to believe proposed acquisition would be completed. Not કે contract થઈ ગયો હતો. અમે માનતા હતા કે અમારી જોડે કરીશું. On the other hand, defendants were simultaneously engaging in discussion with other third parties for the same project. Sir, then para 35. It was only on 4th November 24, PwC sent an email to plaintiff informing some other potential transactions seem to be preferable for the defendant. They will pursue those options as well. Cryptic and vague mail issued with the intention of deceiving plaintiff. Now please see, as plaintiffs were proceeding with every stage of the process of proposed acquisition with a reasonable expectation of being successful, and the same and the indicative and final offer submitted by the plaintiff were accepted as well as acted upon by defendant. Plaintiff were extremely shocked on being informed the defendants were considering other transaction. Copy of email is so and so. With a bona fide intent to close transaction. Laji transaction to open che. And to seek clarity on the aforesaid ambiguous email of PwC of 4th November 24, plaintiff responded stating they have been making attempt to breach any gap in their offer and expected valuation. એટલે એ લોકો પોતે કહે છે કે there is a gap which needs to be breached even on 4th November.
They were ready for the signing the contract.
Sir, if the contract was ready, where is the question of breaching the gap of the valuation and the price? Sir, they were ready to sign contract provided there is a contract. Where is the contract when they say on 4th November, we were ready to breach the gap? Page para 36 जो है. मेल email आपने परम जैसे में दिखा रहे हो तो. If there is a gap, we are prepared to breach the gap. Now, sir, there cannot be a gap once there is a contract. Then parties are at the same mind ad idem. There is no possibility of any gap. You breach a gap, meaning thereby there is a difference between your view and my view. Where is the then question of a concluded contract? I am no potano case.
No, they are also not saying that there is a concluded contract.
तो बात पूरी થઈ ગઈ
That
સાહેબ.
is a clear है मतलब ये लोग कानूनी they are not saying, they are only saying कि we have made all our attempts to sign the contract.
I'm immensely, sir, I'm immensely obliged. I have done my job. If there is no concluded contract, how can there be specific performance? If there is no specific performance, how can there be injunction? बात पूरी થઈ ગઈ. How can there be injunction in relation to a contract which is not concluded? Sir, how can there be a specific performance of a non-existing contract? That is precisely my case. Trial court એમ કહે છે કે contract છે. Sir, that is the whole, your honors have focused on the right issue.
કારણ કે I think you are એમના plaint માં પણ ક્યાંય they have not mentioned કે there was
Sir,
a finality achieved in the contract. I
Sir,
think.
that is only thing that I was trying to point out. Sir, please see their own case. Page 519. Para 41. attempt to breach gap again 14મી નવેમ્બર. સર હવે એક જ પેરેગ્રાફ દેખાડું પેજ
41
520.
માં આ શું છે? As the defendants decided to act in breach of the final offer.
Correct. Sir, I may act in breach of there are 100 offers. Offers તો હોઈ શકે. Till it is accepted, there is no contract. And sir, kindly recall the clause in my tender document and their own offer that it is not a binding offer on either party.
Yes.
Sir, now this becomes very clear. Please see their own analysis, page 520. Now I will point out each of the factor is factually incorrect. Page 520, para 45. This is their case.
Wrongful conduct.
So now I'll go step by step. Plaintiff submits that the following undisputed facts make it clear. Defendants conduct decision of proceeding with finalization of the proposed acquisition with a company other than plaintiff, especially without payment of break fee, amount to plaintiff is wrong and unsustainable. So break fee mane આપવી જોઈએ. કેમ? 1. Plaintiff's indicative offer was accepted by the defendant, meaning thereby clause 2G thereof was also accepted by defendant, which provides no other Indian company will move to the next stage of proposed acquisition. Now, sir, આ જે બ્રેક ઇન્ડિકેટિવ ઓફરની વાત કરે છે, સર પ્લીઝ મેં ગઈકાલે ડોક્યુમેન્ટ બતાડ્યા છે પણ હવે હું આ સંદર્ભમાં આપને દેખાડી દઉં. સર પ્લીઝ ગો ટુ પેજ 172. આ એમની ઇન્ડિકેટિવ ઓફર. આ પેજ 172 ની જે નોન બાઇન્ડિંગ ઓફર છે
આ from સુધીર વીરમણી કરીને
કરેક્ટ છે.
જૂનની
હા.
છે 14
હવે
જૂન.
સર એમાં આપ જોશો તો પેજ 176 માં વેલિડિટી 7 દિવસની છે અને 7 દિવસમાં મેં એક્સેપ્ટ કરી નથી. અને પેજ 177 માં નોન બાઇન્ડિંગ. મેં સાહેબ આપને દેખાડેલું છે પણ આઈ એમ જસ્ટ શોઈંગ અગેન નાઉ વન બાય વન ટુ પોઈન્ટ આઉટ ધીસ ઇઝ નોટ ઇવન ધેર કેસ. Now I go to Roman 2. While submitting first final offer, plaintiff increased enterprise value from euro 360 million to euro 378 million, out of which euro 18 million was for exclusivity premium. Along with the first final offer, applicant also shared a marked up version of the share purchase agreement. Subsequently, on 30th August 24, applicant again shared a marked up version. સાહેબ એમની આ ફર્સ્ટ ફાઇનલ ઓફર આપને પેજ 220 ઉપર દેખાશે. પણ પેજ 226 ઉપર અમારી સહી જ નથી. We have not accepted.
On what basis they are saying that they have accepted our offer and
Yep.
they have granted exclusivity and all?
સાહેબ દલીલ તો ગમે તે થઈ શકે, ક્લેમ તો ગમે તે થઈ શકે. This is not. I'm going step by step. Let's go to the third issue. Next paragraph. On 6th September 24, PwC clearly informed defendants were given a signing exclusivity to the plaintiff. This exclusivity was initially granted till 22nd September 24, since defendant expected the deal to be closed by the end of September. સાહેબ એટલે 22 સપ્ટેમ્બરના લેટરની વાત કરી છે. 22 સપ્ટેમ્બરનો લેટર સાહેબ આપને પેજ 301 ઉપર મળશે.
Okay.
મેં આપને બતાવ્યું હતું કે લાસ્ટ લાઈનમાં એમ કે છે if the એક તો this is sign one negotiation exclusivity નથી, signing exclusivity 22 સપ્ટેમ્બર સુધી છે અને છેલ્લું વાક્ય if the proceeding above is acceptable for Jindal, we are happy to provide you quickly with a draft exclusivity agreement for your review. મેં આપને કહ્યું હતું આવો કોઈ એગ્રીમેન્ટ એમને મોકલ્યો નથી, આવો કોઈ એગ્રીમેન્ટ સહી થયો નથી. એટલે આ થર્ડ કન્ટેન્શન આપણે ફેક્ચ્યુઅલી
એટલે આ PWC વાળા જ કહે છે, if the proceedings above is acceptable for Jindal, they are happy to provide them quickly with a draft exclusivity agreement for their review.
એ એમણે હા પાડી નથી ને કદી સહી થયો નથી. એટલે આ ડ્રાફ્ટ એક્સક્લુઝિવિટી વાત પણ ગઈ.
Jindal has not responded to this email.
નો સર પ્લીઝ સી ધેર ઓન નેક્સ્ટ ડોક્યુમેન્ટ સર. આ ડોક્યુમેન્ટ આપ જોશો તો પેજ 301 ઉપર જે છે 6 સપ્ટેમ્બરનો છે.
Yeah.
પછી 9મી સપ્ટેમ્બરે એ લોકો ફાઇનલ ઓફર આપી દીધી, એક્સક્લુઝિવિટી માંગી જ નથી. એના ઉપર ઇમિડિયેટલી આવું છું, બટ ધેર ઇઝ નો એક્સક્લુઝિવિટી એગ્રીમેન્ટ એવર સાઇન્ડ. Yes.
બરાબર. Next.
Sir, then Roman 4. On 9th September, applicant shared its final offer with the defendant, wherein applicant revised its offer to €1,369,000 on a debt-free, cash-free basis. Applicant clearly provided increase in the enterprise value for defendant of €9 million from the indicative offer should be read subject to clause 2L. સાહેબ આ 9મી સપ્ટેમ્બરની ઈ ઓફર એમની પેજ 304 ઉપર છે. પણ સાહેબ પ્લીઝ ગો ટુ પેજ 309. વી હેવ નોટ સાઇન્ડ ઇટ, વી હેવ નોટ એક્સેપ્ટેડ. પ્લીઝ સી પેજ 309. Accepted and executed, it is blank. So this is also not accepted by us. Now I go to item 5. As per plaintiff's final offer which was accepted, kya accept thai chhe? Who is accepted? Seller agreed to pay €9 million in case it decides to not proceed with the applicant consummate transaction with any other party. So this is part of para 4 which is incorrect. Now I go to para 6. On 20th.
This is what they are claiming.
Sorry?
This is what they are claiming now, damages.
એમ 9 મિલિયન જ જોઈએ છે એમને, પણ આ 9 મિલિયન અમે આપાઈ ના પાડી એટલે આખી ડીલ 3,000 કરોડની અટકાવી દીધી છે. Now sir, Roman 6. On 20th September 24, PwC again shared a counter marked up SPA. The fact that the parties were exchanging version of SPA makes it clear negotiations were at advanced stage and only the non-essential term of SPA were being worked out. સાહેબ 20 સપ્ટેમ્બરનો મેલ જે છે એ આપને પેજ 314 ઉપર મળશે કે જેની સાથે મેં પેલો ડ્રાફ્ટ SPA આપને બતાવ્યો હતો કે એમાં 500 ફેરફાર છે. અને એ લોકો પોતે કબૂલ કરે છે, કારણ કે સર પ્લીઝ ગો ટુ પેજ 415. એ કહેતા હો તો અમે નવો ડ્રાફ્ટ તમને મોકલી આપીએ. પ્લીઝ ગો ટુ પેજ 415 એટ ધીસ સ્ટેજ.
October નું છે.
યસ સર, છેલ્લી લીટી જુઓ આપ. એક તો ટેક્સ કોલ બાકી છે, બીજો ટેક્સ કોલ બાકી છે, લીગલ કોલ બાકી છે. કાઇન્ડલી નોટ અવર share purchase agreement markup is ready. Please let us know if you would like to share with your legal advisor so that they can review in parallel. એટલે અમારો SPA એમને મંજૂર નથી, એમનો SPA એ મોકલી આપવાની તૈયારી દેખાડી છે, એમણે મોકલ્યો નથી, અમે કદી હા પાડી નથી, એમનો કેસ પણ નથી કે એમણે મોકલ્યો. તો કોન્ટ્રાક્ટ ક્યાંથી થયો? So para 6 is also factually incorrect. Now let's go to para 7. PwC had informed the plaintiff that the defendant's lawyers and plaintiff will have the first negotiation round on the SPA and start on WIN process. Thus, PwC had informed plaintiff of the modality of closure of transaction, thereby giving an impression to the plaintiff that the deal would be finalized. Let us assume વાત સાચી છે. મેં એમને impression આપી. Impression is not a contract, which is again not correct. We have always been saying you are not the only candidate in the market. Now I go to 8. Plaintiff had multiple site visit to the offices of defendant number 2. Parties held various meetings to discuss the acquisition. Again, discussions. And finally, Roman 9. At the relevant time, defendant did not object to the break fee clause mentioned in the final order of the plaintiff. This meant defendants had no objection to the break fee clause, accepted the same. Therefore, any step taken by defendants for entering into SPA with a third party, which is also an Indian company, must be subject to the payment of break fee of euro 9 million to the plaintiff. Other amount as mentioned in the suit. Defendants bound by the break fee clause cannot be permitted to SPA with a third party without payment of break fee amount to the plaintiff. आज એમનો કેસ છે. અમને break fee આપો, એના વગર તમને ટ્રાન્ઝેક્શન નહીં કરવાનું. સ્પેસિફિક પરફોર્મન્સનો કેસ જ નથી, કન્ક્લુડેડ કોન્ટ્રાક્ટનો કેસ નથી. Sir, please see conclusion. It is clear from the above that negotiation SPA were at an advanced stage and the conduct of the parties clearly demonstrates that the final offer, including provision for payment of break fee, was accepted. Sir, मैं आपने बताया it was never accepted and acted upon, which again I have shown that it was never acted upon. Pursuant thereto, plaintiff also conducted final due diligence. Deemed acceptance of final offer implies its acceptance. Well, how is it deemed acceptance? Sir, it is not their case. So, para 7 and para 48. Okay, let me read para 47 and 48 and then I'll conclude. The plaintiff's prompt attempt for submission of bid, conducting all required due diligence, site visits, and being regularly involved in discussion with defendant was based on a clear, unequivocal, and unambiguous promise made by defendants, their conduct and impression given by them regarding finalization of proposed acquisition for a plaintiff. Throughout the process, plaintiff were made to believe by the defendant's action that proposed SPA would be signed with the plaintiff itself. In such a case, defendants are stopped from acting contrary to the promise. So, not contract. And are obligated to execute SPA.
તમારે આ જે છે 309 માં એમણે જે તમે સાઇન નથી કર્યો બ્રેક ફી ની ઓફર ને બધું.
હા.
That mail was sent to you on 9th September 2024.
Yes, sir.
બરાબર ને? When
But
you have not accepted that offer, the
Yeah.
break fee that you are not, it is not binding on you, then there was no use of continuing this sending or emails to them. Okay, we will, પછી તમારે એકવાર you have not accepted, that means it comes to an end.
Sir,
પછી why you have started again negotiating with them?
Sir, okay, let me, the Honorable Court's query is pertinent. They gave an offer with
Because
break
after
fee.
9th September also, there are a number of emails that you are.
Correct, correct. Sir, that's what I'm answering. They gave offer with break fee. We were not agreeable to break fee, but subject to that, we were agreeable to negotiate. So once they gave break fee, conditional offer, we came back and said, look, we are not prepared to give break fee, but we will negotiate. So negotiations went on without break fee. Their insistence on break fee, my denial on payment of break fee. So parties continue to negotiate to conclude the deal. But break fee was never agreed to between the parties. Sir, can I again clarify? Their case is in their final offer. And sir, again, let's go to break fee clause. Again, that's also very important because that break fee clause also is not in any way concluded in the present case. Please go to break fee clause. Page 307.
On the acceptance of this offer.
હા સાહેબ અહીં અટકી જાઉં. આ ઓફર તો મેં એક્સેપ્ટ કરી જ નથી.
Right.
એટલે આ ક્લોઝ જ અમલમાં નહીં આવે. First, sellers agreed to pay Jindal following in case no binding agreement in relation to transactions are signed between Jindal and sellers on or before 31st October 24. €1 million in that if case transaction is not consummated by either party for any reason whatsoever, or euro 9 million in case seller decides to consummate the transaction with any other party or not progress with the transaction after Jindal has confirmed their offer post confirmatory due diligence. એટલે આ બ્રેક ફી ની વાત બે કારણસર નહીં આવે. ફર્સ્ટ, I have never accepted. And second, Jindal has not reached the stage of confirmation post due diligence.
Break fee, what they are saying is, upon the sellers agree to pay the Jindal the following in case that no pending agreement in relation to the transactions are signed.
Correct.
Transaction signed na થાય, in that case a break fee no tu.
Ha.
And transactions were not signed.
Correct. Correct. Provided, sir,
Hmm.
it's not as if we were to give a gift to them. Provided we commit breach of the contract. Sir, please go to clause 2 again. Euro 9 million in case sellers decide to consummate transaction with any other party or not progress with the transaction after Jindal has confirmed their offer post confirmatory due diligence. એટલે એકવાર એ એમની ફાઇનલ બધું જ ડ્યુ ડિલિજન્સ કરી લે, ફાઇનલ ઓફર આપી દે, પછી હું ના પાડું, એટલે એકવાર કોન્ટ્રાક્ટ થઈ જાય પછી હું ના પાડું, તો this is in the form of damages.
Okay.
My first submission is, but this is upon acceptance of the offer, which I have not accepted. Sir, page 309 દેખાડે છે કે I have not accepted. Page 314 માં મેં કહ્યું કે ભાઈ હું મારી કાઉન્ટર તમને શેર પરચેસ એગ્રીમેન્ટ મોકલાવું છું. Where have I accepted? But that is one part of the dispute. Question today is trial court proceeds on a footing on the basis of oral submissions of the plaintiff's learned counsel. That's a case of a concluded contract when it is not even a pleading. How can court pick up a case which is not even pleaded in the plaint? Concluded contract નો કેસ ક્યાંય plead જ નથી કર્યો એમણે. એમનો કેસ એટલો જ છે કે તમે છેક સુધી અમને લઈ ગયા અને પછી ના પાડી 9 મિલિયન આપો. Now sir, why would I not be in a position to pay? Not only because I have not agreed, this was, as I said, a proposal which was being discussed with multiple offerers. To everyone, same information was being given. From everyone, offers were being invited. We were evaluating offers of everyone. He said, but I am giving condition of 9 million. We said we are not agreeable with that condition. This is what we are discussing. There cannot be a 9 million condition on an implication. And today, trial court does not say that because of 9 million clause, I am granting injunction. Trial court accepts oral submissions of the learned counsel for the plaintiff. That's a concluded contract. હવે હું આ પત્ર તરત આપણે જજમેન્ટ ઉપર લઈ જાઉં છું.
Okay.
Now sir, એક જ પેરેગ્રાફ આપ જોઈ લો, page 524 para 50, and that probably answers the honorable court's question. It is submitted that defendant's act of signing SPA with another Indian company instead of plaintiff is a clear breach of plaintiff's reasonable expectation from the process of proposed acquisition, not breach of a concluded contract. Breach of expectation. મારી અપેક્ષા પ્રમાણે તમે કામ ના કર્યું. This is not even their case that there is a concluded contract. And trial court elevates the whole transaction to concluded contract and says, I will now injunct you from going further. Sir, मैं आप प्लेंट में मर्जी आपको बताऊं तो बता दूं. Now I go back to the trial court's order. So please go to the trial court's order now. We were on page number 26. So para 11.
Para?
Para 11 થી ચાલુ કરું.
11, अच्छा,
ત્યાં સુધી facts છે by and large.
बराबर.
So looking to all above correspondence, this court comes to the conclusion plaintiff proceeding with every stage of the process for the proposed acquisition with a reasonable expectation of being successful, indicative offer and final offer of the plaintiff were accepted as well as acted upon by the defendant. આવો તેમનો કેસ જ નથી. એમનો કેસ 9 મિલિયન યુરો પૂરતો છે, ઓફર પૂરતો નથી. Plaintiff was and is ready to increase offer and breach any gaps in his offer and expected valuation by writing various emails which are received by PwC. That is not disputed. Plaintiff informed PwC that we had confirmed the enterprise value of euro 369 million, also confirmed to be able to increase equity value to euro 90 million. Defendants were responding to each communication. એટલે ચર્ચાઓ ચાલી રહી છે. This is no concluded contract. It is true that defendant did not accept terms and conditions sent by plaintiff in writing. However, defendant did not object to any condition. So this is factually incorrect. Totally incorrect statement. Particularly break fee clause which was mentioned in final offer of the plaintiff. Even if emails, correspondence or record are treated as counter offer, that's accepted by the silence of defendant, as acceptance can be implied from the conduct of parties. So silence is never taken as an acceptance in law. Otherwise, sir, I will tell someone on the lighter side કે હું 5 લાખ રૂપિયા ફી લઈશ, ક્લાયન્ટ બોલે નહીં તો પછી 5 લાખનું બિલ મોકલી આપું. Sir, it has to be an agreement between the parties. I go further. Learned advocate for the defendant number 1 has mostly relied and argued there is no concluded contract. Defendant number 1 is not accepted offer, not signed document, mostly relied on letter but so and so. Sir, he is referring to various documents. I have taken the honorable court to documents. If the honorable court permits, I'll skip this. Because otherwise I'm again going to take time on reading the document. I can skip the document, sir. I can just give the parallel page numbers. Sir, page 27 માં second paragraph માં page 138 કહ્યું છે. એનો પેજ નંબર આપની પાસે page 181 છે.
બરાબર.
એના પછી લાઈન 3 લીટી પછી page 141 કહ્યું છે, આપનામાં 184 છે.
બરાબર.
ને પછી 4 લીટી પછી 145 છે, આપનામાં 188 છે. ને છેલ્લેથી ચોથી લીટીમાં page 258 આપનામાં 301 નંબર છે.
ઓકે.
Now, sir, page 28, para 13. Before discussion case law, I would like to mention it is the duty of court to arrive at a conclusion whether there was any meeting of mind between the parties which could create a binding contract between them. Therefore, even if documents produced by the plaintiff not signed by the parties, they could not be ground to disbelieve any party. Contract may be spelled out from the correspondence and transaction between the parties. I have no dispute on these facts. While deciding application for interlocutory injunction, court has to keep in mind interlocutory remedy is intended to preserve in status quo. Rights of parties may appear on a prima facie case. Unlike most of the suits where the facts can be a matter of dispute and evidence is required to be led, in the present case, surprisingly or rightly, we have not produced a single document. And we are not disputing a single document produced by the plaintiff. Question is one of interpretation of document. Therefore, on the basis of reading of the document, honorable court will have to take a view. Question of parties entering the box and trying to give better version, etc. will not survive. Court also in restraining defendant from exercising what he considers a legal right, what the plaintiff would like to be prevented, puts scales, relevant consideration, defendant yet to commence. So these are all standard phrases from judgments. Now, sir, then he refers to some of the judgments. When I go to judgments, I'll come back. So I will skip the next paragraph of Rickman, a judgment completely in my favor. We can skip that. Next page, page 29, he refers to my judgments.
Endowment Energy Limited.
Page 29, para 15, again he refers to judgments of the plaintiff. Page 30, para 16. Again, my judgment is referred to. Now, but this is interesting observation. Learned advocate for the defendant number 1 relied on 4 judgment mentioned in so and so on the subject of concluded contract and acceptance of the absolute and conditional formation of contract. This court firmly believes. Now, sir, please see, next sentence is shocking. By sending email and correspondence by both parties, there was a meeting of mind. How can by sending email and correspondence, there can be meeting of mind? Sir, if this is correct, somebody sends offer to me, I say I deny. Mails are sent, meeting of mind. You have to find meeting of mind at the end of the correspondence. Merely because correspondence is exchanged, you can't jump to a conclusion there is a meeting of mind. Sir, learned judge has singularly failed to point out which offer of which party was accepted by the other party. My offer was accepted by them, if so which, or their offer was accepted by us, that if so which, that he has singularly failed to note. He only says sending email and correspondence is a meeting of mind. This is, if I can use the phrase, Himalayan error both in fact and in law. Then the next paragraph. When after thorough reading of documents submitted by plaintiff, this court is satisfied plaintiff has established a prima facie case. Which correspondence? How does he come to that conclusion? In the earlier part, Honorable Court has seen, he has referred to correspondence. A wrote to B, B wrote to A, A wrote to B, B wrote to A. Where is the conclusion that this is on the basis of this correspondence? I hold that this offer stood accepted. No such finding. Because there is email and correspondence, concluded contract. Therefore, there is a first jump, second jump, because there is a concluded contract, there is a prima facie case. Then para 17, he again goes to the judgments. Para 18, he again goes to some other judgments. Page 32, because I'm all not on the judgments part, which I'll separately deal with. So far as arguments on behalf of defendant, there is no concluded contract between parties and defendant. One has not accepted offer, not signed an agreement. I would like to again cite some judgments. I'll come back to these judgments. Page 33. Again, he refers to judgments. Page 34. Para 19. Therefore, looking to the ratio of the aforementioned judgments and arguments on the grounds that when no concluded contract with the parties, suit must be filed, are not helpful to defendant number 1. Why? Where have you said there is a concluded contract? Next para 21st line. Present case looking to documents submitted along with the plain prima facie case is established. Which document? Which document shows contract is concluded? I have taken the Honorable Court to every document, including their last emails whereby they say, we are still prepared to increase the price. Please then go to para 20, subpara of para 20. In view of the above submission averment, plaintiff established a prima facie case in its favor. Balance of conveyance also in favor of plaintiff. And again the defendant. How? On what basis? The dispute pertains to 90 million, if at all, and you stay deal worth rupees 3,000 crore. Plaintiff shall suffer and continue to suffer irreparable loss. How will he suffer, sir? He is not paid 90 million. He has a suit against me. If ultimately he succeeds, he'll get a decree which cannot be compensated in monetary terms. His claim is monetary claim, 90 million. And sir, how? Page 35, how is learned single judge completely with great respect, and I will only use this phrase, wrong. Please go to page 35. Top. One more aspect
Hmm.
I would like to discuss that initially this stage, this court refused to exempt plaintiff to file suit without following procedure as mandate under section 12A of the Act, returned the plaint. After that, as discussed above, Honorable Division Bench of the High Court set aside the order, ordered this court to register plaint without following mandatory procedure, in which order impliedly grants exemption under section 12A of the Act. Order this court will register by passing mandatory procedure as mandatory law. Therefore, this court impliedly believes High Court also satisfied this suit is of interim urgent nature. We are not saying it is not urgent nature, but that does not, sir, every suit of interim urgent nature does not mean interim order is required to be granted. How does he get support from High Court order that interim relief is required to be granted?
In High Court also, Mr. Suparkar, you appeared, no? High Court also you appeared, no? There.
I have not appeared, some other counsel appeared. The Honorable High Court has kept every issue open. Please go to Honorable High Court's order, sir. The Honorable Court will get Honorable High Court's order. I just point out, sir, 559. Please go to page 559. આપને મળ્યું 559 સર હાઈકોર્ટે બધા ફેક્ટ્સ ડિસ્કસ કર્યા છે. અલ્ટિમેટલી જે કન્ક્લુઝન ને ડાયરેક્શન જે આપ્યું આપ જોશો પેજ 577 or page 576 para 27. Taking note of the above, we find that serious disputed questions of fact and law have been raised by the contesting party. It would therefore be proper that commercial court shall examine issues pertaining to its jurisdiction as agitated by the defendant before us. Also, whether plaintiff is entitled to any interim relief or not. We may also note commercial court has returned plaint without registration of the suit. We therefore direct commercial court to register the suit immediately, leave it open for the defendant to file application assailing jurisdiction of the court to entertain the suit. Interim application filed by the plaintiff and application of rejection suit, if any, filed by defendant raising the issue of jurisdiction shall be decided simultaneously, though albeit by two separate orders. We may also clarify, even in case defendant fails to file any application raising issue of jurisdiction of commercial court, it will be incumbent for the commercial court to determine its own jurisdiction before entertaining into merits of the interim relief application filed by the plaintiff. All issues raised by the parties on the merits of their respective claims have been left open, and commercial court is required to examine the matter independently without being influenced by any of the observations made herein before, which are confined to the scope of 12AA. Honorable High Court could not have been more express and more explicit. The page 35, next paragraph. Further submission of the plaintiff is it had made out a prima facie case, even other response 1 to 4 have not denied. Meetings between parties have not been held. And as there was no response to email, letter, correspondence with parties, there was no denial of the contents of email. So there have been plethora of emails denying it. I've taken the honorable court on each of them produced by the plaintiff. Court can consider at the time of injunction application about the existence of agreement. Plaintiff strenuously argued that conduct of parties demonstrated that agreement for the sale of share was considered and was agreed to be enforced, taken all reasonable steps toward the effective implementation of same, which arguments have force. There is no doubt that an oral agreement can specifically enforce, as discussed above, very much known to law. Deciding a question under Order 13 of CPC, court is assigned a very important duty to find out whether prima facie case is in existence. Court is also required to consider a question of balance of convenience. Court is required to form an opinion on the basis of documents on the record, whether the plaintiff ultimately succeed or not is a different question altogether. On failure in the suit would not mean that plaintiff did not disclose any cause of action. Sir, then para 21 again is on law. I will skip. Now para 20, subpara of para 21 is important. Again, facts super આવે છે. In the context of opposite circumstance, if the version of email correspondence to be examined is compared with other documentary material attached along with the plaint, it would suggest till last moment, undisputedly, plaintiff was kept under an impression that the terms are to be agreed and formality of the execution is awaiting. Now, in the aforesaid situation which is prevailing, whether this appears to be oral contract or a concluded contract or a remote right is emerging in favor of plaintiff to seek an equitable relief are questions to be examined at the stage of trial. Sir, with great respect, concluded contract નો તો plaintiff નો જ કેસ નથી. Plaintiff નો કેસ તો ખાલી break fee પૂરતો છે. Therefore, it is not open and shut case where the amount of where the moment agreement to sale took place and some amount is accepted by other party, contract which was in process of getting materialized would evaporate. Sir, it would evaporate provided it is there initially. If it is not there, it will never evaporate. Evaporation means existence first. At least at this stage, with no certainty, a clear conclusion is possible to be arrived at. It is further reflecting from record and conduct of defendants that projection is given that transaction is taking place with a view to mitigate the deal which had to be finalized. So assume that I was giving such signals. That would not mean that the deal has to be stopped. These are the circumstances which are not possible to be ignored at this stage, at the stage of proceeding where the subject matter of suit is directly preserved by the court below. So then, debatable issues, status quo to be granted, and therefore please now see the relief that is granted, page 38. Interim injunction application of plaintiff under order 39, rule 1 and 2 is hereby granted. In the meantime, defendants and shareholders of defendant, this is one fundamental issue which I have already addressed. I will also take the honorable court to law, who are not parties, be directed to maintain status quo in respect of disputed transaction regarding suit property. How can you injunct a transaction when plaintiff is not even claiming specific performance, in the sense it is not his case, it's a concluded contract? Sir, I've taken the honorable court to the whole plaint. It is not his case. There is a concluded contract. His only case is my final offer, whereby I was entitled to 9 million euro of break fee was accepted, which I have demonstrated is incorrect. But trial court has thereupon restrained transferring of shareholding of D1, D2 directly, indirectly through subsidiaries or through officials in any manner whatsoever. And defendant themselves, officers, servants, affiliates, employees, all other in capacity of principal or agent acting for and on their behalf or even claiming through them are restrained from transferring, alienating, creating third-party interest in the shareholding of defendants or dealing with shareholding in any manner. Shareholding is not something which is subject matter of dispute, because it is not even the case of the plaintiff that the contract got concluded. The deal, the honorable court would recall, is around 360 million euro. આજે લગભગ 3500 કરોડ રૂપિયા થાય. Everything got stayed without plaintiff investing a single rupee. Sir, now I would go to the judgment part. So do we start after recess, sir?
After recess. અને તમે ના જે પેજ નંબર 307 માં મિસ્ટર સુપાર saying, no, 307.
307, sir. એક જ સેકન્ડ. હાજી.
No, તમે સ્પેસિફિક કોઈ રિસ્પોન્સ આપ્યો છે કે ભાઈ it is not acceptable to us. So
Sir,
we are not agreeing to this type of break fee clause or anything, something
Sir,
like that you are having.
એના બે જવાબ છે. એક તો 309 મેં સહી જ નથી કર્યો.
બરાબર. But ચલો, at
ના,
least you have not
આપણે
signed.
ના એ જવાબ પણ આપું. અમે એમને ડ્રાફ્ટ શેર પરચેસ એગ્રીમેન્ટ મોકલી આપ્યો. આ પેજ 314 થી જોશો.
You have mentioned that it is not acceptable to us or something like
નહીં,
that.
314 માં જે ડ્રાફ્ટ શેર પરચેસ એગ્રીમેન્ટ મૂક્યું છે એમાં
Right.
ક્લોઝ છે જ નહીં. મેં સામે જે એમને ડ્રાફ્ટ શેર પરચેસ એગ્રીમેન્ટ મોકલ્યો, સાહેબ 314 જોયું આપે?
હા, જોયું મેં.
એ કવરિંગ લેટર છે. ડ્રાફ્ટ શેર પરચેસ એગ્રીમેન્ટ પેજ 316 થી છે. એમાં ક્લોઝ છે જ નહીં. અને ત્રીજું, ઇન એની કેસ આ ક્લોઝ ત્યારે અમલમાં આવે કે જ્યારે એ લોકો ડ્યુ ડિલિજન્સ કરી અને પછી હા પાડવાનું ના પાડવું એ તબક્કો ગયો પણ નથી. So there are three answers. One, I have never accepted expressly by not signing the document. I have not agreed impliedly because my share purchase agreement page 316 does not contain it. And third, in any case, it is not triggered. It is not triggered because the stage has not arisen. One more aspect, sir. Page 3. Sir, thank you. Please go to, sir, page number. Page number 308.
308, yes.
Last clause. This offer is valid for 7 days from the date hereof. We request you to sign the countersigned copy on or before 16 September. એટલે કાઉન્ટર સાઇન મેં કરી નથી, 7 દિવસ તો પૂરા થઈ ગયા.
જે વેલિડિટી નું છે,
હા, એમનો પોતાનો કેસ કે 7 દિવસ સુધી વેલિડ છે, એટલે 7 દિવસ 9મી પછી 7 દિવસ 16મી સપ્ટેમ્બર થાય. મારો પહેલો એનો રિસ્પોન્સ જ આપ જોશો તો મેં 20મી સપ્ટેમ્બર મેં આપ્યો, પેજ 314, ને એમાં મેં આ ક્લોઝ મૂક્યો નથી.
આપણે મિસ્ટર સુપારકર 2 વાગે મળીએ આપણે, બરાબર? 2:45.
2:45. I'll be there. Thank you, sir.
Okay. હા, એટલે મેં કીધું કે moreover he himself is an advocate and he should aware of these things. And in spite of that he has not remained present. એટલે પછી કે પણ સર we want to submit evidence. તો મેં કીધું તો પછી this order will not be cancelled. It should be treated as an interim maintenance order. Your maintenance amount will continue and matter will be remanded back. તો કાલે લોક અદાલતમાં રાખી દેવી છે આપણે કાલે. મેં બંને કે પ્રોસેસ તૈયાર કરી દો, બરાબર ને? એટલે તમારું મેન્ટેનન્સ અમાઉન્ટ જે છે કન્ટિન્યુ રહેશે પે કરવાનું. જે બેનને અરજદારને
મારા ક્લાયન્ટને બોલાવ્યો ને આ છે પે કરીને કોન્ફિડન્સ એને સમજાવી દઉં.
હા, એટલે કાલે રાખીએ આપણે આ મેટર.
કાલે રાખી.
પણ એ કહેતો હતા કે મેજર થાય તો મેં કીધું એ બધું નહીં, એ બધા ટ્રાયલ કોર્ટ ડિસાઇડ કરશે ફરીથી. મેટર વિલ બી રીઓપન ના હોય. એટલે મેં કીધું કે this will be the interim orders and you will be free to decide whether that the persons claiming maintenance have actually majority or not. Minor હોય તો they entitled for maintenance, otherwise they will. બરાબર ને? So we are keeping it on tomorrow on the લોક અદાલત. બરાબર, તો કાલે બોલાવી લેજો એમને.
સીરિયલ નંબર 16 સાહેબ એમની એક તારીખની જગ્યાએ 3 તારીખ કરાવી છે.
હવે કાલે એ રાખી દઉં.
એ પાર્ટીના એનો
હા,
એમને 3 તારીખ
16-3 કરવી છે. 3-4 સારું. અવંતી ફીડ્સ વાળું છે ને? 3-4 સારું.
સીરિયલ નંબર 2 માં
આમાં વંદના છે ને, સિરિયલ નંબર 20 છે ને આમાં, એ લોક અદાલત 8-3.
સીરિયલ નંબર 2 માં સાહેબ એડવોકેટ રિસ્પોન્ડન્ટના હાજર છે. એમને સાહેબ 28-3 28-3 દલીલ રજૂ કરી. એપેલેન્ટ આજે રજૂ કરી.
અપેલેન્ટ કે તો 28-3 જોઈએ છે. તમે એપ્લિકેશન આપી દો, બરાબર છે? યસ, સારું. યસ મિસ્ટર સુપારકર, નાઉ યુ મે સ્ટાર્ટ.
થેન્ક યુ, સર. સર, આપણે પ્રશ્ન છેલ્લો 9મી સપ્ટેમ્બરની બ્રેક ફી માટે we closed at that. I gave my explanation.
બરાબર છે.
But there is also a 2-page note which I had given yesterday,
Yes.
which gave all correspondences after 9th September to show parties were never agreeable to
હા.
their offer.
Note on relevant correspondence on behalf of the appellant.
Ha, I have started from 9th September only for this reason.
Yes, yes.
9th, 10th, 26th September, 10th October, 14th, 17th, 29th. Sir, page number સાથે આપ્યું છે, therefore I don't want to take the honorable court's time again, but this is what our submission is.
Okay, okay.
Now, sir, I come to the law. There are two different compilations which I will give. One deals with the judgments on which trial court or the plaintiff has relied.
Yes.
And second, the judgments on which I rely. Let me deal with the second situation first.
Okay.
That is, sir, compilation B.
Wow. Compilation B, yes. MMH holding GmbH versus.
The judgments relied upon by the respondent number 1 and the trial court for grant of temporary injunction in the order dated so and so.
Okay.
So, in order that honorable court has quick glance immediately after index,
Hmm.
I have given a note also. Please see pages 1 to 10 is a note discussing every judgment, why it is not applicable.
Are all the judgments cited by the plaintiff?
By the plaintiff or by the learned judge on his own.
Okay.
Now, either
soft copy because we to the other side.
either the judgments have no application or in fact some of the judgments help me.
Okay.
For a quick glance, sir, pages 1 to 10 contain my contention with each of the judgment.
Yes.
But I will very quickly take the honorable court to the relevant pages and paragraph of the judgment. We have in the index mark relevant page and para also.
Hmm.
So the first judgment with the trial court holds or reads is on page 11, Prasar Bharti,
Yes.
for the purpose of making a very startling statement that at this stage, nothing needs to be seen.
Hmm.
Now, please see, Prasar Bharti says no such thing. This is a complete misreading of the judgment or order. It's an order which starts on page 12.
Hmm. Hmm. Yes.
And the only observation that the Honorable Supreme Court said,
Hmm.
we have heard the learned counsel for the parties. It is our considered view at this stage we ought not to consider submissions made on behalf of the parties on the merits of the controversy as the same may effect of prejudicing either of the parties. So Honorable Supreme Court at the third stage may not opine on the contentions. That does not mean the trial court has not to deal with the contentions. The trial court says, therefore I don't need to see anything. Sir, आपने ये part trial court नो जो हो तो ये, can I show the honorable court that part of the trial court order, sir?
Yes, page.
Sir, I'll just take please see the trial court order, page 22. On this aspect, the honorable court would find is on page 1 second. Page 21, second para 6. First of all, it is a well-settled position of law propounded by the Honorable Supreme Court that at the interim stage, minute details and examination of merit are not to be undertaken. So, क्या कहूँ છે હું તો આપની પાસે જજમેન્ટ હાથમાં છે પેજીસ 12-13 માં હવે એક પણ અક્ષર સુપ્રીમ કોર્ટે કહ્યો નથી. The merits will have to be considered only to ascertain about existence of etc. He is reading something with great respect. A trial judge is reading something in the judgment which is not there. Then I take the honorable court to the other aspects, sir. Next judgment, sir. Wander, page number 14. Now, Wander, in fact, on page 18, only brings out a principle in para 9 that legal rights are yet to be asserted, yet to be ascertained, evidence is yet to be led. Sir, Wander will have no application for two reasons. Firstly, on facts. In our case, there is no dispute as to facts. The Honorable Court is aware, I have already indicated, every document is on the record and there is no dispute with the facts. It's only interpretation. And it is not even their case contract is concluded. Therefore, this reference to Wander is completely misplaced. The third judgment trial court relies upon is on page 24, Aloka Bose.
Paramatma Devi.
Yes, sir. Now, on page 28, in fact, the finding is in my favor. Page 28, para 17. Section 810 of the Act, that's a Contract Act, provides that all agreements are contracts if they are made by the free consent of parties competent to contract for a lawful consideration and lawful object and are not expressly declared to be void under the provision of the Contract Act. Proviso to Section 10 of the Act makes it clear that section will not apply to contracts which are required to be made in writing or in the presence of witness or any law relating to registration of documents. Kindly mark, I have already shown the Honorable Court, every SPA said it requires to be notarized. That is the requirement of German law. Our attention has not been drawn to any law applicable in Bihar at the relevant time, which requires an agreement of sale to be made in writing or in the presence of witness or to be registered. Therefore, even an oral agreement to sell is valid, if so, written agreement. Therefore, sir, this judgment really will have no application. In any case, there has to be an agreement first, which would require registration or in writing. The next judgment, page 31. So I am only reading the relevant part. Sir, please go to in this connection. This judgment, in fact, completely supports me. Page 35. 35, para 3.
We proceed to consider.
We proceed to consider the next question raised in this appeals, namely, whether the oral agreement was ineffective because the parties contemplated execution of a formal document or because the mode of payment of the purchase price was not actually agreed upon. It was submitted on behalf of the appellant that there was no contract because the sale was conditional upon a regular agreement being executed and no such agreement was executed. We do not accept this argument as correct. It is well established that a mere reference to a future formal contract will not prevent a binding bargain between the parties. The fact that the parties refer to the preparation of an agreement by which terms agreed upon are to be put in a more formal shape does not prevent the existence of a binding contract. There are, however, cases where reference to a future contract is made in such terms as to show parties did not intend to be bound until a formal contract is signed. The question depends upon the intention of the parties and the special circumstances of each particular case. As observed by Lord Chancellor in Ridgeway, fact of subsequent agreement being prepared may be evidence. Kindly marks this observation. Fact of a subsequent agreement being prepared may be evidence that the previous negotiations did not amount to a concluded contract. But mere fact persons wish to have a formal agreement drawn up does not establish the proposition that they cannot be bound by a previous agreement. In Vas so and so, it was stated by Justice Parker as follows. It appears to be well settled by the authorities if the documents or letters relied on as constituting a contract contemplate execution of a further contract between the parties, it's a question of construction whether the execution of further contract is a condition or term of the bargain, or whether it is a mere expression of a desire of the parties as to the manner in which transaction already agreed to will in fact go through. In the former case, there is no enforceable contract, either because the condition is unfulfilled or because law does not recognize a contract to enter into contract. In the latter case, the binding contract in reference to a more formal document may be ignored. So therefore, it all depends upon the nature of arrangement. In our case, sir, terms are not decided. Payment is price is not decided. Every material term is undecided. Even conditions precedent are not satisfied. Warranties and representations, my liability is not decided, his liability is not decided. All is being negotiated, and learned trial court relying on this judgment says correspondence is good enough. Please go to the next judgment on page 39. 1994 SSC 147 at page 57. Para 53. So para 23 ma somewhere in the middle, a mere reference, honorable got it, sir? So 137 શેર ની લીટી છે એના પછી.
Right.
A mere reference to a future formal contract does not prevent the existence of a binding agreement between the parties, unless reference to a future contract is made in such terms as to show parties did not intend to be bound until a formal contract is signed. Question depends upon the intention of the parties and the special circumstances of each particular case. Evidence did not show the drawing of the written agreement was a prerequisite to the coming into effect of the oral agreement, nor did the absence of specific agreement as to the mode of payment necessarily make payment ineffective, since the vital terms, now kindly mark, vital terms of the contract like the price and area of the land and time for completion of the sale were all fixed. Price in our case is not fixed, sir. If the Honorable Court recollects in his last mail says, I am prepared to breach the gap. So then please go to page 59, judgment of Rajasthan High Court.
Page?
Sir, it's on page 60. Sir, pagination. Page 6. 59, sir. Scanning ni logo માં આવી ગયું છે પેજ 58 પછીનું પાનું સાહેબ 59. જોધપુર બેન્ચ રાજસ્થાન હાઈકોર્ટ જજમેન્ટ.
Arif Khan, son of Salim Khan.
Yes, sir. Emma trial court relies upon paragraph 8. In the opinion of this court, in the above facts and circumstances, innocuous order of temporary injunction passed by the trial court, restraining defendant from alienating the property in question, cannot be said to be in any manner in excess of jurisdiction. It is settled proposition of law that in civil litigation involving property, sued property needs to be protected so as to ensure relief granted ultimately does not prove to be illusory. I pause here for a moment. Sir, આપે જોયું કે દાવા અરજીમાં તો ક્યાંય સ્પેસિફિક પરફોર્મન્સની વાત નથી, except for the prayer. Correspondence માં ક્યાંય વાત નથી. So the question of protecting the property, namely my shares held in Germany by German shareholders, is completely irrelevant. I go further. As held by the Honorable Apex Court, the very essence of the concept of temporary injunction and receivership during the pendency of civil litigation involving property is to prevent its threatened wastage, damage, and alienation by any property to the immeasurable prejudice to the other side or to render situation irreversible, not only to impact upon the ultimate decision, but also to render relief granted illusory. સાહેબ રિયલ એસ્ટેટ લેન્ડના ઝઘડાની વાત છે. કોઈ માણસ અંદર ઘૂસી જાય, ના ઘૂસી જાય, થર્ડ પાર્ટીને વેચી દેની વાત છે. How is this material for our purpose? So reliance on this judgment is also completely misplaced. Next judgment cited by learned judge on page 65.
Dev Prakash.
Dev Prakash. Sir, please go to page 68. Sir, Emma, the pending the suit, High Court said you sell away the property, put it to public auction. So destroy the property pending the litigation. So Honorable Supreme Court says para 12, in the preponderant factual backdrop as outlined above, we are of the view that not only the reasons endeavored to be cited in the impugned order in justification of the direction for public auction of the suit property like in persuasion, those are apparently speculative and illogical to say the least. Direction for disposal of suit property by public auction in the facts and circumstances of the case clearly militates against the fundamental concept of preservation of subject matter of any dispute pending adjudication in a court of law, more particularly related to civil litigation. So this is when a property subject matter of dispute, court cannot say, High Court cannot say, sell away the property and keep the proceeds. What has that to do with the fact of our case? So then comes judgment at page 70. On page 71, in fact, this judgment completely supports me. Para 9 and 10. While it is true that lower appellate court did not go into the question of prima facie case and held that appellate had not made out any such case, High Court did not go into any question at all. Be that as it may, Mr. Sacher is right in contending unless and until a case of irreparable loss or damage is made out by a party to the suit, court should not permit nature of the property being changed, which also includes alienation or transfer of property, which may lead to loss or damage being caused to the party who may ultimately succeed, may further lead to multiplicity of proceeding. Sir, I pause there for a moment. Subject matter of sale is shares of the German company held in Germany by the German shareholders. How is that going to be material in the matter of plaintiff's right? Plaintiff has no claim over defendant number 2 company. There is no negotiation for defendant number 2 company with him at all. Therefore, question of any such loss or damage being caused to the shares of German company is completely misconceived. The whole concept is frankly misread by the learned judge. The next judgment, page 73, is in fact completely in my favor. So please see page 73, relevant on page 82. Para 12. Because this is completely in my favor, I'll read it a little slowly. Submission of Mr. Nariman that an agreement, even if not signed by the parties, can be spelled out from correspondence exchange between the parties admits of no doubt. In fact, various judgments cited by him at the bar unmistakably support this assertion. The question, however, is, can any agreement be spelled out from the correspondence between the parties in the instant case? Now, so now comes the test. What is it that you see for the purpose of finding out? In this connection, cardinal principle to remember is that it is the duty of the court to construe correspondence with a view to arrive at a conclusion whether there was any meeting of mind between the parties which could create a binding contract between them, but the court is not empowered to create a contract for the parties by going outside the clear language used in the correspondence, except insofar as there are appropriate implications of law to be drawn. Unless, so please mark this sentence, unless from the correspondence it can unequivocally and clearly emerge that parties were ad idem to the terms, it cannot be said that an agreement had come into existence between them through correspondence. The court is required to review what the parties wrote, how they acted, and from the material to infer whether and how they acted, and from that material to infer whether the intention is expressed in the correspondence was to bring into existence a mutually binding contract. Intention of the parties is to be gathered only from the expressions used in the correspondence and the meaning it conveys. And in case it shows there had been meeting of mind between the parties and they'd actually reached an agreement upon all material terms, then and then alone, I emphasize the word, then and then alone can it be said that a binding contract was capable of being spelled out from the correspondence. Learned judge can correspondence is high because the Supreme Court says so. So Supreme Court, in fact, clearly says, one, you must find out from the correspondence as to whether or not there is a contract. You must go through the correspondence to reach that conclusion. By saying parties exchange email and correspondence, you can't jump to a conclusion there is a contract. As I was saying before recess, which is the mail that I gave which is accepted by them, or which is the mail that they gave which I accepted, that has to be found out. No such attempt is made. Only thing that is said is there is a lot of correspondence and email. Supreme Court is very clear, unless there is a meeting of mind, then and then alone it becomes a binding contract. Let me go to the next judgment cited by my learned friends, page 84, Govind Rubber. Relevant on page 89, again, completely in my favor. So paragraph 12, para 11. We have heard learned counsel appearing for the parties and have perused and considered all the facts and documents brought on the record. I pause for here. Even the Honorable Supreme Court at that stage perused every document. Did not say there is correspondence. There may not be any dispute with regard to the settled proposition of law that an agreement, even if not signed by the parties, can be spelled out from the correspondence exchanged between the parties. However, it is a duty of the court to construe correspondence with a view to arrive at the conclusion whether there was any meeting of mind between the parties which could create a binding contract between them. It is necessary for the court to find out from the correspondence as to whether parties were ad idem to the terms of contract. Supreme Court could not have been clearer, sir. And trial court very clearly says there is correspondence, email, contract. So this is a travesty of justice. Please see the last judgment, page 94. Relevant on page 101. Now, this is again misreading of the judgment. Let me indicate what the facts are and then I'll read. So, under the Arbitration Act, there has to be an agreement between the parties in order to invoke Section 11. Now, courts have taken a view as to whether or not there is a binding contract, etc. or not. Arbitrator will decide. Today, we need to see prima facie. So, this is in relation to Section 11 of the Arbitration Act. Please go to para 20. Westcare referred to several acts and transactions as also the conduct of Indovind to contend that an inference should be drawn that Indovind was a party to the agreement. An examination of transaction between the parties to decide whether there is a valid contract or whether a particular party owed any obligation towards another party or whether any person had committed a breach of contract will be possible in a suit or arbitration proceeding claiming damages or performance. But the issue in a proceeding under section 11, please mark this, issue in a proceeding under section 11 is not whether there was any contract between the parties or any breach thereof. A contract can be entered into even orally, contract can be spelled out from correspondence or conduct, but the arbitration agreement is different from a contract. Arbitration agreement can come into if existence only in so and so. What has this observation to do with our matter? These are the judgments cited by the court on its own or by the plaintiff. My respectful submission is some of them are completely in my favor, some of them are not really relevant. Let me now take the Honorable Court to the second compilation, which is judgments on which I rely.
Compilation A.
Compilation A. Sir, please recall my first contention is, sir, against, before each judgment, I have also given the mark, the purpose for which I am citing. Please recall my first contention is the shareholders of defendant number 1 are not parties. No relief is sought against them. In fact, we had moved application under Order 7, Rule 10, saying that unless shareholders are joined, there cannot be a suit. This judgment of the Honorable Supreme Court, sir, page 1, relevant at page 17. Honorable Supreme Court has quoted 4 judgments, so I am citing this so that all 4 judgments can come at one go. In Trojan, this court considered the issue as to whether relief not asked for by a party could be granted, and that too without having proper pleading. The court held as under, it is well settled that the decision of a case cannot be based on grounds outside the pleading of the parties, and it is a case pleaded that is to be found. Without an amendment of the plaint, court was not entitled to grant the relief not asked for, and no prayer was ever made to amend the plaint so as to incorporate in it an alternative case. Similar view has been reiterated by this court in Krishna, observing that a party cannot be granted a relief which is not claimed. Dealing with the same issue, this court in Bharat court, though the court has very wide discretion in granting relief, court, however, cannot, ignoring and keeping aside norms and principles governing grant of relief, grant a relief not even prayed for by the petitioner. In fertilizer, this court held that the High Court ought not to have granted relief to the respondents which they have not even prayed for. In view of the above, law on the issue can be summarized that the court cannot grant a relief which has not been specifically prayed for by the parties. Sir, how can therefore injunction against the shareholders of defendant number 1 be sustained even for a minute? They are neither parties nor a relief is asked against them. And trial court goes and grants relief even against them. This, by virtue of the 4 cited judgment, and this is the 5th judgment, is ex facie without jurisdiction. So now I go to the next proposition. Let me first indicate the proposition and then cite the judgment. Parties have agreed to jurisdiction of a German court. And once parties have agreed to the jurisdiction of German court, Indian courts would have no jurisdiction. Please mark the shares are being held by the German shareholders and defendant number 1 is also sitting in Germany. Now, sir, this clause the Honorable Court would find on page 50 of the list. You also got that?
Yes.
Page 50, sir. Please see last but one paragraph. This letter
Shall be
shall
governed
be-
by and construed in accordance with German law,
and
including its conflicts of laws, provisions,
and you hereby irrevocably submit to the exclusive jurisdiction of the courts of Frankfurt am Main, Germany.
Germany.
On this basis, we invited the offers. Please see his offer, which is on page 172. Based on this invitation to offer, he gave this offer on page 172. June 24. Many thanks for sharing Project Roadrunner with us. Please see enclosed our non-binding offer.
Page 70.
172.
172. Hmm. Okay.
So pursuant to my invitation of offer, he gave this offer. He has expressly therefore agreed for German court and German law. Sir, in his offer, he does not say that I do not agree to this clause and yet I give this offer. It nowhere says so. Please take it from me. He has not raised any objection. Now, if therefore parties have agreed to a particular jurisdiction, can a party thereafter go to a court of another jurisdiction? So please go to firstly the lead judgment of Honorable Supreme Court, page 26, ABC Leminat.
Page
26, sir. 26. Relevant on page 39, para 21. From the foregoing decisions, it can be reasonably deduced that where such an ouster clause occurs, it is pertinent to say whether there is an ouster of jurisdiction of other courts. When the clause is clear, unambiguous, and specific, except that notions of contract would bind parties unless absence of addendum can be shown, other courts should avoid exercising jurisdiction. As regard construction of ouster clause, when words like alone, only, exclusive, and the like have been used, there may be no difficulty. Even without such words in appropriate cases, maxim expressio unis as exclusio ulterius, expression of one is to the exclusion of another, may be applied. What is an appropriate case shall depend on the facts of the case. In such a case, mention of one thing may imply exclusion of another. When certain jurisdiction is specified in a contract, an intention to exclude all others from its operation may in such cases be inferred. It has therefore to be properly construed. Now, this is in relation to two courts within the country. Question might arise, but here we are dealing with Indian court versus a foreign court. Honorable Supreme Court has dealt with that issue in the next judgment. Please go to page 41. Paragraph 11 on page 54 first.
Page 54.
Page 54, para 11, sir, pehla. In regard to jurisdiction of courts under the CPC over a subject matter, one or more courts may have jurisdiction to deal with it, having regard to the location of immovable property, place of residence of work of a defendant, or place where cause of action is arisen. Where only one court has jurisdiction, it is said to have exclusive jurisdiction. Where more courts than one have jurisdiction over a subject matter, they may be called courts of available or natural jurisdiction. Growing global commercial activities give rise to the practice of the parties to a contract agreeing beforehand to approach a resolution of their disputes thereunder to either any of the available courts of natural jurisdiction, and thereby create an exclusive or non-exclusive jurisdiction in one of the available forum, or to have dispute resolved by a foreign court of their choice as a neutral forum according to law applicable to that court. It is well settled principle that by an agreement, the parties cannot confer jurisdiction where none exists on a court to which CPC applies. But this principle does not apply when the parties agree to submit to the jurisdiction of non-exclusive jurisdiction of a foreign court. Indeed, in such cases, English courts do permit invoking their jurisdiction. Thus, it is clear that parties to a contract may agree to have their dispute resolved by a foreign court termed as a neutral court or a court of choice, creating exclusive or non-exclusive jurisdiction in it. So then please go to page 67. Or I can go straight to page 68. Sir, पे 363 નંબરની જે લીટી છે પેજ 68 ઉપર. Honorable Court got, sir, 363?
Yes, and sufficient reason is
No, about 7 lines before that. But when the jurisdiction clause indicates
Yes,
the
yes.
intention of parties is to have disputes resolved in accordance with principles of English law by an English court, unless good and sufficient reasons are shown by the appellants, intention of the parties as evidenced by their contract must be given effect to. So at this stage, I yesterday said, and therefore let me jump there, because subject matter of dispute is transfer of shares of defendant number 1 company. So where are shares of defendant number 1 company situated? So defendant number 1 company is a German company registered in Germany. Now, sir, shares of defendant number 1 company are always lying in Germany in law. So please at this stage go to page 254. Judgment of Morgan Stanley. Relevant on page 278. Para 42. Para 42. As far as India is concerned, residence of the company is where registered office is located. Normally, cases should be filed only where registered office of the company is located. Courts outside the place when registered office is located, if approached, must have regard to the following: injunction, etc., etc., etc. Now, as a first principle also, suit must be filed in Germany. Parties here have expressly agreed to German jurisdiction. Let me envisage one argument and deal with in advance. Their case is, but defendant number 2 companies located within the territorial jurisdiction of the Honorable Court. No dispute. But defendant number 2 companies completely stranger to the deal. shares of defendant number 2 company are not being sold. The Honorable Court has seen share purchase agreement draft. Shareholders are to.
But they are subsidiary of defendant number 1, no? That
I agree, sir. But they are not subject matter of transaction independent of D1. Shares of D1 are being sold. The Honorable Court has seen share purchase agreement to German shareholders.
okay.
One buyer from buyer's side, one person on the buyer's side, third party, fourth party, guarantor of the buyer's side. Whereas the Honorable Court, would the Honorable Court again like to see that part, sir? Please go to that part again, only for that limited purpose. SPA. Sir, please go to that part only for that limited purpose. Share the second share purchase agreement, which the Honorable Court will get on page number 321.
Yes.
This agreement is between MHM Better something German of Germany, MHM Wormo something of Germany. Number 3 is the purchaser. Number 4 is the purchaser's guarantor. And what is subject matter of transfer? Subject matter of transfer is shares. What is shares? Please see first recital. MHM Holding, that is myself, is a German limited liability company duly organized under laws of the Federal Republic of Germany, having its register office at so and so, registered so and so, local code so and so, Munich so and so. Company's registered share capital is euro 12 million. All shares in the company are held by the sellers as set out in the list of shareholders, copy of which is included so and so. According to shareholders, seller number 1 shares and shares held by seller number 2, according to list of shareholders, seller number 2 shares. The company directly or indirectly holds majority of so and so. Now, what is subject matter of sale? Please go to the clause, page 330. Each seller hereby sells to the purchaser respective shares held by that seller as specified in first schedule. Each such share is a sold share. Share is my share. Share is not the share of the defendant company. How do I say so? Please go back to page 328. The term share is defined. Shares is as defined in recital A. The Honorable Court got third definition.
Yes, yes.
And recital A, the Honorable Court I have taken is on page 321, is my shares. So defendant number 2 has nothing to do with this transaction. And therefore, Indian court would have no jurisdiction. More so when parties have expressly agreed that only German court would have jurisdiction. Therefore, my second fundamental contention: 1, you cannot give injunction against a person who is not a party. Second, trial court would have no jurisdiction. I now go to the third proposition, sir. That is, offer must be unconditionally accepted so as to constitute a contract. Sir, page 71. So this judgment I cited yesterday. In fact, I started with this judgment yesterday.
Page, which one?
71. Padilla Timber. Sir, I have read this judgment yesterday. In fact, I started with this judgment. But because I had given loose and I did not want to give a loose judgment, I put it in this compilation. Relevant discussion on page 84, para 53 to 56. Probably the Honorable Court has already marked it yesterday. But because it may be a loose judgment may probably get lost. I have again captured here.
Page 84.
So page 84. देखिए यहाँ पे जोड़ू छे साहब. Acceptance must be unconditional, absolute. Parties must have ad idem. Sir, आपे वॉल्यूम ए જોવાનું છે, compilation A.
बढ़िया टिम्बर कंपनी है ना.
हाँ जी, para 53 to 56. I have read it, so I'm not going to read again, sir. If the Honorable Court would recall, yesterday I started with this judgment that unless there is a concluded contract, whole suit must fail. So next submission is one cannot jump to a conclusion on the basis of mails and correspondence that a contract is concluded. I have already shown this judgment from their compilation, this Rickmer's judgment. So please have a look at the index of volume A. I have said that it is already put in volume B or compilation B, so I am not again putting it. I am again not therefore citing it, sir. Do I go further, sir?
Yes,
I've already
sir.
taken the Honorable Court that unless there is a clear-cut finding of meeting of mind, you cannot assume merely because there is correspondence, there is a contract.
Yes, sir.
So then please go to the next submission. Silence, whether it amounts to consent or not. Then a trial court has propounded completely an unknown theory in law that a silence amounts to contract. So please go to page 182. AR 66, Supreme Court 543.
Yes.
So please go to page 183, paragraph 4. Or we can go straight to page 184, paragraph 6.
Yes.
The principal contention raised by the defendants raises a problem of some complexity which must be approached in the light of relevant principles of common law and statutory provisions contained in the Contract Act. Contract, unlike a tort, is not unilateral, and if there is no meeting of mind, no contract may result. There should therefore be an offer by one party, express or implied, and acceptance of that offer by the other in the same sense in which it was made by the other. But an agreement does not result from a mere state of mind. So મગજમાં આયને કારણે agreement ના થઈ જાય. Agreement does not result from a mere state of mind, intent to accept an offer, or even mental resolve to accept an offer does not give rise to a contract. There must be intent to accept and some other external manifestation. I'll read again. There must be intent to accept and some external manifestation of that intent by speech, writing, or other act, and acceptance must be communicated to the offerer unless he has waived such intimation. Of course, the negotiation implies an agreement to the contrary. So there has to be external manifestation. It should be clearly show, it should manifest. How? By speech, writing, or action. Learned trial court says, but silence may amount to an acceptance. That is something unknown to law. Please see the next judgment, on page 204. So this is Allahabad High Court judgment, where on page 215 in para 42, it first of all quotes Bhagwan Das judgment, to which I made a reference. And then para 48 is identical to our facts. That's why we have cited a High Court judgment. Page 216 bottom. In the present case, there is no averment regarding mode of communication adopted by the petitioner communicating its acceptance. There is not even a whisper as to how and in what manner communication of acceptance was made. In absence of any specific pleading so as to attract exception with regard to communication, we have no option but to hold acceptance will be completed only when it was communicated to the offerer, and communication obviously would be at a place where from that was made. That be so, agreement can be said to be concluded contract and executed when it is communicated to proposer, offerer at Noida, where from the offer was made. Sir, I took this honorable quote at the beginning of the day to the plaint to show there is not even a whisper as to how they have communicated acceptance, or how I have how I have communicated acceptance. If there is not even an averment of acceptance of offer, how can there be a binding contract? So then I skip 10th judgment, which is not really material. I go straight to judgment at item number 11, which is again very important. Specific relief injunction. Page 229. Trial court says specific relief injunction api devu જોઈએ. Please see what the Honorable Supreme Court says. Page 241. Para 18. This completely answers every argument raised by them. The specific performance of a contract is the actual execution of contract according to the stipulations and terms, and the courts direct the party in default to do the very thing which he contracted to do. The stipulation and terms of contract have therefore to be certain, and parties must have been consensus ad idem. Burden of showing the stipulation and terms of contract and that the minds were ad idem is of course on the plaintiff. If the stipulation and terms are uncertain and parties are not ad idem, there can be no specific performance, for there was no contract at all. Where there are negotiations, Supreme Court goes further, where there are negotiations, court has to determine at what point, if at all, parties have reached agreement. Negotiations thereafter would also be material if the agreement is rescinded. Therefore, negotiations, exchange of email and correspondence is not an answer to problem. Learned judge ought to have come out, ought to have found when, at what point parties were ad idem. On a lighter note, sir, my respectful submission would be, if the Honorable Court, if it deems appropriate, may ask only one question to the respondent number 1. Please identify the contract. Who made offer? Who accepted it? And can you translate it on a piece of paper? If my learned friend, Mr. Dave, can draft a document which contains accepted terms of both parties, I must go home. But if he cannot come up with a document with accepted terms of both sides, then he must go home. Sir, parties are still negotiating. There are, as I said, more than 500 suggestions in the share purchase agreement that I gave, and they have yet to give me share purchase agreement. Where is the question of a contract being executed at this stage? Please see the same effect in the next judgment, page 245. Relevant on page 247. Again, this is important, para 5.
Page number 247.
Yes, sir, para 5. It is settled law that remedy for specific performance is an equitable remedy, is in the discretion of the court, which discretion requires to be exercised according to the settled principles of law, not arbitrarily and adumbrated under Section 20 of the Specific Relief Act. Under Section 20, court is not bound to grant the relief just because there was a valid agreement of sale. Section 16C envisages plaintiff must plead and prove that he had performed or has always been ready and willing to perform the essential terms of the contract which are to be performed by him, other than those terms the performance of which has been prevented or waived by the defendant. Continuous readiness and willingness on the part of plaintiff is a condition precedent to the grant of relief of specific performance. This circumstance is material and relevant and is required to be considered by the court while granting or refusing to grant the relief. If the plaintiff fails to either aver or prove the same, he must fail. To adjudge whether the plaintiff is ready and willing to perform his part of the contract, court must take into consideration the conduct of the plaintiff prior and subsequent to the filing of the suit, along with other attending circumstances. The amount of consideration which he has to pay to the defendant must necessarily be proved to be available. Right from the day of the execution till the date of decree, he must prove he is ready and always been willing to perform his part of the contract. As stated, factum of the readiness and willingness to perform his part of the contract is to be adjudged with reference to conduct of the party and attending circumstances. Court may infer from the facts and circumstances whether the plaintiff was ready and was always ready and willing to perform his part of the contract. Sir, I must at this stage clarify one thing. There has been amendment to Section 16 of the Specific Relief Act. The obligation to make averment has now been obliterated. Obligation to make available funds on his own is now not there. Therefore, to that extent, this judgment may not have applicability. I am relying on this judgment for the principle that without any financial commitment, can you be permitted to block deal worth rupees 3,500 crore in relation to shares of German company held by a set of German shareholders when you have agreed that you will go to Germany? From that limited perspective, this judgment is material. So then please go to page 249, a judgment of Bombay High Court for the purpose of page 252. Interim reliefs are granted on the basis of case made out in the pleading. Therefore, unless case is made out in the pleading, there cannot be an interim relief. Finding that in the interest of justice, interim order is necessary in order to prevent abuse of process of law or to prevent wastage or to maintain situation as on the date from recurrence of certain incident which are existing as on the date of presenting such application. Court is also to take into consideration balance of convenience and whether petitioner would suffer any irreparable loss if no injunction is granted. Court would not be justified in granting injunction without examining the matter in detail by merely saying prima facie case was made. Apart from stating that other two requirements are fulfilled or not, before temporary injunction be granted, it is necessary to prove that irreparable injury is going to be caused which cannot be properly compensated in damages. I'll make my submission once I go through the next judgment also. Please go also at this stage, the next judgment of Morgan Stanley, page 254, at page 280. Unless there is the para 37. No injunction could be granted under Order 39, Rule 1(2) of the Court unless plaintiffs establish they had a prima facie case. Please also see, I will finish reading a couple of more judgments and then make my submission. Page 281, 281 Delhi High Court, relevant on page 285, para 11.
For the grant of temporary injunction.
Yes, sir. Plaintiff has to prove that besides prima facie case, balance of convenience also lies in his favor. And in case injunction is not granted, he will be suffering irreparable loss and injury. Balance of convenience means comparative mischief or inconvenience which is likely to issue from withholding injunction will be greater than that which is likely to arise from granting it. In applying this principle, court has to weigh amount of substantial mischief that is likely to be done to the applicant if the injunction is refused and compare it with that which is likely to be caused to the other side if injunction is granted. As I said, I'll come back and make submission once I finish judgments on this. Please see page 290, 288 Supreme Court judgment, relevant on page 290, para 5. The 29, it starts on page 288, relevant on page 290, 290.
Para 5.
Para 5. But એમાં પણ સાહેબ તમે next page ઉપર જશો સીધા વાંધો નથી. તો last line page para 5 ની last line. Or I'll read para 5 કારણ કે એમાં ત્રણે contention આવી જાય છે. Therefore, the burden is on the plaintiff by evidence illuminate by affidavit or otherwise that there is a prima facie case in his favor which needs adjudication at the trial. Existence of the prima facie right and infraction of the enjoyment of his property or right is a condition for the grant of temporary injunction. Prima facie case is not to be confused with prima facie title, which has to be established on the evidence of the trial. Only prima facie case is a substantial question raised bona fide, which needs investigation and decision on merits. Satisfaction that there is a prima facie case by itself is not sufficient to grant injunction. Court further has to satisfy that non-interference by the court would result in irreparable injury to the party seeking relief, and there is no other remedy available to the party except one to grant injunction, and he needs protection from the consequences of apprehended injury or dispossession. Irreparable injury, however, does not mean that must be no physical possibility of repairing the injury, but means only that injury must be a material one, namely one that cannot be adequately compensated by way of damages. Third condition also is that balance of convenience must be in favor of granting injunction. The court, while granting or refusing to grant injunction, should exercise sound judicial discretion to find amount of substantial mischief or injury which is likely to be caused to the parties if the injunction is refused, and compare it with that which is likely to be caused to the other side if the injunction is granted. If on weighing competing possibilities or probabilities of likelihood of injury, and if the court considers that pending the suit, subject matter should maintain in status quo, injunction would be issued. Thus, the court has to exercise sound judicial discretion in granting or refusing to relief of ad interim injunction pending the suit. Now let me go to one judgment which I left out in between so that I will then make my submission. Page 156. I'm only reading one small para on page 177, para 86. All the three elements, prima facie case, balance of convenience, and irreparable injury, para 86. So now my submission on this. I already made my submission on the prima facie case. There is no contract. There is no pleading to the effect of contract. No correspondence is shown as to contract. If there is no contract, question of damages will not arise. Answering that 9 million as probable loss to them, please see my very first offer, first letter where I said we will not be responsible for the losses that you will incur. Kindly go to that part, sir. If the honorable court goes to page, I think 50 or 50, page 50.
Yes.
Page 50, third paragraph. You acknowledge you will bear your own cost and expenses of your investigation and evaluation of the company, including the fees and disbursement of your own legal, financial, and other advisors, whether an indicative offer or any subsequent offer is accepted or rejected for any reason whatsoever. Neither the vendors nor PwC or any of the advisors shall have any obligation to you in this regard. Next paragraph. Nothing in this letter shall create any binding obligation, including, for example, obligation to enter into any agreement on the vendors or PwC in particular. Neither this letter nor the release of information memorandum or any other information shall constitute an offer to sell or an invitation to purchase or tender for the company or any of its businesses, shareholdings, or assets. By submitting an indicative offer, you confirm your full understanding of and agreement with the terms and conditions set out in this letter. With full knowledge, they have given a bid. They can't come back and say that, no, but then I have suffered and that's why you need to pay me something. Their 9 million offer, 9 million break fee, I have already demonstrated, has never been accepted by us. In fact, we have refused it, and the stage also has not a reason that 7 days has gone. Therefore, they have no case, much less prima facie case. Let me now go to the second aspect. Balance of convenience. Please consider the situation today. Today, there's an injunction. Suppose the Honorable Court is inclined to confirm it. What happens? My deal of rupees 3,600 crore gets stuck. Even if I take interest at 12%, interest per month will be rupees 36 crore. It will be more than 1 crore of rupees a day. And what is it that they will lose? Nothing. They have not put in a single rupee. What is the injury to them? They are not, I've seen, the Honorable Trial Court has seen, they are not seeking of specific performance. They are seeking 9 million euro. In their whole plaint, they are seeking 9 million euro. It's a different matter. In the prayer, they are asking for specific performance. But there's a complete mismatch between the pleading and the prayer. Suppose the Honorable Court is inclined at some stage to give them 9 million. What has that to do with the transaction of 363 million euro? Sir, for the purpose of their alleged claim of 9 million euro, which I have never accepted, can my transaction of 363 million can be blocked? It is like this. Somebody files a suit against me, let's say for rupees 10 lakh. which I am disputing, and says, so long as my 10 lakh is not paid, you don't sell property worth rupees 1 crore. This honorable court would never permit that. It's a matter of money claim. It will be appropriately adjudicated. Balance of convenience is not in their favor. Irreparable injury. What is irreparable injury? If deal is permitted to go through, they have nothing to lose, because in any case, they have accepted that deal is not going to go through. Their reaction was, give us 9 million. If deal is not permitted to go through, I will go bankrupt. I have serious financial problems. I need to comply with all requirements of banks by 31st of March. That's the reason why we are pressing for the matter. Therefore, both balance of convenience and irreparable injury are factors in my favor. Therefore, let me now conclude in only 2 minutes. Sir, the trial court order is fundamentally fallacious. A, it has granted relief against parties who are against persons who are not parties. B, it has applied, it has no jurisdiction at all. Only German court would have jurisdiction. C, there is no concluded contract. Mere acceptance, mere exchanges of correspondence is not a concluded contract. No attempt is made by the learned judge to hold which contract is intended to at which stage. 4, it has applied wrong law that silence is consent. 5, therefore there is no prima facie case. 6, there's a balance of convenience completely in my favor. There will be huge loss to me if relief is granted against me. As against that, they will suffer nothing. And finally, irreparable injury, I would be completely ruined. As against that, they have nothing to do. This, in our respectful submission, is nothing but arm twisting tech method to get 9 million euro to which they are not entitled to. With immense respect, this honorable court should see through the whole game and dismiss, allow the appeal and dismiss Exhibit 5 application. I am immensely obliged, sir. I have finished my argument. I can put in my written submission, sir, within 2-3 days if the honorable court permits or requires.
Okay. You come after all the way finishes. In
Okay.
case if you want to say anything, what he argues, then if you want to clarify, then you can come again on that day.
Okay, sure. Sir, I would be here, but then I will now go. May not be visible now, but I will still be here. If honorable court has any query, honorable court can require me, sir.
Okay, okay.
My Lord,
Yes, Mr. Soli Cooper.
yes, my Lord, sir, be kind enough to give me a few minutes.
Yes,
First of all, I adopt everything that Mr. Soparkar has argued. And
you are appearing for number?
I'm appearing for 2, respondent number 2.
Okay.
I adopt all Mr. Soparkar's arguments. I reiterate all of them, and I will endeavor not to repeat myself or to repeat anything that he has already argued. I just want to emphasize a few points a little and highlight a few issues regarding those points.
Yes.
First of all, the court has been pleased to see that German law is the applicable law to this contract.
Yes.
Mr. Soparkar has shown it already. I don't intend to show it again.
Okay.
I just want to draw your lordship's attention to the fact that in the process note, which we issued as far back as 3rd June 2024,
yes,
in the very first instance, we said that it shall be governed and construed in accordance with German law.
yes,
Now, just keep this in mind.
yes,
It is also an accepted position that under German law,
yes,
a transaction for sale of shares can only be done through a written, notarized document.
yes,
German law does not recognize the transfer of shares through an oral agreement. It does not recognize the transfer of shares even through a written agreement, only through a notarized agreement. So in the very first instance, assuming everything he says was correct, so long as German law applies, he is out of court. Nothing more is necessary. He's out. Under German law, he does not have a contract for sale of shares.
yes,
Now, significantly, I have gone through the impugned judgment of the trial court. There is not a whisper, not even one sentence, not even one word of why German law should be ignored. He doesn't mention it. The trial judge pretends that German law doesn't exist. He doesn't pretend that this clause doesn't exist. German law doesn't exist. And he doesn't talk about it at all. So my first point is that he, irrespective of anything else, contract, no contract, jurisdiction, no jurisdiction, he cannot grant any injunction unless you apply German law. And now it's very familiar. The courts have laid down repeatedly, and I'll be giving your lordship a list of judgments. So the courts have held that the contracting parties are perfectly entitled to say which law they want applied to their contract. They could have specified any law, and they have specified German law. And that, therefore, is the law under which you must judge everything in connection with this transaction. And if German law says that this is not a contract for sale of shares, then it is not a contract for sale of shares for any court considering this transaction. So first, he's out of court on this alone. Secondly, as Mr. Soparkar has pointed out, there is no jurisdiction.
And this is your first letter, this letter dated 3rd June 2024.
Yes, first process
Your
note itself.
your
Right
return
from
to
the beginning, we've told him.
plenty, yes.
Yes, your
Wherein
lordship
you
is
have clarified that these letters shall be governed and
That's right.
construed
The whole
in accordance
process-
with German law.
That's right. Your lordship is right. The whole process from June onwards, everything that flows is under German law. The whole transaction shall be under German law. It says shall governed and construed in accordance with German law.
And all correspondence started on the basis of this letter?
Absolutely. Your lordship is absolutely right. Every single thing that has happened has followed from this. This was the first starting point. I told everybody, look, let us start this process under German law. Everything we do under this will be under German law. It is under this letter that they issued their initial offer. It is under this that they issued their first final offer. It is under this that they issued their second final offer. It is under this that all correspondence took place. It is under this that the drafts were exchanged. This is the governing letter which governs the whole
starting point
process.
of this correspondence.
Yes, my lord is right. It is called a process note because the entire process is to be governed by German law. In fact, the shareholders agreement which is to be entered into ultimately is also under German law. It says so, that the shareholders agreement will be German law. And that is something I will just mention just now. The draft agreements that they were talking about, their draft, my draft, etc. All drafts talk about German law. Each draft, even their draft, says German law shall apply. Even their draft. So all drafts, everything is under German law. They have accepted that. Significantly, the learned judge ignores this completely. It doesn't exist. In fact, the transaction which has actually been concluded, the full, final, proper transaction which has today been concluded, has been concluded as per the requirements of German law through a notarized formal transaction. It has been done. Not only has it been concluded, the Competition Commission of India was approached to grant its permission. It has granted its permission in December 2024. So we have a concluded agreement. Competition Commission approval. And we are now stuck with this injunction which has come about, not under German law, but under some, I would say not even under Indian law, but some imaginary law. This, I submit, is fundamental. Once German law applies, you are out of court. Because under German law, you don't have a deal. You don't have an agreement. You do not have a transaction. Step one. Next, the second point is whether he has jurisdiction. Even if he wants to apply German law, can he apply it? Can this trial court apply German law or any law at all? Does he have jurisdiction? Now, the transaction, as Mr. Soparkar rightly pointed out, is a sale of shares of a company known as MMH Holding. MMH Holding is a German company. MM Holdings shareholders are German shareholders. So a German company has German shareholders. Those German shareholders are selling their shares in accordance with German law. They, in the process note itself, again, the same process note, which I pointed out earlier, and your lordship has correctly noted, dated 3rd June 2024, not only says it shall be German law which applies, it says that the exclusive jurisdiction is with the courts of Frankfurt in Germany. It's the court of exclusive jurisdiction. So supposing theoretically even more than one court had jurisdiction, that is the court the parties have chosen to be the exclusive jurisdiction. Your lordship knows that you cannot confer a jurisdiction upon a particular court. But if more than one court has jurisdiction, you can certainly choose and say, I want this court to have jurisdiction. Now, in our case, this is the only court which could have jurisdiction. But aside from that, the contracting parties have specifically agreed this court shall have jurisdiction. Once again, this is a clause which finds its place in every offer and every draft which has been exchanged. This is not disputed by anybody. Even if he was to say that he has an agreement, his agreement would have to be subject to the exclusive jurisdiction of the Frankfurt courts. Even if he had an agreement. Even if he had an agreement, it would be under German law. Even if he had an agreement, it would be under it would be in the courts of Frankfurt that he would have to enforce it. So when he says, I want an agreement, he can't pick and choose. He can't say, I want an agreement on this term that I offered, on that term that I didn't do. He can't. If he says that this was that he has a deal, then the deal is under German law and the deal is in the Frankfurt courts. He can't come here.
Even if he want to claim damages, he has to approach court at Frankfurt,
he
German.
has to go to the German courts. In fact, there's he would have to go to the German courts or German arbitration, whatever, but it would have to be in Germany. There is no cause of action in in India. What is the cause of action in India? Zero. There's a sale of a German shares by a German shareholder.
Yes.
Nobody else is concerned. There are only the sellers and the buyers. The sellers are the German shareholders. There's nobody else who's a seller. Nobody else is doing anything. Nobody else is buying anything. Nobody else is selling anything. Only the seller is selling shares. The buyer is not buying anything else. He's buying no property. He's buying nothing else. He's buying his shares. So there is one party selling shares, one party buying shares. The shares are therefore the subject matter of the whole transaction. They are the subject matter of the suit. And in that sense, if you want to talk of suit property, they are the suit property, the shares. Now, in fact, as I will show you, in the impugn judgment also, he says in paragraph 9, I'll just read one sentence in paragraph 9 of the impugned order. Looking to the plaint averment, the Dave's client, that defendant 1, that is the Soparkar's client, intended to dispose of 100% shares of the defendant company, number 1 company. Now he right that is what the plaintiffs claim. Transaction.
Yes.
The company is not disposing of a single share.
Yes.
As Mr. Soparkar rightly said, if Mr. Mukesh Ambani was to sell his shares, Reliance is not selling anything. Mr. Ambani is selling his shares. If Mr. Ambani agreed to sell his shares to me and then backs out, I can't sue Reliance. I have to sue Mr. Ambani. Now, if I file a suit against Reliance and don't make Mr. Ambani a party, I'll be thrown out of court. That is what he has done here. He has filed a suit against the MHM. He has not filed a suit against the persons who own the shares, who are going to sell the shares. He can't get an injunction against shareholders without making them parties. That is, I think, elementary law. And the court certainly can't pass injunctions against people who are not parties to the suit, which is equally elementary law. So the injunction is on the face of it bad, but his suit is misconceived because he's filing a suit saying his whole claim in the suit is that the company agreed to sell me shares. The company agreed to nothing. The company didn't engage PwC. The shareholders engaged PwC and said, please find a buyer. The company has nothing to do with it. It is the shareholders. Now, if this is the transaction, let's first test it. Where is the jurisdiction? The jurisdiction, he says the jurisdiction is in India because my client, defendant number 2, which is respondent 2 here, is an Indian company. Yes, it is. And the only reason I've been dragged in and thrown in as a defendant is to claim that there is somebody from India here. But it's irrelevant. A company can have many subsidiaries. What is a subsidiary? It's a company which is owned by the principal company. So MHM owns not several companies under it. It owns companies in more than a dozen different countries, one of which happens to be India. Now, the Indian company happens to have its office in Vapi, happens to have a property in Vapi. Does that give the Indian court any jurisdiction?
And plaintiff has no correspondence with the defendant number 2.
Of course not. Not a single, not a letter, nothing. Zero.
Nothing. Yes.
Zero. Not only, just look at the logic. You take a company like Indian Hotels. Indian Hotels has subsidiaries. It has properties all over the place. It has all over India, some in other parts of the world. Will all those courts have jurisdiction if somebody agrees to sell shares of Indian Hotels? I may own 100 shares of Indian Hotels. I agree to sell it. Does that mean that the buyer says that, oh, I'm buying a part of the property of Indian Hotels, and I will therefore sue wherever the property of Indian Hotels is, or where every subsidiary of Indian Hotels is, because I've got a part share in that? Of course not. He has to sue where the registered office is, as Mr. Soparkar said. That's the logical place to sue. But in this case, it's a contractual place also. The only jurisdiction he has claimed here is that, but number 2 happens to be an Indian subsidiary. Now look at how absurd this is. Are the shares of number 2 getting sold? The answer is no. If this transaction was to go through with either the plaintiff or with anybody else, will the ownership of defendant number 2 change? The answer is no. Defendant 2 belongs to MHM Holdings. Defendant 2 continues to belong to MHM Holdings. After the transaction, defendant 2 will continue to belong to MHM Holdings. There is no transfer of the shares of defendant 2. Nothing is going to happen to defendant 2 at all. Wherever defendant 2 is, and not only defendant 2, but all those subsidiaries all over the world, they will remain exactly as they are. No change in their shareholding. They continue to be subsidiary companies of the holding company.
Yes.
Will the property of defendant 2 be sold or bought in any way? The answer is no. The property of second defendant remains the property of second defendant before, during, and after the transaction. Therefore, nothing is happening to defendant 2. Nothing is happening to defendant 2's property. Nothing is happening with regard to defendant number 2 shares. What has defendant number 2 got to do with anything at all? They have just brought me in deliberately. So say that there is an Indian party because everybody else is a German party. To say, one of your subsidiaries, one of your 20 subsidiaries all over the world happens to be in India. So now Vapi court has jurisdiction. But this is not only misconceived, it is mala fide. Now please see what the learned judge in the impugned order says for jurisdiction. First look at what he says in his plaint for jurisdiction. If you see his plaint, the plaint is at page 503. And the court is kind enough to just have a look 1 minute at the jurisdiction clause. It's at page 528. 528 is the jurisdiction clause, paragraph 65.
Okay.
How does he come out with this jurisdiction of Vapi?
Yes.
65. The
Yes.
Honorable Court has territorial jurisdiction to entertain the present suit. Why? Because defendant number 2 has registered office at Vapi. So what? There may be other companies who also have a registered office at Vapi. So what? There may be 100 companies who have registered office at Vapi. So what? What have they got to do with this transaction of sale of shares of MHM Holding?
Yes.
The cause of action for filing the present suit has also accrued to the plaintiff. Now, this is something which I have never heard of in law. Within the ordinary territorial jurisdiction of this Honorable Court, as parties have conducted multiple plant visits and meetings. So he said, I came to meet you in Vapi. So the cause of action is now in Vapi. So I agreed to buy shares of a German company in Germany, but I made a visit to Vapi and I had a look there. So my coming to Vapi creates territorial jurisdiction in Vapi. So perhaps if he had met me maybe in Chennai, Chennai would have jurisdiction. If he met me in Calcutta, Calcutta would have jurisdiction. Now, what is this?
Yes.
This is a perversion of law. Because you went for a visit somewhere and saw something, so therefore what? How does that confer jurisdiction? Under which law, I don't know. Under which code, I don't know. It is certainly not under the Civil Procedure Code. That because you went to visit, a cause of action has arisen there. So there is just nothing which connects this transaction to the trial court's territorial jurisdiction. And on this basis, the court asserts that it has jurisdiction. The immovable property at Vapi is not the subject matter of this suit. It is not suit property. What is in Vapi happens to be an office of defendant number 2. Defendant number 2, as I pointed out, is not being bought and not being sold. It has been, will continue to be the subsidiary of MHM Holding. The shares of MHM Holding may change hands, but it continues to remain the same. If I tomorrow were to buy the shares of Indian hotels, the various hotels all over the world don't change hands. They will continue to belong to Indian hotels. It's only that instead of the Tatas or whoever owning the shares, I will own the shares. That's all. I will own which shares? Indian hotel shares. Now, Indian hotels also have subsidiaries. They have subsidiaries which, one which deal with some of their gateway hotels, the lower grade hotels, etc. All those subsidiaries will remain. They will all continue to belong to Indian hotels. The hotels which belong to the subsidiaries will continue to belong to the subsidiaries. All that will happen is that instead of Tatas being the shareholders, I become the shareholder. That is all. There is no other difference. So there is no jurisdiction vested where those subsidiaries are or where the hotels are. The jurisdiction is where the shares of Indian hotels, which is Bombay. That would be the place of jurisdiction. Now, in the contract, we have said that Frankfurt will be the place of jurisdiction, which is also the place where the shares are. So if the German, that is why we have said German law, German courts. So you have no territorial jurisdiction, and this territorial jurisdiction is not something you just can somehow or the other drag in by putting some Indian party as happens to be a party. And then say that now Vapi court has jurisdiction here. Why not the Istanbul court? The MHM has a subsidiary in Istanbul. Would that also become a court where he can go? He might as well say, I went there. He went for a visit there. He had a look at that plant out there. He said, therefore, now Istanbul court will have jurisdiction. Or some other, there are in a dozen countries, they have subsidiaries. They will all be, every one of them will have jurisdiction. It's an absurdity. With great respect, this is not only misconceived law, it is destructive of law. And with the greatest of respect, I would say that such an order is extremely dangerous. It is dangerous because it does damage to India's reputation as a place to do business. Commerce, international commerce will be afraid to come to India if this is the kind of order which is allowed to stand. Which is why we are so anxious for your lordship to reverse this order and to do so immediately. Every day this stands, it stands as a barrier against people wanting to do business here. They say, look, it is dangerous to come here. Is this some kind of the Wild West where I can do anything I want? Where people can grab injunctions in this kind of manner? It is destructive, my lord. It's a destructive order. And it can never be allowed to stand, should not be allowed to stand for a day. Next point. My learned friend has dealt exhaustively with the concept of the existence of a binding contract between the parties. And I don't intend to repeat everything
Yes, that I'm clear.
Yes, he has dealt exhaustively, I know. But there are just 2 or 3 things, small things which I would like to highlight.
Yes.
Every single offer which was made by the plaintiff, the initial offer, the first final offer, and the second final offer. Each of these offers was specifically stated by the plaintiff to be a non-binding offer. Aside from the process note which said everything is non-binding, each offer he made, he said it is not binding. Now just pause for a moment. If an offer is not binding on him, could it ever be binding on me? Can I say that I am offering to buy your pen, but I'm offering to buy your pen for 100 rupees, but the offer is not binding on me until XYZ happens. Now, if it is not binding on him till XYZ happens and XYZ doesn't happen, how does it become binding on the buyer? Or I'm sorry, on the seller? The seller says, but where is the binding offer? A contract requires binding offer and binding acceptance. You cannot conceive of a contract which has a non-binding offer and a binding acceptance. So a man can't say, I'm willing to sell you this. It's not binding on me. And I tell him, okay, I'm willing to buy it. He says, it's binding on you now that you have to buy it, but I may or may not sell it to you. It's not binding on me. Let us look at the reverse. Supposing I today had said, I'm accepting your offer and I sue him that yes, now specifically perform. He would turn around and say, but where did I ever make an offer to you which is binding on me? I made a non-binding offer. It's not binding on me. You can't compel me to buy your shares. So I have to be told that it doesn't bind him, but it binds me. I'm going to ask myself a simple question. When did any of these non-binding offers ever get converted into a binding offer? He says in writing to me, in each of the offers, look at the last non-binding order, because that is the last order offer that he makes, which he believes has become a contract. That second final offer he makes, which is a non-binding offer, he says it will not be binding unless we have a written agreement between us, signed written agreement. Now, we never had a signed written agreement that at least both parties are agreed on, that the learned judge also accepts. So how did that non-binding offer become a binding offer? He says it is not binding till you have a signed agreement. There is no signed agreement. How did it become binding? And if it never became binding, then how did you come to a contract? Now, just 2 or 3 dates I may just remind my lord about.
Oh.
He makes this second offer on the second non-binding offer to us on 9th of October, correct? 9th September, I'm sorry, 9th September, he makes this non-binding offer. Now, after that, admittedly, that offer has been subject to various negotiations which are going on. And for that, I'll only point out 2 or 3 things. On 17th October, that is more than a month after the so-called non-binding offer, on 17th October, he writes, the plaintiff writes an email, not me, which is at page 409. And your lordship, just kindly have a look at that email. That is his email, not my email. He says that in that email, that he admits first,
Yes.
he says that paragraph 2, we are confident that both the parties can achieve signing and commit all resources for so and so, as discussed in yesterday's meeting. Following are the key principles to achieve signing. Now look. Now look at item number 1. Enterprise offer, which provides is not subject. This now he is telling us various things about his offer. 2, transaction certainty. And now in transaction certainty, please look at number 4. Because he says that you gave me signing exclusivity. What he does not tell you is that he did not want signing exclusivity. He wanted negotiation exclusivity. Now, what is the difference between the two? In negotiation exclusivity, it means you only talk to me. You only negotiate with me. Don't negotiate with anyone else. We told him nothing doing. Mr. Soparkar has read those documents which say nothing doing. I am going to negotiate with other people. Yes. What I'm willing to do is that I will allow you signing exclusivity, meaning that I will keep negotiating with someone else. But if you finish signing on this date, then I will, till that time, I won't sign up with someone else. So if you finish signing by this date, if we are able to arrive at terms, then I'll give you a first shot if you finish everything by that date. If that date passes, too bad, no signing exclusivity. Now, as Mr. Soparkar also rightly pointed out to your lordship, even that much limited signing exclusivity which we offered him, he never accepted. Now he himself says that he recognizes this. Look at on page 409, look at item 4 under the heading transaction certainty. We asked for exclusivity after NBO phase and were told the reason it could not be given was due to legal limitations. So they were told we are not giving you negotiation exclusivity. So on the date they're writing this, they are fully conscious they never had negotiation exclusivity. Then look at timelines and way forward. Number 5, our truncated list of critical outstanding questions for which we require answers is attached. And then he says, please note that complete answers to these questions along with requested expert sessions will enable us to favorably reduce the requirement of holdback escrow as per your ask. So he said, I want to keep certain amount in escrow. Some amount I'll pay you, some amount I'll keep in escrow. We said we don't agree. We don't want escrow. We want lesser escrow. We want more amount paid up. So he said, let's discuss it. You give me all these answers, and if all those answers work, then maybe I'll change that. Now, let's just stop here. The single most critical issue in any transaction is the consideration. How much? And if we are talking about what monies are going to come to me and what money is to be held in escrow and other critical terms, there is no deal at that time. You can't have a deal where we have not yet decided how much you're going to pay me and how much you're going to hold in escrow. Tomorrow, if supposing tomorrow you were to grant specific performance and the plaintiff gets it, what will you write in the specific performance? How much is he going to pay me? How much is going to be held in escrow? Where is that? What is going to be written in that agreement? Specific performance of what? Now, this is 17th of October. Now, this is 17th October. On 22nd October at page 411, we write to him saying we need some more time to consider all this. On 29th October, and now this is crucial, on 29th October, which is at page 415, your lordship may just have a look at that.
Yes.
He now says, I have again changed the markup. Your lordship saw, Mr. Soparkar pointed out, they first sent a marked up copy of the SPA. We wrote back a marked up copy showing our markup, showing various changes on both sides. So they wanted something, we wanted something else. We never had an agreed draft. Now on 29th October, they make a new markup. And they write there. If you turn to page 417, the second last paragraph, kindly note, I'm sorry, 415. Kindly note that our SPA markup is ready. Please let us know if you would like us to share with your legal advisors so that they can review in parallel. So he has now created a new markup which he has not even given me. And he's telling me, I have prepared a new markup. If you want to show it to your lawyers, I will now send it to you. Is this a final deal? On 29th October, a man is making fresh markup, which he is now offering to send me, and he has still not sent me. At least 29th October, there was no deal, no oral agreement, no understanding. When do we write to him next, telling him that, sorry, no deal? We write on 4th November 2024 saying, sorry, we are exploring other options. Your option is not attractive enough. Now, he can't possibly think that on 4th November we have a deal with him when I'm telling him, sorry, I want to explore with someone else because your deal doesn't sound good. And this is not to be found at page 416. So on 416, I'm telling him categorically, sorry, I do not want to go with you. I want to go with someone else. Please see what I say on 416. Many thanks for your continued interest, all fruitful discussion and efforts. Today, we had some internal alignments. Conclusion is that other potential transactions are currently preferable for the stakeholders. We will pursue these other options and try to finalize a deal within the coming weeks. So I'm telling him I'm now going with the other options and I'm finalizing a deal on those other options in the next few weeks. He can't possibly imagine that I'm agreeing to anything that he says. So on 29th October, he himself says that now there are changes. So we have on 29th October, we have a non-binding offer and we have a new markup which he has still not shared with me. On 4th November, I tell him there is no deal. Now, when did this oral agreement, this oral understanding, the oral meeting of minds, oral item, when did it come about? between 29th and 4th. But no, that's not enough. It couldn't even have come about between 29th and 4th, because the very next page, on page 417, please see what he says. Now, please see, this is very, very important, because this document gives the lie to his entire theory of an oral agreement. It's a complete lie, and it is demonstrated by his own email. This is page 417. It's his own email on 4th November after we tell him I'm going with someone else. He writes, "We are surprised with the bill of mail. We have been in continuous touch with you over the 2 weeks with regard." Now, just please look at this. Why has he been in touch with me? In regard to finding ways to bridge the gap in our last offer and the expected valuation. Pause here. He says, look, there is a gap between my last offer, his last offer being 369 million euros, and our expected valuation. So he says there's a gap between what I'm offering you and what you want. Now, if there is a gap between what he wants to give me and what I want, can it ever be said that we are at idem on anything? Can it ever be said that we have a concluded contract between us? So on 4th November, he is telling me, this is not my email, this is his email. He is himself saying there is a gap, and I am trying to find ways to bridge the gap. But now on 4th November, I've told him, sorry, I don't want to deal with you. So he says, look, please. I want to deal with you. If you feel that I'm not giving you enough consideration, I'm willing to go more. How does that create a concluded contract to say, I'm willing to give more? If there is no agreement, there's no agreement. To say that now I'm willing to give more, so now there's an agreement. That is not an agreement. Yeah. Now, what is even worse, that look at what the learned judge says in the impugned order. With the greatest of respect, the learned judge has deliberately misread this mail. This mail is from them telling me, I am sorry, we are trying to find ways to bridge a gap. There's a gap between what you want and what I'm willing to give. Let's find a way to bridge the gap if it's possible. This is after I've told him I don't want you. He doesn't turn around and say, but we have a deal. What do you mean you don't want me? He says, look, okay, you don't want me, but there's a gap. We'll try and bridge the gap. So don't go with someone, come back to me. And look at what the learned judge says in the impugned order, page 25, and this is important. I'm sorry. Just, your lordship doesn't mind. Please just see page 25.
Yes.
Yeah, the paragraph just above the last two lines. Plaintiff again sent mail. My lord has got that?
Yes. On
Plaintiff again sent mail
2000.
on 4th November, which is the one I just read you, in which he states that interaction with all bidders has been stalled due to this, will resume this week. We are expecting feedback towards how we can quickly sign the deal. Instead, we are surprised to hear that you have decided to focus on the transaction with other bidders. Very nice. What the learned judge does is reproduce the last part of that email, but he forgets the first part. The first part which says, what is he himself says, the plaintiff himself says, there's a gap. We've been trying for the last 2 weeks, we've been trying to bridge the gap. So at least the last 2 weeks, there's been no ad hoc. We've been trying to bridge it. So he just completely ignores it. So he quotes the email. He quotes one sentence on the email, but ignores the most crucial part of the email. This email is completely destructive of his case. So he takes the email, pulls out one sentence and says, we are surprised. What are you surprised about? And then, of course, we write to him on 8th November, no, sorry, we're not interested. We'll focus with other people. If things don't work out with someone else, we may get back to you. And then, of course, on 13th November, we even tell him, none of which I had to do. Nobody had to tell him anything. But PwC tells him out of transparency, look, we are doing someone else. Then they tell him on 13th, we have actually done it with someone else. Now, on this, the learned judge comes to a conclusion. There's a concluded contract. And a concluded contract on what basis? On the basis of an imaginary oral agreement. Now, there are 2-3 things when you say oral agreement. One, when was that oral agreement entered into? When? You have to give a date. You can't say, I have an oral agreement. I won't tell you when. Was it entered into when he made the non-binding agreement? Was it entered into when he sent a draft which was not accepted? Was it entered into when he sent a second draft, which he made a second draft, but he never sent to us? Was it entered into when he said that there is a gap in valuation? When did that second agreement come about? If no second agreement could have come about till at least 4th November, when he himself admits there is a gap in valuation, then if it could not come about after that date, because after that date, it's all over. So when was that oral agreement? Nobody has given an answer. Nothing in the plaint, nothing in the IA, nothing in the judgment. There is no date of such imaginary oral agreement. After that, secondly, you must tell me what are the terms of the agreement. So the learned judge imagines that the terms must be the second non-binding agreement. Now, how does he come to that? That second non-binding agreement was 9th September. On 4th November, he's saying there is a gap in our valuation. And there's a very significant reason why he's saying that, which of course, everybody seems to have pretended that doesn't exist. The plaintiff pretends it doesn't exist at all. In fact, the plaintiff tells the exact opposite in his plaint. In his first initial offer, and your lordship will mark this, was 360 million euros. No dispute. His first final offer was 378 million euros. That is 18 million euros more. Now, what does he do in his second final offer? He brings it down. From 378, he brings it down to 369. But he does not only brings it down, he then tells an outright lie. He says, actually, I didn't bring it. He never says I brought it down. He pretends that the 378 offer is just to be ignored. Let's pretend it's not there. And he says instead that 360 was my offer. Because I'm putting in a break fee of 9 million, I'm increasing my offer by 9 million and making it 369. Now, this is an outright lie. Because he's not increasing his offer from 360 to 369. He's reducing his offer from 378 to 369, which is what caused us a lot of problems. And let me explain this also to my lord. When he made his offer of 378, before he made the 369 offer, he made the 378. He said, give me exclusivity. So I said, okay, listen, if you want even the signing exclusivity, forget negotiation, I'm not giving you. But even for the signing exclusivity, it will be on the condition you do not reduce your offer. Specifically, that's what I've said. Mr. Soparkar read the email also.
So this is what it has caused the problem.
So one of the problems, there may be other reasons also. There are several problems. So one of the problems was we told him, don't reduce.
Yes.
He reduced it. Now, it is possible a man may say, look, I said that. I don't want to stand by that. I want a lower offer. Because nothing was binding. He was entitled to reduce it. He could have said, I'll go below 360 also. He could have. That's his prerogative. But it's equally my prerogative to say no. He could, nobody says he was bound to 360 or 378 or 360. He's not bound to any of them. He says, I'm not binding. I accept that. So he is not binding. He's entitled to reduce it wherever he wants. But equally, I am entitled not to accept it.
Yes.
Now, I've asked myself only this. When did the non-binding offer get accepted? According to him, it got accepted by oral acceptance. Which? It's not enough to say it got accepted. You have to specify on which date did it get accepted. Secondly, if you say it got accepted by conduct, which is again completely false, then on which date, which conduct accepted it? He has to say, okay, by this email is your conduct which accepts it. But he himself admits as late as 29th October. 29th October is his email saying, I have a new markup. How could therefore on that date? So as of that date, obviously nobody had accepted. Because if there was already an accepted deal, there was no question of making any markups. It was all done. It was a done deal. Everything was over. But more importantly, if it was a done deal, forget about 29th October. Assume it's a done deal. On 4th November, when I tell him I'm looking at other people, I'm sorry about yours. I prefer my clients prefer to go with somebody else. What is his answer? This is the crucial thing. What did he say on 4th November? He said that, look, if there is a gap between us, I know what I'm offering you is not what you are expecting. Let us find a way to bridge that gap. Is that the answer of someone who believes that he has a concluded contract? Or is it the answer of someone who says, look, don't go somewhere. Please come back. Let's make a deal. There is no contract. If there was a contract, he'd say, what are you talking about? What gap? There's no question of gap. We have agreed on a price. If we have agreed to 369, we have agreed to his escrow amount, we've agreed to his upfront amount. Where is the question? There's no gap. It's all done. It's agreed. Where's the question of finding a way to bridge the gap? There is no gap. It's all done. Why does he say, please, let's meet, let's see, let's find a way forward? Nothing. That email, the 4th November email written by him, which is to be found at page 417, is by itself enough to destroy his entire bogus case that there is a concluded contract entered into. Because there is, in the entire plaint and the entire IA and in the impugned judgment, there is not a whisper of when, the point of time at which this concluded contract took place. Because if that concluded contract took place before the 4th of November, then the 4th of November email would be completely different. Therefore, 4th of November shows that at least on 4th November, there was no concluded contract. If 4th November, there was no concluded contract, then when could it happen? It could never happen, therefore. And this is his email, not mine. I am not telling him nothing. I have only told him, I have made it clear I am going with someone else. So first of all, this whole concept of silence being amounting to speech and silence amounting to consent is a bogus. It's a bogey created only to try and divert the issue. What consent? I am writing to him categorically. And forget what I say. Look at what he says. Does he say that there has been consent? Does he say that there was silence was consent? Not in the plaint. Did he say it to when I told him I'm going with other people? What is his answer? No, please don't come back to me. I know that there is a gap between us. I'll try and bridge that gap. That is his answer. And clear admission that on that day there was no deal. Now, please see just 2 or 3 judgments I want to show you on this silence amounting consent. First of all, as I said, in this case, there was no silence. There was categorical speech. There were categorical emails. There was categorical conduct. Everything was against him. But let us on the principle of that the learned judge has imagined. There is no law which says that silence amounts to consent unless, and the only exception is when there is a duty, a legal duty to speak, to say something, then silence can amount to speech. Because the law says if you will have to answer this. So if you don't answer it, it is deemed to be admitted. Then there is silence can amount to speech. Till that time, in all normal circumstances, silence does not amount to consent. And your lordship, just 3 or 4 judgments, very short. I'll just read one paragraph. If my lord is kind enough to look at
page number.
I think the advocate is telling me.
That's judgment.
Mr. Dhruv Mistry is there. Can I just request him to tender
Yes.
the judgments? They're just 2 or 3, and I'll just read the only one sentence from each.
Yes.
I want to.
Which one you are referring, Mr. Cooper?
The first judgment, if my lord is kind enough to see, my lord.
Yes.
The first judgment, if your lordship will see, I'll finish in the next 10 minutes, my lord.
Yes,
If your lordship sees, the first judgment is a 1941 judgment of the Rangoon High Court Division Bench.
SM
AIR
versus
1941.
Yokohama Specie Bank.
Yes, that's right. Yokohama Space Bank,
Yes.
Specie Bank. If my lord is kind enough to turn to paragraph 5 of that judgment. It's just a short 4-page judgment. I just want to show only one paragraph.
Yes.
Paragraph 5. He has here contended up to a certain point that he was entitled at all times to the goods by reason of the fact, as he says, that there was an understanding between him and the bank at Rangoon that there would be settlement after instructions were received from Osaka. Learned counsel has been unable to show on his behalf when a firm contract was entered into. Again, as I argued, must show when. But he has tried to rely upon the visit of the plaintiff to the bank on 22nd September and upon some subsequent correspondence in which no reference is made to a firm contract having been entered into. Exactly like in our case. No correspondence which talks of a firm contract. Indeed, from the terms of one letter seen, the offer was made first time, no acceptance had been forthcoming. And this next sentence is what is crucial. We are invited to say that although there is no answer to this letter, because in that case, the plaintiff wrote a letter saying, these are the terms and you will do it. There is indeed no answer to the letter. There was an implied acceptance by the bank. It is enough to remark. The division bench dismisses that out of hand, saying it is enough to remark plaintiff has not shown that any assistant had any authority to enter, much less he had done so. Learned judge has found as a fact no acceptance by the bank. Silence to a letter is not acceptance of the terms proposed in it. This is the key. Silence to a letter is no acceptance of the terms proposed by the bank. Mr. Feldhaus, and this is again, you just see the example, offered by letter to buy his nephew's horse for so much, adding, if I hear no more about him, I shall consider the horse is mine. Now, that is not also not what he says. He doesn't say, look, I'm writing this. If you don't, if I said, look, this is I'm buying your horse for so much. If you don't answer, I will take it that you have accepted my offer. It was held, and it is now very elementary proposition of law that Feldhaus was wrong in considering the horse was his. That's so much.
Yes.
I'm sorry, my lord. Am I clear?
Yes. Mr. Cooper, just a 5 minutes. Just I'm taking break. Some administrative work is there. Just a 5 minutes. I'm finishing it and coming back. Just 5 minutes. સુપારકર ભાઈ 5 મિનિટમાં આવું છું
સાહેબ કોઈ વાંધો નથી, કોઈ ઉતાવળ નથી. અમે અહીંયા જ છીએ.
મેં ફાઇલિંગ બધું આવ્યું છે ને તો હું સાઇન કરી દઉં. ઓલ એડવોકેટ્સ આર વેઇટિંગ આઉટસાઇડ.
સાહેબ કઈ વાંધો નહીં, 5 મિનિટ પછી.
ઓકે, જસ્ટ અ મિનિટ. બોલાવેલો સહીમાં
તમારું એ જે બોલેલો બરાબર પક્ષકારોને બોલેલો તમારી ખુરશી ને જે આપવાનું આપજો મને ખુરશી ને તો સર જમા થઈ હા કયા નંબરની આવે કયા નંબરની મંજૂર થાય હે તો અમારો તો ચોપન ઉઠાયેલા છે હવે સર છે નથી એ નયન અમારા પૂછી આપી મળે કે 52 ની જગ્યાએ 54 નંબર આપી દે 52 24 8 કે कुछ बोल अभी मुद्दत विश्व नंबर एक है बेम
Yes, Mr. Cooper.
Please, my lord.
Sorry, huh? Tamne wait. You have
Nah,
to
nah,
wait for
Sahib,
that.
I'm much obliged. I put it on. So you've been extremely kind to give me all this time. You're sitting way over time just to hear us. So that first judgment I showed was that Yokohama, where the Rangoon High Court says that silence does not amount to speech. You can't just assume that because someone doesn't reply, there is automatically consent. Now, there is the Bombay judgment of Justice Desai, which is one of the most well-known judgments on this issue and lays down the law completely. It's called Bank of India versus Rustam Fakirji Kawasji.
Yes, yes.
54 judgment, 1954 judgment.
Yes.
Now, does my lord have the judgment?
Yes, yes, yes.
If you're kind enough to look at paragraph 98, I'll just read 3 paragraphs, 98, 99, and 100.
Yes.
So they sum up the law. My lord has got 99?
Yes, yes.
I am unable to accept the contention. I'm sorry, 98, I'm sorry.
Now there is nothing.
Now there's nothing to show in the evidence. Now what happened in that case was a letter was sent by the airline to the bank saying we are hypothecating this. No reply was received. So they said, well, obviously, therefore you accepted my hypothecation. So he said, now there is nothing to show in the evidence laid before me that there was any acceptance of the proposal contained in the airline company's letter, assuming that the letter contained any proposal. Now, in that case, it was a binding offer which they made, no kind of non-binding. All that is relied upon is the connection, is that the bank remained silent and did not send any communication denying the existence of any hypothecation. This is exactly what the learned judge said. He says, you never denied, you never positively told them, I don't accept your offer. The bank did not owe any duty to the company to send any reply to that letter. So they could have thrown it in the dustbin. Moreover, a person who makes an offer cannot prescribe the conditions under which it may be refused. He can't say that if you don't accept it, if you don't reply, it is deemed accepted. I can refuse it just by throwing it away. 99. I am unable to accept the contention that when the airline company stated in the letter so-and-so that its assets were hypothecated with the bank against cash credit account so-and-so and went on to state that it trusted that the statement would be found in order and obligation was cast on the bank to reply to the letter. Mere silence cannot amount to any assent. This is directly contrary to what the learned judge has said. It does not even amount to any representation on which any plea of estoppel may be founded. Then 100, this is the law. It is well established that mere silence cannot amount to a representation unless there is a duty to make some statement or to do some act. It is only when there is a duty to disclose some fact or to do some act that deliberate silence may become significant and amount to a representation. Cases where it is said that sometimes performance may be given for a promise and the result may be an agreement stand on a totally different footing. This is not one of those cases where only some act is required to be done by the person to whom the offer is made, and the doing of such act is by itself sufficient to amount to communication of the acceptance. So this is not a case where the law says you have to do this act that will amount to acceptance, and you do the act. And the person making the offer becomes bound by such tacit acceptance because the law says if you don't reply, you're bound to. If you don't, it is deemed. This is not one of those cases. So the law otherwise is silence does not amount to consent. This judgment has been consistently followed. And I'll just draw your attention to one case where it has been followed. Is a Delhi case.
No, Mr. Cooper, 1 second. This is pre-bifurcation, therefore it's equivalent to the pre-bifurcation judgment, so it's a Gujarat High Court judgment. 54.
Oh, I see. Thank you. I'm much obliged. Thank you, sir. I am obliged to Mr. Soparkar. He's right that it was a case of the United Bombay State before bifurcation. I'm much obliged. And this judgment has been followed also by the Delhi High Court in 1985 judgment of Urmila and Company Private Limited versus J.M. Bakshi, where if you see, my lord is kind enough to look at paragraph 13. It's just same thing. It says the aforesaid letters have no legal effect. Paragraph 13. It was not obligatory on the part of defendant to have responded to those letters or to have contradicted the arriving at of the terms and conditions as mentioned in the letter dated 20th February in Bank of India versus Rustam Fakirji Kavasji held no contract could be concluded. It was necessary that so contract could be concluded necessary. There should be an offer and acceptance, and the mere silence of one party to offer did not amount to assent of the other party remaining silent. Therefore, mere silence could not amount to consent. Then the last judgment, I want to just show one a judgment more, and that is the judgment of the again of the Delhi High Court 2013 judgment, Kashyap versus Bata India. Again, my lord, this judgment cites both the Bank of India judgment, Rustam Fakirji's of Bombay. It cites Urmila and Company of the Delhi High Court also. So, and it also cites the Yokohama judgment, which is the first judgment I showed to your lordship.
Yeah.
And paragraph 33, as far back as in Bholat versus Yokohama, first judgment, it was held that silence to a letter is not acceptance of the terms proposed in it. Similarly, Bombay High Court in Bank of India versus Kavasji, AR so held that mere silence cannot amount to representation unless duty to make such statement or to do some act, etc. View of the Bombay High Court was followed by this court, by Delhi High Court in Urmila Company, etc. And they already followed. So I don't want to keep on multiplying this, but therefore this is the consistent view of all the courts. And it's my respectful submission is it's a judgment. This is the principle which must commend itself to your lordship also. So therefore, yes. Now, if you just, the last point, which of course Mr. Soparkar has already made and eloquently addressed, and I don't want to repeat it, but I'll just remind it, that in this case, the offer that he made, the second final offer, which he made on 9th September, which is to be found on page 304, at page 308, Mr. Soparkar already said this today, so I'm just reiterating, on page 308 says, this offer is valid for 7 days from the date hereof. We request you to send a countersigned copy on or before so-and-so. Now, just look at the consequences. It's a non-binding offer. He says, if you want to accept it, the way to accept it is to sign it within 7 days, after which it ceases to be an offer, even non-binding. He says it is only valid. So even my non-binding offer is only valid 7 days. Otherwise, if you don't sign it, I can do what I like, which of course he can. And of course he has. So therefore, just because I don't categorically tell him, look, I don't accept your offer, I don't have to tell him that. The very fact, in fact, as Mr. Soparkar pointed out, in letter after letter, we write to him saying, this is not, we are going to consider, we have to discuss this, we change the draft agreements up and down. All this is being done. And it says that there has to be, even his own offer, it starts by saying it is non-binding and then goes on to say that it is subject to confirmatory due diligence. So unless the due diligence is done by them, they say we will not even confirm our own offer. So they will confirm it. You must accept it. Now, all this, where is the binding agreement on which you're going to grant an injunction and hold up my 3,000 crore odd transaction in this manner? With the greatest of respect, I say, and I know this is strong language, but this is nothing short of a blackmail action. It is extortion. The whole idea is, I will harass you, I'll hold up your transaction. I know that you have to conclude this transaction by 31st March, but I'm going to create problems for you and hold you up so that you will pay me out. That's all they want. It is blackmail. And my lord, with the greatest respect, no court should encourage a plaintiff to behave in this manner. They should, on the contrary, it should be deprecated and the court should come down very heavily on such a plaintiff. The last point, I'll just point out is, and this is again, Mr. Soparkar has argued this, the break fee, according to him, is, he says, I put in a break fee and you have accepted it, so you must pay me break fee. But the argument is so contradictory on every level. If the break fee is part of a contract, if it is, if there was a concluded contract, assuming there was a concluded contract, this is completely independent of everything else that has been argued, then the mention of a break fee in such a concluded contract, if there was no concluded contract, there is no break fee. That is what he himself says. He says there is a concluded contract. and you are now breaking my concluded contract by not executing the agreement. Therefore, pay me a break fee. If there's a concluded contract with a break fee, what does it mean? It means that that concluded contract contemplates that it can be broken. And the break fee clause that he has put in, if you look at it, it's on page 307. If you look at it just for one moment, sir.
Yes, yes.
Break
Upon
fee
acceptance of this offer, sellers agree to pay Jindal the
upon acceptance, sellers agree to pay pay Jindal the following in case of no binding agreements in relation between Jindal and sellers on or before 31st October, 1 million or 9 million. Now, when according to him this happens? Upon acceptance of this offer. So when was this offer accepted? I come back to that question. There is no answer. Answer is orally it was accepted. Impliedly it was accepted. But when? On the next day, 10 days later, 1 month later, 2 months later, when? On 4th November, he's saying there's a gap between us. So if there's a gap, obviously this was not accepted. And if this was not accepted, then when did it get accepted? So the break fee only springs into existence if there is a concluded contract. That's what he says. Now, if there is a concluded contract and there is a break fee, then the break fee will be payable under that concluded contract, which means that the concluded contract is saying that yes, even though there's a concluded contract, you can break it, but if you break it, you will have to pay me this money. In other words, it prescribes the conditions under which the contract, it prescribes the consequences of the breach of contract. So it says you can breach it, but the consequence will be that I will come and ask you for money if you breach the contract. And so first he will have to establish there's a concluded contract. Then he will have to say you have breached the contract. And then he will have to say, therefore, now pay me this damages. But where does he get specific performance? Because if he asks for specific performance, he is saying, don't give me the break fee, perform the contract. Now, where does he have the right to do that? He himself says there's a break fee. So he says you can break the contract and I will ask for a fee. But fine, that you ask for the fee. That's your suit. The suit will decide whether there is a concluded contract or not. If there is a concluded contract, the fee will be paid. If there is no concluded contract, the fee will not be paid. How are you entitled to specific performance? On his own statement that there is a break fee, he is not entitled to specific performance. Nor is he entitled to say, as he now tries to say, that look, you first pay me the break fee, only then you can go ahead. That also he can't say. A man can't say that you first pay me damages for breach of contract, only then I'll allow you to breach it. Because if you don't allow me to breach it, there's no breach. The breach takes place. The consequence of the breach is the payment of the break fee. That's a consequence. And a consequence comes about after the breach. So I go ahead with someone else. That is a breach. That consequence leads to him a break fee. But for that, he has to first establish all this. Now, he can't say that my trial will take place after a few years. I will at that time try and establish there's a contract. And at that time, I will get my break fee. Till then, you don't do anything. You can't enter into any agreement. His case is now a money case. This is going beyond that. His case is a money case. He says, you owe me a break fee. Well, good luck to him. If he can prove that there is a concluded contract, he'll get a break fee. And there's no concluded contract, he'll be thrown out of court, as he well should be. The greatest of respect, there is not a single ground on which he can claim specific performance. The law is against German law. Jurisdiction is against him, no jurisdiction. Contract, no concluded contract. Admittedly, by him, there is no concluded contract till after we have told him we don't want to go with you. Even then he's saying there is a gap between us. After we tell him that. There is no. And on this pleading, on a pleading which says there is an oral agreement. When? I don't know. What are the terms? I don't know. This is on this injunction is granted. No, this is a complete abuse of the process. The court must be put down by your lordship very, very strongly. Just one. So now only finally, I've concluded my arguments on this. The only thing I want to say is, therefore, first of all, the only persons who should have been parties to this entire case were the sellers and the buyer. So the plaintiff should have had only parties he should have had were the sellers, whom he doesn't make parties. Neither number one, that is the appellant today, Mr. Soparkar's client, or number two, my client, or numbers 3 or 4 are the sellers. None of them are the sellers. So all the defendants to the suit are not the people with whom he's dealing. He is dealing with PwC, who is on behalf of the sellers. PwC is not on anybody else's behalf. On behalf of the sellers, he is dealing with PwC. The sellers are not parties. What kind of a suit is this? Nobody is a party. None of the parties are parties are the sellers.
And
So
there
it's-
is one query, sir.
Yes, sir.
You have invited lot of bidders, no? There.
Yes, yes. And I
Because-
negotiated with
Yes,
all
sir.
of them and I chose one ultimately.
Yes.
સર મેં કહ્યું ને સીતા સ્વયંવર જેવું હતું.
Can you put on record some other parties to whom you have sent an
Sir,
invitation for this?
sir, we could do it, but the only problem would be
list
that we have
or-
breach of confidentiality because
Sir,
we
then
have,
no.
with each person we have a confidentiality agreement. So the idea is
Sir, one second, sir. I must show, sir. Please have a look at the first document, sir. Why is it a problem? Please look at the very first document on the file.
there's a
Page number-
confidentiality clause.
हाँ,
Yes, yes, then-
ये आपने बता भी दो, sir. Just kindly go to very first document, sir,
Yes.
by which he has given his indicative offer. Please go to first page, first line.
Page number?
I'll just give the page. I think, 1 second, sir. His indicative offer. No, sir, please go to page, no. Offer મંગાવી લે, 50 કે જે છે. Sir, page 45. એની પહેલી લીટી જુઓ, sir.
No, just actually what they have written this letter, no, the first letter.
No, sir, page
Sorry.
45 ની પહેલી લાઈન જુઓ ને.
Thank you
for your
interest in project
and
owner.
returning signed confidentiality agreement.
Agreement, okay, right.
દરેક
Every
જોડે
single-
દરેક
Okay,
જોડે
okay.
confidential agreement છે, સાહેબ. એટલા માટે.
Okay. No, no problem.
That was the
Every-
reason, sir. I just wanted to show this.
No, no,
Thank you,
issue.
thank you, Mr. Soparkar. In fact, every single bidder signs a confidentiality agreement with PwC. So
Yes,
it would be wrong on anybody's part to disclose because it would mean that
Yes, sir.
that the sellers tell everybody, all the possible prospective buyers, you are all to be maintain confidentiality, and then it goes around breaching that confidentiality, which is unfair.
Okay.
So it would not be proper for us to anybody to reveal that. But the fact is there are other bidders, they know. That is an admitted position. Nobody disputes that there were other bidders because the very fact that they asked us and we told them there was no negotiation exclusivity. So therefore they know
Except
that
this
there are
year,
other
there is no other suit anywhere in India. Only
Nobody.
this one.
No, sir. Therefore, in my respect, so one, you've not made the only parties who are concerned to be parties. You made all 4 wrong parties. Who are 3 and 4? What have they got to do with this transaction? Number 1 is a company whose shares are being sold, which I explained. You don't make the company selling its shares. Number 2, me, I'm only a subsidiary and I continue to be a subsidiary. I will always, irrespective of the transaction. So my shares are not being sold. My property is sold, it belongs to me, it will continue to belong to me. Oh, what are 3 and 4? 3 and 4 are not sellers. 3 and 4 have no property in India. 3 and 4 have nothing to do with this transaction. 3 and 4 are not going to sign anything. So why have you brought 3 and 4? So the whole idea is just bring anybody here. And as I said, it's a blackmail action. Harass all of us to ensure that before 31st March, because I may just tell my lord, what is the urgency? This company has certain financial dues to various German banks. If this money is not paid by 31st, the company technically will become insolvent. If that happens, there will be huge consequences which will follow later. That is why it is essential we have to conclude before 31st. And it is not enough just to conclude before 31st, because the buyer with whom we have already signed, he has to now raise over $300 million and pay, euros, and pay the banks, pay us. It's not something he can do over. He's not writing a check and giving it. Now, therefore, that process will also take a time period of maybe 10, 12 days. That is why we are under such tremendous pressure to have this matter resolved immediately. And the whole transaction fails, the company will be in incredibly difficult circumstances. And which for the plaintiff, he couldn't care less. What does he care? He has, as Mr. Soparkar says, he hasn't put one paisa in this transaction, except hiring his own lawyers and hiring his own advisors is fine. But he has no money in the transaction. Well, great respect. This is not a matter in which he is entitled to grab an injunction like this and hold on to it. It's not as if, oh, nothing is going to happen for a while, so it's all right. We'll see about it. This is a very harmful
argument is
injunction.
on 3 points.
Yes, sir.
There is German law is applicable to this case.
Yes, sir.
There is a no concluded contract.
Yes, sir.
And silence is not an acceptance.
Yes, sir. No jurisdiction.
The more fundamental, sir.
No
Injunction
jurisdiction.
against third parties.
German jurisdiction.
And finally,
third parties.
Finally, there is no, the parties who are concerned are not parties.
Yes, shareholders are not
No,
parties.
they are not parties.
And you're passing injunction against them without them being shareholders. How does he do that? I mean, it is incomprehensible. Any court applying any law can pass orders against people who are not parties after they've been told that they are not parties. It's not as if they don't know. We've not only told them, and application is taken out to the court saying that you can't go on with this because they have not made the fundamental parties to the suit. He knows that. So that application is dismissed by the judge, saying that I don't care. It doesn't matter if they are not parties. And you pass an injunction like this, knowing that they are not parties, accepting they are not parties, saying I'm not going to bother about them, and then pass this injunction against them. Well, this is great respect, completely untenable.
You have also filed 0711 application there before Rabi court?
Yes, sir. We had filed 711. My friend had filed 110. Both are rejected. 3 and 4 are also 110. That was also rejected, but their writ petition were lied to the Honorable High Court. I don't want to have two parallel litigations. Therefore, as of today, I have not disputed it. Once this issue gets resolved, I'll take up that.
Okay.
Oh, finally, I don't want to say anything more. I think I've taken up more than enough time of your lordship. May I just be permitted to just give you a short written submission, which I have prepared? I'll just hand that over. If my counsel in president.
I was about to ask for that.
Yes, I've just summarized everything. Yes.
So that I don't have to refer everything.
No, my lord.
I can go on.
Yes, so can I just hand that over to your lordship?
Yes.
Just a brief note which contains everything that I've said. It summarizes it.
Yes, written submission in support of the appeal by respondent number 2.
My lord.
Sir, my submissions can come, as I said, by even tomorrow or post rejoinder, whatever. If the Honorable Court would like to see in advance, I don't mind even giving tomorrow.
No problem. You can give it or after arguments of the other, you can submit. No problem.
Okay, then I'll do
same
it
day you
after.
can give it.
Yes, sir.
Please, I'm very much obliged to your lordship for very, very patient hearing.
Immensely obliged, sir.
Okay.
So now the only one last request, sir. Please don't.
No one is coming for number 3 and 4, no? Or
3 and 4 are really unnecessary. It's just, but they are there. Anyway, I pointed out the only thing to be pointed out as far as they are concerned is that they are not. They should not be there at all.
Yes, sir. They are all formal parties.
Yes. They're not even formal. What parties are they?
Sir,
the only thing is that now your lordship may fix an urgent. As I said, there's great urgency. Please fix the matter as soon as possible if your lordship is.
Sir, every day costs us more than 1 crore of rupees. I have already shown by the simple arithmetics. 3,600 crore, 360 crore a month. A year, which means 1 crore of rupees a day.
No, but he has taken time on 13th. He has taken. I don't mind if he's coming on Monday, but I think it was not feasible for Mr. Dave. So
perhaps he can appear virtually because virtually means that effectively the whole week goes, which means that effectively I can't get an order till the week after that, which doesn't leave us enough time to close the deal. So, your lordship,
Mr. Dave is available on 13th only, and also I wanted to make a request. Can we start at 3:30 on 13th?
No.
This whole idea is not just to
the 14th is holiday, 15th is holiday, 16th is holiday.
No, 15th hour court is working.
Correct, but sir, then it will not be over. Why can they not start early? Mr. Dave can find time on Monday.
It was the dates were fixed as per convenience.
They can come online.
No, at Exhibit 5 stage, we were told to argue on a day-to-day basis because other side wanted injunction. Now that they've got injunction, they are going very, very lightly because it doesn't really matter to them. Their
No,
whole
the schedule was fixed as
delay.
per everyone's convenience.
I agree,
No,
madam, but it has
And convenience
council has
can't
to
be at
make
the cost of
himself convey it.
not this kind of cost.
Please deposit 1 crore of rupees on a daily basis. No issue. We can have it on 13th. I'm only saying 1 crore a day. That's a cost that I'm suffering, which I have pointed out.
No, but what is the wrong? Mr.
This is not a
Subhakar,
matter where
that 13th was taken with the consent of Mr. Umesh Shukla. He himself
Right,
said that he
okay.
don't have any objection
That-
if matter is
when I
kept on
was in the
13th.
hospital.
Yes,
Yes,
yes.
Your Lordship.
Yes, on that day. That is
So
why.
if your lordship
And
is
I also requested them to keep it early. So they said
No,
no.
Lord, if your lordship is keeping it on 13th, then at least there should be a clear undertaking that 13th the matter finishes.
Yes, sir. Let them start by 1 o'clock, 12:30.
Let them start
whenever the
anytime they
honorable
can
court
start,
settles
but
the
finish
matter.
on
Lordships,
13th.
we can't confine
after-
ourselves at
No,
this
this
stage.
is-
We'll
this
only
is
know
not
once the
fair. This is
arguments
not
begin.
fair.
After
This is
12:30 or 1 o'clock, you can continue at any
Yes,
time.
yes.
No, no.
Yes, you
And
can
Soparkar,
start
you
at
just
one
get
and
in
finish
touch
the
with Mr. Dave there in the High Court.
I will indicate to him
No,
that
no.
we would request him or the honorable court expects you to start around 12:30.
Yes,
Then
yes.
it's entirely between him and the honorable court. I will pass on
He has requested for 3:30.
No, it
No,
can't
madam,
be. Then it can't be that
he
he
can't.
We have already
select the
spoken
time.
to him
Yes,
and has
yes,
taken
yes.
his convenience, but he is available from 3:30
It
onwards.
can't be. He can select a date, but he can select a time also. It becomes too much, my lord. He must conclude on
I
that
am
date.
just requesting on his behalf, my lord. It's my lord's
No
decision.
problem. You ask him if he get time earlier, he can join earlier.
We'll do
No
that.
problem.
We'll do that.
And after 3:30, we'll continue like this only. And we'll see that on that day, his argument is over.
Okay, then it's
On 13th. Even after 5 o'clock, I don't have any objection looking to the urgency of this matter.
I'm immensely obliged.
No, no.
He
If all
we'll
parties
try to
agree,
finish it.
Yes,
if
yes,
all the
sir.
party agrees, I don't have any objection.
Up to 8 p.m. we'll wait, sir. I'm saying, sir, we want the matter to be
No,
finished at any
I
cost.
don't have any objection because
Yes, sir.
I'm here only.
Okay.
So, but subject to is agreement of all the parties.
Yes, sir.
Otherwise, someone may
No, sir, but we
court is
need
taking up the hearing and all.
Sir, we need his consent provided he starts at 3:30. If he starts at 11:30, 12, it will be over by end of the day,
No problem.
including with my rejoinder. Obliged.
No, okay.
Thank you, sir.
Obliged.
Okay. સાઈન માટે બોલાવો બધાને સહીઓનું છે ને બધું લોક અદાલતનું છે આ લાઈવ બંધ કરી અદાલતમાં છે ને સારું સારું આપી દો આવ્યા છે બધા litigants તમે કોના તરફથી છો આ ભાઈ તમે ધોલ દળે તરફથી ધોલભાઈ બહારગામ ગયા છે તમે પાછળ છે તમે કોના તરફથી છો જિંદાલ તરફથી કોણ આવ્યું ઇન્સ્યોરન્સ કંપની બધાની સહી છે ને ચેક કરીને જવા દો અમને
ઇન્સ્યોરન્સ કંપનીની છે એડવોકેટની પણ છે બંને પક્ષકારની પણ છે
અને ગાંધીભાઈને બોલાવો
છે ને નીચે અરજદાર નંબર 1 અને નીચે અરજદાર નંબર 2
આ છે ને આમાં સાઈન ડેટ વખત બાકી છે આમાં
હા એમાં શું તારીખ ને એવું બાકી છે
આ બધું
ચાર જજમેન્ટ પાછા માંગે છે લિસ્ટ ઓફ ડોક્યુમેન્ટ લઈને આપે છે
હા તો એ આપણને બહુ સારું એમાં અને ફોર રેસ્પોન્ડન્ટ નંબર 2 લખીને આપજો આમાં કોણ છે તમે આપો છો ને સોલિક ઉપર તરફથી છો ને તમે હવે બસ આપી દો હવે આ તો હું તો હવે attend થશે.
લિસ્ટ ઓફ જજમેન્ટમાં
હું મેસેજ છે ને ગાંધી મેસેજ કરી દઉં છું સાહેબમાં